I'm Tanya Iser. I'm an investigative reporter here at Channel 8. I'm joined by Katie Sherrod and Mike Howard. Katie's going to be our political commentator for the day, and Mike is going to be our legal analyst, walking us through and trying to explain what is happening in this impeachment trial for Ken Paxton from a legal perspective. Just to give a quick recap, yesterday we heard continued testimony from Jeff Mateer, who was Ken Paxton's former first assistant attorney general. That would have been the second highest ranking person in that office under Ken Paxton. Mateer testifying for hours on the stand about his about the affair and how Ken Paxton had acknowledged this affair to both senior staff and to senior in the campaign and at the office. And then, of course, later on we heard from Ryan Bangert. Ryan Bangert was involved in many of these issues that arose in that office, the open records situation, the foreclosure situation, and also the MIDI Foundation. So a lot of interesting stuff coming out yesterday. So I want to toss it to you guys to kind of get your initial perspectives as we enter day three.
I think it's going to be very interesting to see how the defense cross-examines Bangert. I think he was a very effective witness for the House managers, and a basic rule in trial is if the other side is scoring points and getting good facts in, you're going to aggressively cross-examine that. So I would expect an aggressive cross-examination, which should be interesting.
Oh, I totally agree. I think they've got to go. I mean, he's like the perfect witness. He's squeaky clean. He is Mr. Clean. And to call him a rhino is just laughable. And they will do that. I mean, what is the saying that if you can't pound the facts, pound the law. If you can't pound the law, pound the facts. And if you can't pound either, pound the desk.
Right.
And I think that's what Busby has essentially been doing, spraying out a fog of misinformation, and the fact that Patrick has allowed him to testify. Every time he makes an objection, every time he asks a question, he leads in with a whole speech with all the buzzwords he wants to embed in the brains of all those senators on the jury.
It's very interesting to me because, from a as a criminal defense lawyer, I look at what a defense lawyer is doing, and Busby is doing a very good job of speaking to his intended audience.
Right.
Regardless of what your politics are, it seems like the defense is losing on the facts of the issues. But he is trying to speak to a bunch of far right conservative senators. These are, whether you want to call them MAGAs or whatever. These folks have a certain set of beliefs, and the conspiratorial, bringing up George P. Bush, and some of these kind of rabbit trails that he seems to be going down, which I think it's easy for us to look at and say, what does that have to do with anything? And that's a bunch of nonsense. Well, that's the purpose of that. He's trying to give foothold to his intended audience, which is the jury of this case, the senators, and he's not obviously speaking to the Democrats on the
He only
Senate.
needs to speak to five of the senators, actually.
Well, we've got
in addition to the solid six that are already there.
Right. Well, because you would, in order to convict, you need 9 Republicans to join in, because it does appear that the Democrats are going to hold strong. But I think really what came through just crystal clear yesterday is the limitations of having someone who is not a lawyer, not a trial judge, preside over the situation. Because, and Mike, you can speak to this more eloquently because I'm not a lawyer and I kind of act like I know stuff. The whole issue of hearsay and executive privilege, it's very clear Patrick doesn't understand these issues.
Right. Yeah, it's easy for somebody, a lot of legislators have a legal background. A lot of them went to law school, a lot of them practiced. But there's a difference between somebody who has a academic understanding of the rules of evidence, an academic understanding of hearsay, and being a seasoned trial lawyer, being a seasoned judge. Having a judge who actually understands the law and understands how to control lawyers. Lawyers are big personalities. They are adept.
Really?
Yeah, I know.
Particularly
I know,
these.
I know. And these are legal legends. I mean,
Right.
especially on the House manager side, Rusty Hardin and Dick DeGuerin are legends, and Busby is no slouch. These are people that are very used to commanding a courtroom. They're very used to having control of a narrative, having control of the situation. And if a judge lets them run roughshod, things go haywire very quickly.
Which he's allowed with Busby.
Which is exactly what's happening.
And that is going to favor Busby
Yep.
all the time because
Yep.
he will observe no guardrails. If he
That's right.
sees them being lowered, he's going to be all over the map.
That's right.
And he knows how to do that because you have to know the rules really, really well to be able to break them effectively. And he does. And Patrick can't control them. At least he hasn't demonstrated his ability
I know
to
some
control
judges
them.
that could. I know some judges
Oh,
that could do this.
absolutely. That would
I mean,
shut him
well,
down in a nanosecond.
The judge who's advising him, Lana Myers, would be very effective at that. I mean, that's the issue. I have practiced in front of extremely seasoned judges who know how to control their courtroom, and I've practiced in front of newer judges who are just learning the ropes and they haven't yet gained that skill. And the trials proceed very differently. And as you said, that really benefits the defense because whether it's a criminal case or an impeachment, they have a lot of similarities. There are obviously some differences. But the big thing for the prosecution is you want a clean narrative. The facts need to be really easy to understand. Juries are infamously fickle. They're not always listening. So you want to make your narrative super easy to follow.
And
Right.
Busby's job is to disrupt that
That's right.
as much as possible,
Yep.
to interrupt the narrative,
Mm-hmm.
Make it
to go down
confusing.
rabbit trails,
That's
so people have lost the thread of
That's
the
right.
narrative. And I don't know if Rusty Hardin has just given up on objecting or because of the response, where Patrick seems to say, gentlemen, let's just move on.
Because he's not. And
He's not ruling on
Right,
them.
and that is extremely unusual.
It's extremely
If you had a lawyer who lodges an objection in a traditional courtroom, the judge is going to issue a ruling. And if the person keeps doing the conduct that's a problem, they can be held in contempt. I mean, in this testifying stuff, that,
Like you said, the judge she's good. She's knowledgeable.
Judge Myers, I practice in front of Judge Myers. She's
and
very
we've
knowledgeable.
seen Patrick leaning over and them talking. Is he not listening to her? Because I can't believe she's not giving him good advice.
I would have to think she's giving him good advice and she's telling him, but you can only you can lead a horse to water.
Right.
You can only tell him so much, and he's going to lean over. And
Which is one of the things
when he
Mateer
wants.
said. We tried to save him, but he wouldn't let us.
well, and we haven't really discussed just some of what we heard yesterday. I mean, Bangert. I think what made Bangert so effective is, Mateer really couldn't speak to a lot of the specifics because he's the second in command of that office. So, and to some extent, he was not aware until really late in the game all that was going on.
Right.
And he made that very clear, I thought, yesterday.
Oh,
That
okay. So
did-
Patrick's coming up.
okay.
Oh, sorry. Hold on. They just spoke in my ear. So let me pull up on mine. So. Oh, wow, they are going to kick off on time, it looks like.
Shocking for a trial. I'm very used to trials not starting on time.
Okay, our mics are on. So sorry, guys. So we'll keep an eye and here we'll watch and see and we'll make sure we don't speak over Dan Patrick once they get going.
Morning,
but,
everyone.
Bangert
Bales, please
was
bring in the jury.
particularly effective because he could speak to some of these specifics. Okay, here we go. Let's take a listen.
And Judge, at this time, I do have a matter I'd like to bring up at the bench, if that's okay.
After the prayer,
Yes,
please,
Judge.
and after the jury comes in. Good morning, members of the jury. Senator Hinojosa, I understand you're going to do the prayer this morning. Please come forward.
Good morning. Please, let's bow our heads. Lord, we come before you today, acknowledging that our understanding is imperfect and limited. We ask for your guidance and direction in every aspect of our lives. As we walk down unfamiliar paths, we ask for your guidance. Open our eyes, sharpen our senses, so that we may use good judgment in every situation and decision we encounter. Help us to be patient. Help us to avoid making rash decisions and impulsive actions that may lead us astray. We understand that our choices have the power to shape our future. For that reason, we ask for your wisdom and guidance. Help us make wise decisions as we trust in you. In Jesus' name we pray. Amen.
Thank you, Senator. Please be seated. Counselor, you wanted to approach the bench?
Okay, so Mike and Katie, while we're watching this live stream, Jay, can you bring up beside us so where we can kind of, there it is, okay. We don't really know what's going on. Mike, you're a legal guy, what do you think's happening right now?
So the lawyers will have some sort of issue that they want to discuss outside the presence of the jury. This could be timing of witnesses, this could be legal objections. There's been some wrangling back and forth about, the defense was objecting to privilege and then they're withdrawing privilege objections. It could be any
kind of
that.
head spinning stuff.
Right, that's right. So it could be almost anything, but the idea of this, the sidebar, is to discuss issues outside the presence of the jury. The idea being that the jury needs to only concern itself with the facts that are being presented from the witness stand, and all of the wrangling about objections and all of that should not be considered.
And it's funny because it's such a quasi-jury thing because, you would never have, like on day one, Katie, a jury that is voting on motions.
Right. I mean, from the
So
beginning,
strange.
this was strange and wonderful and Texan. I mean, it just was. And Patrick so solemnly, swearing all of them in. I felt like I was sworn in by the end of the day. I heard that oath so many times. I also thought it was interesting how some of them clearly practiced the oath so they could have their own little swing to it, Politicians are politicians. And that's one of the things I think we all have to keep in mind is that this is implicitly a political proceeding. It was designed, that's what impeachment is. Mm-hmm. It is implicitly political. So when people say they're politicizing this, well, yeah, because that's what an impeachment trial is. It is totally, completely political. And Patrick, I think, has been caught in that join between a trial and his presiding over the Senate. And he can't quite fit into the presiding over a trial mindset for him. It's not natural to him. He's not an attorney. And I hope that his advisor, who's sitting next to him, grabs him from time to time and goes, you've got to rule on this motion. You've got to do this. Or Busby will run out of control in that because it's to his advantage to do so.
And frankly, I think it's also worth considering that Patrick, it may be partly that he's unpracticed as a judge and he's outside of his swim lane, but it also may be, judges sometimes don't rule on motions intentionally. The adage in trial law is if the judge doesn't rule, then it's not preserved for appeal.
Right.
And so judges can be adept at, if they know they're on a hot button, they just don't rule.
Well, I don't really think that's what's going on with Patrick.
Yeah, because
True.
there's no appeal.
No, true. But I do think sometimes Patrick is probably weighing his political role.
Right.
If he's too judgy, that may get in the way of his political role. And so I think it's probably a little A, a little B. I think it's probably his lack of experience as a judge, and I think it's probably he's doing what he wants to do because, frankly, he has a political role to maintain.
And he will do what he wants to do. It's his chamber. Mm-hmm. And similar to the AG claiming that he's the AG so that he can do anything he wants.
King's X, right?
I think Patrick has a similar mindset. This is my chamber. Yeah. I'll run this the way I want to.
Well, and as much as Ken Paxton and his attorneys have tried to frame this as the rhinos and the deep state and whatever else coming after him, these whistleblowers, you cannot emphasize enough, these are the right wing of the right wing.
Yeah.
Right.
Mateer works for, I think it's Liberty Legal Institute. A very far right group. These are very conservative people. Of course, Ryan Bangert works for, is it Defending Alliance Freedom or something? One of those kind of groups. Another very conservative group. These are, I don't know if Bangert's a member of the Federalist Society, but Mateer was. These are very conservative people. Evangelical Christians. They are, but what they're testifying to is that, they came to work for Ken Paxton because they believed in the things he was doing, but they could not stomach the things that they saw.
Right.
But for me, Bangert's testimony about the open record situation, and as someone who has filed thousands and thousands and thousands
Right.
of open records in my career. The idea that the AG's office would take a no position on an entity seeking a law enforcement exception, it doesn't happen. No. I mean, you just don't see that. And then the foreclosure opinion, which was the antithesis
Right,
of the position.
of their opening Texas up.
Right.
This was the very antithesis of that.
Yeah.
And then, of course, the MIDI Foundation, where the AG's office is charged with protecting the interests of the public in charitable organizations, to be coming in and trying to side with Nate Paul. But it seems like what Mateer described, that it wasn't until they all got in a room together that all the pieces, they go, oh wow,
This is what's happening.
And anyone who's worked for a very large organization can understand how that happens.
Yeah.
And the AG's office is huge. What is 800 lawyers?
Yeah,
And other staff, the support staff. It is an enormous.
He's talking now. All right, Rick Gilbert.
Witness, are there any statements from this witness you have not turned over? No, Your Honor. Okay. The only thing you have are work product notes? That's all we have. All right. Okay. Be at the microphone, please.
There are no statements from this witness. We have notes that we have, are our mental processes and everything as to what he said in summary of different things and issues, but no notes and no notes have any statement from the witness.
If there are any statements you discover, they would need to be turned over.
That's absolutely right.
All right. Motion's denied.
Yes, Judge.
Bailiff will call the witness in.
Thank you. Oh.
No, you're still under oath from yesterday, Mr. Bangert. Please be seated. Counselor, you can continue.
Good morning. Oops.
Good morning.
Thank you. I want to go, if I can, back a little bit from where we broke up yesterday, back to the MIDI Foundation issue and your involvement in that. After the intervention that you've testified about on June the 2nd of 2020, did the Attorney General contact you personally about that issue again?
We did have conversations subsequent to the intervention, yes.
All right. And what was the occasion? Did you attend any meeting with the Attorney General about it?
I did attend a meeting with him. We were having a senior staff meeting. We had a weekly meeting every week where all of the deputies would gather in the main conference room, and he did request my presence at a off-site meeting to discuss the MIDI Foundation.
Can you give us a time?
The meetings happened in the morning, roughly mid-morning. It was, I believe, after the intervention, but it was prior to my being removed from the case by First Assistant Mateer.
All right. So what did he say? Just if you could repeat what he said to you and asked for.
He came to me in the meeting. The meeting had already started. He approached me and said, I need you to come with me to lunch.
And did he say any further? Who was the lunch going to be with?
Nate Paul.
What did he say to you as to why he wanted you to go to lunch with Nate Paul?
He didn't say specifically at that time. He just said we needed to go and have lunch with Nate Paul.
Did he indicate why he wanted you to go to lunch with Nate Paul?
It became clear subsequent to that what the meeting was about, yes.
What was your position at that time that you had stated to him before the intervention and even at the time of the intervention as to whether you were opposed or unopposed to it?
I was very uncomfortable with the intervention. We had discussed it. There were ongoing conversations after the intervention that made me even more uncomfortable with our position in that case. And I had communicated to him what I believe were the pros and cons, and we were very heavy on the con side.
So where did you go to lunch?
I believe it was Polvo's. It was a Mexican restaurant downtown.
And who went to the lunch with you?
Well, it was, we had to go through some gymnastics to even make the lunch happen. It was with the Attorney General and Drew Wicker from the Attorney General's office, and Nate Paul, of course.
How many weeks after the intervention and after you had expressed your opposition to it, how many weeks after that would this luncheon have been?
It would have been 1 to 2 weeks after is my best guess. I can't tell you precisely, but it was sometime in mid-June. It was very warm.
Did he ever ask you to go to lunch with anybody that represented the Midi Foundation?
No.
Did he ever ask you to go to lunch with the lawyers representing the Midi Foundation?
No.
In the entire litigation that had been going on for several years, did he ever ask you to meet with anybody other than Nate Paul, one of the parties to the litigation?
In connection with that case, no.
All right. Now, when you arrived at lunch, can you describe the lunch for us, please?
The Attorney General drove us over to Nate Paul's office, which is not far from our office, and left his car there. And as I recall, we piled into Nate Paul's car, and then he drove to Polvo's.
As a lawyer, what was your reaction to being asked? Did you consider it an ask or a directive? Let me ask you that first.
Objection, relevance.
I've simply asked you, I've given him a choice. I'm not telling which is
Overruled. You can ask the question.
Thank you.
It was not a request to which I could say no for reasons that I can explain.
Please.
The reasons why were Jeff Mateer and I discussed briefly the request that I go to lunch with Nate Paul. And we very quickly determined that it would be inappropriate.
Objection to hearsay. He's talking about a conversation with Jeff Mateer.
Let me re-ask it a certain way if I can. Thank you,
Please
Your Honor.
sustain that and re-ask.
Thank you very much. All right. Let's go back now to apparently more happened on their initial request. Let's go back to when, at the meeting, he wanted you to go to lunch with Nate Paul. What was your initial reaction when he asked you that?
I was concerned that I was being asked to meet with the principal of a party in a lawsuit to which we had intervened.
And so without going into what Mr. Mateer and you said, who did you go to talk to?
I visited with the Attorney General, and I explained to him that there were ethical concerns because as counsel for the state of Texas, I would be meeting with a represented party in a lawsuit to which the state of Texas had intervened.
So what did you ask him if you could do, and what did you do?
I explained to him
Objection to
that...
hearsay.
What? It's not. It's a conversation with the Attorney General.
It's
Overruled.
I explained to the Attorney General that the only way that we could properly make this work under the rules of ethics is if there was a waiver from Nate Paul's counsel allowing me to speak directly with a represented party. My assumption was that that would terminate the request and we could go back to the meeting.
So was that the course that you took after you privately consulted with Mr. Mateer?
Yes.
All right. And then when you told the Attorney General that, what did he do?
He went back to his office for a short amount of time and emerged with a document that purported to be a written waiver from Nate Paul's counsel, giving me permission to meet with Nate Paul without his lawyers present.
Mr. Bangert, how long did it take the Attorney General of the state of Texas to go into his office, contact the counsel for Nate Paul, and get a document prepared that waived any objection that lawyer would have to you talking directly to Mr. Paul?
Objection, speculation. This witness doesn't know what Mr. Paxton did in his office.
The question was how long it took.
Overruled.
Thank you. Excuse me. Thank you.
No more than 15 minutes.
And what was the document he brought it back to you in 15 minutes?
My recollection is it was a document that had been faxed or emailed to him. It was not something that I believe he would prepared. The appearance of it was not something that he would have prepared. But it was a document that had been prepared by one of Nate Paul's lawyers, waiving any conflicts that might arise from me as counsel for the state of Texas, meeting with a represented party.
All right. Well, after that process and all, did you feel free to decline the lunch meeting, or what was your reaction? What did you do?
Well, I told Mr. Mateer that he had gotten a waiver, and I was pretty much straight out of luck at that point. I had to go.
Now, when you went to Mr. Paul's office, where was his office, by the way?
It was in downtown Austin, south of here, but I don't recall specifically the location.
And when you went, I mean, you guys actually went and got in his office and got in his car and went in his car?
We went and parked in his parking lot and got in his car.
Describe the lunch for us. Where, did you sit in a public area or a private area or what?
We went to Polvo's. I recall the layout of the restaurant. It was Polvo's downtown. We went into the restaurant. If I recall correctly, Nate Paul wanted to sit outside, even though it was warm. So we sat out on the porch. It was very uncrowded. There weren't many people there. And we sat down for lunch.
And how did the conversation go? Did Mr. Paxton introduce the subject, or did you introduce it, or did somebody else do it?
I was not entirely sure why I was there, but it became very clear. Nate Paul, in the moment we sat down.
Objection, non-responsive.
I'll take care of it. Thank you, Judge. If it's okay, I'll
Sustained and continue.
Thank you very much. Who was the first person to speak, if you recall?
Nate Paul did almost all of the talking.
Did the Attorney General do any kind of introduction or anything? What was his role in this conversation?
It was nothing more than, Ryan, this is Nate Paul, and there are some things he'd like you to hear. That was effectively the upshot of it.
There was some thing, he said what?
I'm paraphrasing now, but it was to the effect of, this is Nate Paul, and he has some things to share with you.
So then what did Mr. Paul do?
He proceeded to lay out his theory of the case.
Objection, hearsay. He's talking about a statement by Nate Paul.
Sustained.
Did the Attorney General during this entire conversation reject anything that Mr. Paul was saying?
No.
Did the Attorney General of the state of Texas do anything to show that he did not agree with the things that Mr. Paul was saying?
No.
So once again, this conversation with Mr. Paul that was had in the presence of the Attorney General, what did Mr. Paul say?
Objection, hearsay.
Your Honor, the reason for this is all in the presence of the party, the Attorney General, and his silence or his statements are acquiescence in adopting the statements of Mr. Paul. That's why I don't believe that it is subject to the hearsay exception.
Judge, permission to respond?
Respond.
There is no evidence that this witness can talk about that Mr. Paxton has adopted any statements made by Mr. Paul during that conversation. And because of that, it is not a statement that is adopted by a party opponent, and for that reason, it's still hearsay. Any statement by Nate Paul is hearsay at that meeting.
Overruled. Continue.
Thank you. What did he say?
Mr. Paul laid out his theory of grievances against the Midi Foundation. He described to me how unfair it was that a charity that was a limited investor would be able to assume control over assets that were owned by World Class. He was very vehemently opposed to the receivership. He, as I recall, was more or less railing on the way that Ray Chester and the counsel for Midi Foundation had handled the case, and more or less went through a number of different complaints that had been raised in a memorandum that had been provided to me by his sister, Sheena Paul.
think it'll be coming clear in later testimony from others, but Sheena Paul is a lawyer, is that correct?
Yes.
And she's the sister of Mr. Nate Paul, is
That's
that correct?
correct.
But your familiarity with the case, that she's been actively involved in the litigation on behalf of her brother?
I don't know how actively involved she was. My impression was she was involved as general in-house counsel for World Class, yes.
All right, fair enough. How long did this description of his complaints and his position with by Mr. Paul, how long did that last?
Oh, the lunch lasted for a good 30, 35 minutes, if not 40. Somewhere in that range.
Did you folks have food?
We did order food. I don't think I ate very much.
Did the Attorney General during this meeting ever reject or try to modify or ask questions or do anything during the time that Mr. Paul was pleading his case to you?
He did not, no.
How did the luncheon end?
Mr. Paul completed his exposition, and that was a signal for the lunch to end.
Did you ask any questions?
I may have asked a few questions, I don't recall, but it very much had the feeling that I had been summoned to a lunch.
Objection, non-responsive.
Excuse me. I don't know whether it was or not. I don't know what the answer was.
Sustain the objection, rephrase, please.
Thank you. What was your impression about that, what that whole meeting was about?
The strong impression that I had developed was I had been summoned to that lunch by Nate Paul to hear out his grievances and to convince me to get on board with the MIDI Foundation intervention program.
So how did it, once it ended, what did y'all do?
We parted ways, drove back, got back in the Attorney General's car and came back to the office.
Did the Attorney General say anything to you about the case after y'all left Mr. Paul at his office?
Very little.
Did y'all just sort of sit there silently?
As I recall, it was a very quiet ride back, yes.
And was Mr. Wicker present for this whole conversation?
He was, yes.
Did you talk to Mr. Wicker about that after you came back?
I did.
All right. And did you yourself express yourself as to what you thought about the lunch?
Yes, I did.
What'd you say?
Objection, hearsay.
This man is here. It's not hearsay. A statement by the witness, Your Honor, is not.
Overruled.
Thank you. What did you say?
I told him, Drew, that was one of the craziest things I've ever seen.
His response?
Objection, hearsay.
Thank you.
Sustained.
Right. Thank you, Your Honor. Thank you, Your Honor. We'll move on. Now, let me, how old were you at that time of that conversation?
How old was I?
How old were you in the summer of 2020?
I was 42 or 43. I'm trying to do the math in my head. 42, I believe.
How long had you been a lawyer?
I had been a lawyer since, for about 15. Well, I think I was 43 now that you mention it, because I'm doing the math. I was 43. And I had been a lawyer for the better part of 15 years at least.
Had you ever, in 15 years as a lawyer, experienced anything like that?
Objection to relevance and an improper opinion, Judge.
I'm just asking him if he's experienced he'd ever had anything similar as a lawyer.
Overruled. Continue.
Go ahead.
It was, as we say in the Latin, sui generis. It was one of a kind. I'd never seen anything like it.
All right. Now, I can, if, by the way, there is one fact I want to try to move on to another subject. But at this time that y'all are spending this time dealing with Mr. Paul's issues, what all is going on in the Attorney General's office as far as real work that you guys, women, were responsible for doing? What's happening on the landscape in the state of Texas and in the Attorney General's office that y'all wanted to be working on?
We were working around the clock on COVID-related issues, and we were also preparing a major multi-state lawsuit against Google.
And is that Google lawsuit still pending?
As far as I know, it is.
But has it since been given to an outside law firm?
Yes.
At the time you were there, was it being handled in-house or by an outside law firm?
In-house.
Right. Did it remain being handled inside the firm, inside the agency, until after all of you resigned or were fired?
Objection, this witness doesn't have personal knowledge of that.
Let me put it this way. Of the people that left on the top floor that were all terminated ultimately, the 8, what people have called colloquially the 8 whistleblowers, was Google ultimately farmed out to a private law firm after all of y'all were gone?
Objection hearsay, objection lack of personal knowledge.
Hearsay is
Overruled.
Thank you.
I believe more than one law firm, yes.
Pardon me?
I believe more than one, yes, outside
Right.
firms.
Now, if the microphone, I can't tell, I don't know whether it's being picked up behind me, so if you could just, maybe if it's louder to me, then maybe it'll be louder back there, okay? In addition to Google, were there other major pieces of litigation going on that you were responsible for?
Yes, there were.
What?
The Special Litigation Unit was very busy handling a number of election-related lawsuits.
All right. And were there other areas? What was y'all's experience or involvement at that time in trying to cope with COVID-related legal issues?
We had a section called the Disaster Counsel Advice section under the General Counsel that was handling a flood of requests from local officials as to how to handle COVID.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
Can you put any kind of quantifying amount on it as you sit there?
Well, certainly the opinion that we discussed yesterday consumed the better part of 3 days of my time that could have been spent working on other matters. And of course, the MIDI Foundation consumed a lot more time than that.
Now, I want to ask you if I can, and then of course we haven't gotten to whatever time was expended on the hiring of somebody purportedly being a special prosecutor. In other words, the hiring of an outside counsel. We haven't even discussed that.
Objection to attorney testifying.
Excuse me, let me finish my question, please.
Judge, my objection is
Please.
to the call of his question.
Counsel, let him finish.
Yes, Judge.
And then you can object. Mr. Hardin, you can finish your question.
Thank you. Do you have any idea how much more time and resources were devoted to once you discovered this issue of an outside counsel being considered and then being done?
It was many, many hours. We spent days dealing with the fallout of that, and that was all of us together. So 7, 8 of us at least, plus a few support staff. So it'd be hundreds of man hours.
All right, now, Mr. Bangert, I want to go to, you mentioned what some of us colloquially have called the midnight opinion. Can you tell us, without not necessarily a long legal description, is there a section in the government code that deals with these opinions?
There is a very distinct section in the government code that deals with our authority to issue opinions, yes.
All right. So when we talk about opinions, very briefly, that come out of the Attorney General's office, how many types of opinions would you say there are involved?
There are there are a handful of types of opinions involved. The first would be an opinion issued pursuant to our government code 402 authority to issue opinions to individuals who are authorized requesters.
All right, let me stop there. So Section 402 of the government code authorizes you to produce opinions in response to whom?
Very specific individuals. There's a list in the code. Chairmen of legislative committees are one. Certain statewide officials. There are a handful, I believe, of local government officials who would be authorized, but it's a very distinct list, and that list cannot be waived.
And is there any distinction in the government code between an informal and a formal opinion?
No.
Do you recall whether or not in the opinion that y'all wrote at the Attorney General's request, do you recall any language at the end of it that talked about it was an informal opinion guidance? Can I put up, do we have an exhibit number for Can I step over there just to get an exhibit number, please?
Yes, sir.
Thank you. Stacy, can I ask you to put up Exhibit 115, which is in evidence? And can we go to the end of that opinion, please? Well, first of all, do you recognize...
Counselor, has this already on the list of admitted evidence?
This has already been admitted.
It has been. Okay.
Yes, this is one that's agreed. Thank you, Your Honor. Do you recognize this exhibit?
I do.
And what is it?
The first page, this is the opinion that we worked on and issued August 1st in response to the Attorney General's request concerning foreclosures.
All right, and this is the opinion you've talked about earlier that was completed at about 1 o'clock in the morning on that Sunday?
It is.
All right, now if you would, Stacy, would you scroll to sort of the end of the opinion? Now, could you explain to us, I believe you just testified there's not a difference, there's not a distinction in the code between informal and formal?
And Judge, I'd object that that is an improper legal conclusion by this witness.
What? I'm
Overruled.
sorry. Thank you. This opinion that you drafted, and this is actually an opinion that you signed, correct?
Yes.
And was this division and this matter under your supervision and control?
It had been.
All right. Before you became the deputy first assistant, is that what you mean?
Yes.
Okay. All right. So the language says, I'm trying to stay with the microphone to be able to read. It says, please note, this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance. Explain to me what the significance of that and is that inconsistent with your previous testimony?
No, it is not.
All right, explain, please.
Well, I would analogize this to the practice in Texas courts of issuing published and unpublished opinions. We have an obligation under 402.045, which is part of the opinions authority, only to issue opinions to individuals if they are authorized requesters. You cannot simply issue opinions as the Attorney General's office to any individual who asks, because we are not a private law firm. We serve the interests of the state.
So if I walk in off the street or have something in my business or so that I really want an opinion for, am I entitled to ask the Attorney General's office to give me an opinion, just to give me the legal advice?
No, not unless you're one of the listed statutory requesters.
Is a legislator one of those people that is authorized to ask?
Chairman, yes.
All right. And it has to be a chairman of a committee?
Yes.
And in this case, as we've talked about yesterday, that's what happened, correct?
Yes, I believe Senator Hughes at this time was chair of the State Affairs Committee and possibly one other.
All right. Now, was there a time in the history of the Attorney General's office in which the office did issue informal opinions?
My recollection was that, yes, there was a time when we would post opinions on our website that were informal in nature.
All right. And are you aware that your website, their website now, the Attorney General's website now, indicates that stopped in 1979? Is that anywhere consistent with your understanding?
That would not surprise me.
All right. Now, go here to explain to me why you put this language in here then that said it's not a formal Attorney General opinion. It is it is intended only to convey informal legal guidance. Explain why that's okay, or why you put it there either.
Yes. The normal opinions process involves going through the opinion committee. It's a very rigorous process of drafting, review, approval. It goes up through a number of different layers of review. This did not follow that normal process. It did not go out for briefing for third parties to evaluate and consider whether they wanted to brief on this. So none of those procedural aspects were associated with this opinion, nor did it receive what we call a KP number, which is a formal opinion assignment number for publication on the website and ultimately publication on Westlaw.
Well, as far as the statute is concerned, is there a distinction by what you did on this opinion that night? Any different? Is that opinion and its consequences any different than in terms of its effects on the outside world?
Objection.
Excuse me, let me finish my question. If I could remember what it was, let me start over. Is there any difference on the impact on the outside world of what you did here in this particular opinion and what an opinion that you might have issued that went through the formal process that you say takes up to 6 months or so?
No, all of our opinions have persuasive value.
Improper legal opinion.
Overruled. Continue.
Why did you say that then?
This signaled to the reader that this opinion had not gone through the formal, rigorous process of review by the opinion committee. It had not gone out for briefing. It had not gone through the normal process that can take up to 180 days of time. And it was also not going to be receiving a KP number. And I don't believe this is published on Westlaw. I haven't checked, but I would be surprised if it were.
So why did the two of you decide to do it this way, to put that sentence in there? Would you ordinarily have put that sentence in an opinion where, say, another chairman of another committee asked for it, et cetera? Would you have ordinarily put this sentence in there?
We would not put this sentence in an opinion that went through the normal formal process. There were other opinions that contained this language, but all of them had similar characteristics. They were requested by someone who was an authorized requester, and they did not go through the formal process.
And does that not going through the formal process and you're communicating that to the outside world, is there a reason you do that?
This signals that it did not receive the rigorous review that an opinion of our office normally would.
So if lawyers in court are contesting, having a controversial issue, and their opposing side sought to introduce this, is that sort of a signal to anybody that knew about the process that they might have an argument to the judge? Wait a minute, this is not, there's no such thing, may not be such a thing as an informal opinion, Judge, but this opinion did not go through the rigorous process a normal opinion did. Would that argument be available to him?
I presume it would be. Certainly our intent was to signal this had not gone through the formal process.
All right. I notice your eyebrows go up when you're thinking. Does that mean that you never had thought about it before I just asked this?
Oh, no, this is something that we were dealing with en masse.
Section non-responsive. There wasn't a question asked.
Okay. Were you having these were you having these kind of questions all the time? Or not all the time. Let me put it another way. Were you frequently having to deal with this kind of issue?
At this time, this specific moment, we were dealing with an unusual influx of requests for advice.
And was there a process in which you could provide, are there other ways that you could provide, other than just this? Could you do things in another way, like press releases or things like that?
Certainly, if we're not providing legal advice to an individual, we can send out press statements, we can send out bulletins or announcements. I don't see anything that would preclude us from doing this, but the code 402045 is very clear that if we're providing advice to an individual, then that individual must be an authorized requester for the purpose of ensuring that the interests of the state are being represented by that request.
Are you aware, one way or the other, whether opinions like this might be used by litigants in private litigation?
I assume they are, because that's why they are posted
Objection,
on Westlaw.
speculation. This witness was not there for the litigants.
I would,
Overruled.
Your Honor, I'm going to ask if the court might, I'd say this nicely, instruct counsel when he has an objection to wait until the answer is completed, and then he can object and ask for some, if the court sustains it, he can ask for other things. But this constant interrupting the witness in the middle of the statement, or the questioner in the middle of the statement, is unduly time consuming.
Your Honor, may I respond to that?
Yes.
I have to object if the witness is testifying to things that shouldn't be admissible into evidence. I shouldn't have to wait for him to say hearsay before I make that objection. And so I would request to wait till Mr. Hardin finishes his question and then lodge my objection.
If you're talking over each other, the courtroom counselor, but try to not talk over each other.
Yes, Judge.
Thank you, Your Honor. Excuse me. Now, there, real quickly, we're about through with this issue, but I want to know if there are other ways that y'all chose to inform people. For instance, if mayors, what was your experience during this period of time, if mayors of cities or local government spokespersons or officers were contacting you for legal guidance, how did you approach those kind of issues in dealing with COVID?
Yes. The legislature had granted our office authority under Section 418 to respond to requests for legal advice from certain local officials, mayors are one of them, for issues related to a declared disaster in their jurisdiction. That code was passed, my understanding, in response to hurricane disasters. No one anticipated every single county in the state of Texas being placed under a simultaneous disaster declaration in response to COVID, but so it was. So we effectively became available to officials in 254 counties throughout the state of Texas under 418.
Do you have any knowledge one way or the other through discussions and activities in the Attorney General's office as to whether or not the Attorney General had indicated he was aware of other possible ways to address someone's concern about a gathering other than Section 402?
Unless there was an authorized requester under 418, no.
All right, thank you. Now, at the end of the day, once this process was completed, was there any distinction in however it would be considered by others in this opinion and the opinion that went through the very rigorous 6 months of research and consultation?
The effect is the same. They have persuasive value based on the solidness of the reasoning and based on the fact that it's issued by the Attorney General's office. It's the persuasive value of the opinion that follows it.
Thank you. Now, when we can, I want to go to one final question. Is an opinion under this Section 402 that you issued, is it considered just as authoritative, though, in terms of its results, as an opinion that goes through the rigorous examination that you described?
There's no reason it would not.
Okay. Now, would it have the same ability and the same impact if one wanted to seek to use it in litigation?
Again, the reader would evaluate it for its persuasive value, just like a formal opinion.
All right. Now, I want to move, if I may, sir, to what happens starting in your experience. When did you become, with the outside counsel, when did you become aware that the lieutenant governor wanted to appoint outside counsel?
Senator, counselor, I almost called you senator, so we're even.
You know, I've done it again.
Yeah. I'm going to be forced to hold you in contempt soon, Harold. Just kidding. Just kidding.
I'm just thankful I didn't put a name to it.
So am I. So go ahead.
All right. Let me start again. When did you first become aware that the Attorney General was interested in and concerned and wanted an outside lawyer hired to deal with an investigation of Mr. Paul's complaints?
Objection leading.
I don't.
Overruled.
It would have been sometime in August or September that I learned about the outside counsel request.
All right, there we have seen one that talks about the matrix that such a request would have to go through. Were you aware that Mr. Vassar had drafted a contract at the request of the Attorney General's office before, and if so, when did you become aware of that?
I was aware of that, yes.
And had you taken a position about whether or not to hire an outside counsel?
With the Attorney General,
And
no.
your microphone.
I had not, but I obviously in conversations, I should say obviously, in conversations with other senior staff, we were very much in agreement. This is
Objection to
not a
hearsay.
proper.
Objection to hearsay.
He hasn't. See, that's the problem with doing it. He did not talk about what they said. He did not talk about any statement. And this interruption of the question keeps it from being clear as to what he was going to say. That's my concern.
Overruled.
Thank you. So, and the question was your position.
Improper.
All right. And do you recall when's the first time you told the Attorney General that yourself?
I did not have occasion to speak with him about this as it was outside my line of authority.
All right. So if your opposition that you thought you were opposed to it, would that been communicated to others rather than the Attorney General?
Objection
Yes.
hearsay.
I'm sorry, what was the answer?
I'm objecting, and I would ask for a ruling, Judge.
Counsel, you're talking over him that I can't even distinguish what you're objecting to, what he said or what he said. So let's start over on that question.
Sure. Thank you, Judge. Were your conversations, without going into what they were, about this subject with other people rather than the Attorney General?
Yes.
Objection. Okay.
Overruled.
Yes.
Thank you. Now, at the end of when did this, from your perspective, when did this issue boil over?
When you say boil over, could you be more specific?
Yeah, if you could, again, it sounded to me like you moved away from the microphone a little bit.
Mr. Bangert, you could speak a little louder, I think.
Yeah,
Speak up a little bit more.
Thank you very much. All right. I didn't know that moved. Okay.
I think I might have broken it, so
All right.
hopefully not.
So don't mess with the base of it very much or we can both get in trouble. When I used the phrase boil over, let me explain what I mean in my question. What I mean is, when did this become an issue of concern to more than just one person in the criminal justice division that you became aware of? What time frame is all I'm asking you?
Increasingly through August and into September, it became an issue of very urgent concern for me, as well as for others on the senior leadership team.
All right. Now, tell me what it was, in fact, when did this issue first surface, and what matter did it surface that gave you concern?
When you say the matter, it would be with regards to Nate Paul?
Yes.
My concerns had been growing exponentially over the 9 to 10 month period that we were dealing with matters related to Nate Paul. It began when the opinion when I was asked to intervene and work with the open records requests. It was uncharacteristic. It continued and was heightened when I was asked to work on the MIDI Foundation project. I was exceptionally concerned after the opinion was issued because I felt there had been a break in trust at that point. And of course, when I became aware that the Attorney General is now pressing for criminal investigation of individuals in the community based on allegations that all of us believed, and I certainly believed, were frivolous at best, I was exceptionally concerned.
Now, without going into what other people told you at the time in a specific conversation, did you become aware of generally the subject area or so that the Attorney General was seeking to hire outside counsel to investigate?
Yes, it involved the law enforcement action concerning Nate Paul and his properties. He was concerned that again, this was his same mantra over and over again.
When you say he, are you talking about the Attorney General?
Well, Nate Paul, and in connection with the Attorney General, arguing that law enforcement had been wronging Nate Paul, had been oppressing Nate Paul, and had been treating him unlawfully. There was no evidence that I had seen whatsoever to substantiate any of that.
Judge, I would object to that. It's an improper opinion, it's speculation, and this witness doesn't have personal knowledge of Nate Paul's opinions or feelings at that time.
He's expressing his opinion of what gave him concern on an evolutionary, evolving way, Your Honor.
Counselor, I think he's expressing his opinion, so overrule.
Yes, Judge.
Now, when exactly did you start getting involved in expressing your position and taking your position on this matter?
We were discussing it actively throughout the month of September.
All right. Now, at the time, were you aware one way or the other that Mr. Penley was refusing to sign the contract that had been drafted by Mr. Vassar to retain Mr. Kamek?
Yes.
Though it had not made its way to you, had you seen the contract that was proposed?
I do not recall, although I had certainly discussed it with others.
Did you, in fact, take any position in these meetings, you yourself, of senior staff, on the advisability of hiring Mr. Kamek to go investigate multiple public law enforcement persons? Did you?
Yes.
And what were you saying? What was your position?
Objection, hearsay.
It is not hearsay. There is no hearsay for the witness on the stand.
Overruled. Counselor, he's asking him for his opinion.
Okay. What was your position?
There was no basis or justification for it. It would not serve the public interest.
And if you had to describe the opinion of about how many of you were involved in this issue at the senior level?
Jeff Mateer, I was aware of it. David Maxwell, Mark Penley. I'm Ryan Vassar, obviously. Lacey Mays, because she was working with Mr. Vassar, and Blake Brickman as policy would have been involved as well.
By the way, you've essentially named the group of 8 whistleblowers, have you not?
I don't believe I named Darren McCarty.
All right, and was he one of those that was also concerned?
He was, although his focus was primarily civil.
All right, now, I don't think I asked, maybe if I did, I want to be clear. Have you sued in this case?
I have not sued the Attorney General, no.
And so as we look and listen to people in this testimony, Mr. Mateer and you both, neither one of you have sued or sought any damages or compensation. Is that correct?
I have not sued, and I am aware that Mr. Mateer has not either.
All right. Now, when how did this thing come to a crescendo, if it did? When you talk about the first week in September, what events were you aware of that affected what happened at the end of September?
I was in Atlanta, Georgia, at a conference with Mr. Mateer. We were about to join a significant telephone call with our multi-state partners to discuss the Google litigation that was planned. The call was set to begin. It was a very important call for coalition building purposes. Mr. Mateer received a telephone call. It was from the Attorney General, and I was witness to Mr. Mateer's side of the call. The call had nothing to do with Google. It was all about Nate Paul.
And at that time, how big an issue and a matter and piece of litigation was the Google case in the Attorney General's office?
It was consuming substantial resources and was a major initiative of the Attorney General's office, and it was, yes.
Did you two inform the Attorney General you were about to go into an important meeting on Google?
Yes.
What did you say?
Mr. Mateer was the one communicating directly with the Attorney General, but something to the effect of, do we have to do this now? Because we're about to have this Google conversation.
What was the Attorney General's response?
I could not hear his response, but the phone call continued for some time, so I have to assume his response was yes, we have to.
All right, his objection is to you assuming, and I agree with that. Don't assume what happened, but as a result, even though the Attorney General was told that you were about to be involved in a meeting on a very major piece of civil litigation, did he terminate the call to talk later?
No, it continued for some
Objection
time.
to speculation. He couldn't hear Ken Paxton on the phone.
Counselor, he asked if he terminated the call.
Yeah.
Continue.
Thank you.
Overruled.
Thank you. Now, this conversation that lasted, were you part of it in terms of being able to respond and hear the Attorney General?
I could not hear the Attorney General, nor could I respond to him.
Could you hear the conversation in response by Mr. Mateer?
Yes.
And the conversation lasted again about how long?
We went right up to the bell. We were almost late for the Google call. It probably took about 10 minutes.
Your Honor, I would urge that this conversation, which was happening between the two of them, is actually not hearsay in the sense the content of what the Attorney General was saying, or what Mr. Mateer was saying, rather, not offered for the truth of the matter of what he was saying about Nate Paul, but only that that's what he was telling these folks. And so I would like to tender conversations as to what he was having with Mr. Mateer as they were talking.
Hold 1 second, Counselor.
Sure.
Was there I don't think there was an objection. You were starting this line of questioning.
Only because I didn't want to speak over anybody, but I am objecting to this line of questioning, and I do have a response if the court would care to hear it.
What is your response?
Well, that Mr. Bangert has already testified that he could not hear Ken Paxton on the other side of that phone call. So he can't testify to this court that he's adopted any of the statements made by Mr. Mateer. Mr. Hardin wants to submit Mr. Mateer's testimony. That's not made in court. That's hearsay.
If I may I ask counsel, I didn't understand the first part of it when he characterized what the testimony was.
The objection's hearsay, Judge.
Well, I understand that, but when he characterized what Mr. Mateer's testimony was, I just asked him to repeat what he said there because I just didn't get it. That's all I'm saying.
What I said was that Mr. Bangert has already testified to you and the jury, Your Honor, that he could not hear what Ken Paxton was saying on the other side of that phone call. And so there is no evidence that he adopted anything that Mr. Mateer said. And so they're not his statements, and it still amounts to whatever Jeff Mateer said is still hearsay.
I'm sorry, but you have to go back on the record. That's not my memory of Mr. Mateer's testimony. That's why I wanted to ask him to repeat it. I don't think they talked for 15 minutes with Mr. Mateer not being able to hear him.
I'm going to overrule. Be careful as you move forward.
So this conversation, did Mr. Mateer give any indication he couldn't hear the Attorney General?
It became clear to me by listening to the conversation, it was about Nate Paul, and in particular, this question about retaining outside counsel.
Objection to hearsay. Judge, may I be heard?
No, wait a minute. We just went through that. He just ruled on this matter.
I've already ruled, overruled. Continue.
Go ahead, sir.
It was concerning the hiring of outside counsel to investigate these allegations that Nate Paul had brought to our office.
Can you put a date on it?
The best I can recall, the conference took place maybe a week and a half prior to the end of September.
Was there anything in this conversation, as you heard from the other end, about him being disturbed that Mr. Pendley would not sign the contract?
Objection. The question calls for hearsay. He's asking what Jeff Mateer said on the phone call.
I believe the court's already ruled on this. I'm simply asking him about the conversation.
I've already ruled on this, Counselor.
Judge.
Go ahead, sir.
Mr. Paxton was frustrated that we were not moving forward with the retention of outside counsel.
Objection to speculation. And he didn't hear Mr. Paxton on the phone call. His opinion of what Mr. Paxton thought is improper.
The court has just ruled 3 times on this issue.
My objection was different, Your Honor.
Overruled.
Now, at the end of the conversation, during the course of this conversation, were the people for the meeting at Google having to wait till the General Paxton finished trying to get you to approve an investigation by Mr. Cameron?
I know we went right up to the wire. We may have gone a few minutes past it. I don't recall, but it was close and it might have gone over.
Well, I'm wondering, is at the end of the conversation, did you have any new instructions as to what the 2 of y'all were to do about Mr. Kamek?
I did not receive any instructions myself.
All right. As a result of that conversation, did you do anything new or express any new concern about the hiring of Mr. Kamek?
I did nothing new. My concern was heightened substantially.
Objection, non-responsive.
Let him finish the answer, please.
Counselor, he's answering the question that was directed.
Yes, Judge.
Overruled.
Thank you.
My concern based on that occurrence was substantially heightened because we were about to move into a very intense phase of the Google litigation, and the Attorney General's focus was on Nate Paul, not on the Google case.
So at the end of this conversation, who did you understand that the Attorney General wanted an outside counsel to investigate?
The law enforcement action concerning Nate Paul. That would have included the search of his house, his properties. The theory was that there had been an improper warrant obtained, and I believe there were also allegations of a conspiracy by law enforcement.
All right. And did it include investigating federal magistrates? 8 federal magistrates?
Yes.
Did it include investigating individual law enforcement officers in the FBI?
Yes.
Did it include investigating DPS officers?
I believe so. I believe that's correct.
And did you know at that time, were there any members of the Securities Board that were also part of this that he wanted investigated?
I believe Mr. Saban.
And were you aware as to what both the head of your law enforcement division and Mr. Maxwell, because I'm not sure exactly what his title is, were you aware of what their consistent positions have been all along on this matter?
Yes.
And in spite of that, was the Attorney General still insisting on going and investigating these people on behalf of Mr. Paul?
Yes.
When you returned to Austin, when was the next time you had any contact with, or were aware of this particular activity?
I was in a meeting at the governor's office. I believe it was with Mr. Brickman. We had normal meetings scheduled during that time to respond to COVID.
Can you give us a date?
I believe this was September 30th.
All right.
Toward the very end of September. I received a text message telling me to return to the office, that something had happened. My immediate assumption was that something was Nate Paul.
Why?
Because we had been becoming increasingly concerned. We felt as if matters were coming to a head. The Attorney General was insisting that we move forward with outside counsel. We strongly resisted that. We, at that point, had become cognizant of the pattern that had developed over the preceding 9 months. And it was clear to me that hiring outside counsel to undertake this task could only benefit one person.
Then I'd object to that opinion. It's an improper opinion.
It's his opinion, Counselor.
Totally responsible. I'm sorry. I'm sorry, Your Honor.
Sorry. I said it's his opinion. Overruled.
Yes, Judge.
Thank you. Now, when you were at the governor's office, had you been aware, or made aware yet, of a phone call that had been received by any of your other staff the day before involving Mr. Kamek and subpoenas?
If you're referring to a phone call received by Ms. Mays from a banker.
And I'm only asking, were you aware of that call?
The meeting at the governor's office took place on the same day that Ms. Mays received the phone call from the banker. So if that phone call took place on the 29th, that was the day of the meeting.
All right.
Objection, non-responsive to the question.
Counselor, overruled.
And now, when you were at the governor's office, was there somebody else with you from your staff? Was there another member of the Attorney General's office with you?
My recollection was Blake Brickman.
All right. And were y'all on totally unrelated, normal business with the governor's office?
Normal business.
All right. So what did you do when you got that text?
Excused ourselves from the meeting, and we departed and went back to the office, the Attorney General's office.
And what time that day, on the 30th of September, did you return to the AG's office, and where did you go?
We went to the 8th floor and went directly to Mr. Mateer's office. And Mr. Mateer was there, Lacey was there, I believe others were starting to gather.
All right. And now, would you describe the atmosphere in the room? First of all, how many ultimately ended up in the room talking about this matter?
Mr. Maxwell was on vacation, but all the other deputies that were involved as the whistleblowers ultimately were there.
And what was the atmosphere?
Disbelief, shock, extreme concern.
What were you most concerned about? What did you learn that made you most concerned?
We had been following this pattern of Nate Paul and his interests metastasizing throughout the agency over a period of months. It had become clear to me, based on my conversations with the Attorney General, based on the lack of any substantiation for many of the claims that were made, based on the absence of a public interest in taking actions to benefit Nate Paul. Based on all of those concerns,
Counselor, I'm sorry.
I
If
was
you have an
asking
objection, raise an objection, but just interrupting, not helpful. I didn't hear an objection, and I just heard interruption.
I apologize, Judge, but I'm just intending to object because I believe that what Mr. Bangert is doing on the stand is not responsive to Mr. Hardin's question, and I have to lodge my objection so that he doesn't testify before the jury.
Counsel, I think he wants you sitting so the rest of us can hear you.
Sorry,
we can hear you.
Just
Sorry.
please sit. We can hear you better.
Right. I'm objecting while Mr. Bangert is speaking because he's testifying to evidence that I believe is not admissible, and he's telling it before the jury. And so I'm lodging my objection before it gets to the jurors so it doesn't affect, inadmissible evidence doesn't come in and affect their judgment in this case. So I don't mean to speak over Mr. Bangert, Your Honor, but I do have to lodge my objection on behalf of Mr. Paxton.
I just did not hear the word objection.
Okay.
And if he objects, witness, stop talking where you are. Do not continue. I overrule the objection, however.
Thank you, Judge.
And the question was, I was asking you what your concerns were and why. And I think you were in the process of setting that out. Let me ask you this. In the course of this conversation, first of all, you of course were not here for opening statements, were you?
No.
And you weren't here for the cross-examination of Mr. Mateer?
No.
If someone was contending that you folks were sitting around involving it in a mutiny, what would be your response to the suggestion that you folks were sitting around there cooking up a mutiny against the Attorney General of the state of Texas?
As in we were, that would make no sense to me. We were trying to protect the Attorney General as much as we could.
As a matter of fact, over the last 9 months, what had been your mission in relation to the Attorney General as it related to Mr. Paul?
We had continually, in various ways, warned him about Mr. Paul. We had discussed with him the absence for any substantiated basis for taking actions to benefit Mr. Paul. We had been rebuffed.
During all that time, were you still a supporter of the Attorney General?
Yes.
Did you believe in the things that he was publicly saying that he believed and he wanted to do?
Yes, that's why we were there.
And did you, all that period of time when you were warning him about Nate Paul, what is your testimony in terms of whether or not you still were looking after the best interest of the public, but also the Attorney General?
Senior staff always has to walk that line. And our job, we take an oath to defend the Constitution of the state, but we also are loyal to our principle. And those two things, in almost all cases, are consistent with each other. So our job is both to protect the interest of the public and to serve at the pleasure of the Attorney General.
And when this meeting is held, by the way, I think you said the 30th, and I want to sort of put a couple events in your mind to see whether it's possible that meeting would have been the 29th, for you to let us know whether it's the 29th or 30th. You ultimately called and made an appointment to visit and go to the FBI during this time frame, correct?
Yes.
And you were over at the governor's office. And if the evidence is going to be unrebutted that you and your group went to the FBI on the 30th, when would this meeting, what is your testimony as to when this meeting that you've been describing would have been?
It would have been the day before. It would have been the day before, the 29th.
Okay. So this meeting where you come back over from the governor's office and you all meet together was on the 29th of September?
Yes.
How long by this time, had you been informed of what these subpoenas that had been served by Mr. Kamek were asking for?
Initially, we were aware of a subpoena to a bank requesting records relating to Nate Paul's financial interests. That was the first one that we became aware of. We subsequently became aware of others.
Did you become aware that these subpoenas were actually seeking information through the grand jury, a criminal state grand jury, of Mr. Paul's opponents in his civil litigation?
Yes.
Objection leading. My objection is that the question is leading, Judge.
I'll put it another way, Your Honor, real
Dane,
quickly.
please rephrase.
Were you aware of one way or the other? And if so, what were you aware of in terms of whether the subpoenas of Mr. Kamek were being used and drafted to help Mr. Paul in his civil litigation?
Yes, it became, as the subpoenas began to roll in and we became aware of them, reading them, they were consistent with his argument that he wanted to pursue action against both the law enforcement officials who had pursued the subpoenas of his house and his properties, as well as financial interests related to MIDI Foundation and I believe others.
Now, at this time, when this is all happening, what was there sort of a mood of concern? When you talked about shock, why were you shocked? What were you concerned about?
We were unaware, at least I was unaware, that Mr. Kamek had been taking any action on behalf of our office. I was unaware that he had been retained. I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interest of the broader public.
And the fact that he had invoked the use of a grand jury to try to help Mr. Paul in his investigation, what level of concern and why was that a bother to you?
It was unconscionable in my view. You were using criminal process to pursue the private enemies.
Objection. I'm objecting to improper opinion about the unconscionability of these actions.
I asked why he was concerned.
Overruled.
Thank you. You can pick back up.
Yes, in my view, the criminal process had been harnessed to pursue the business enemies of an individual, Nate Paul, who also happened to be under intensive investigation by law enforcement.
So how did you folks decide? I think it was seven. Was it 7 guys and 1 woman? I mean, so when I'm talking about guys or women or whatever, how did y'all decide? I mean, what kind of considerations did you give as to courses of action you should follow?
I will speak for myself here.
That's all I want you to do.
As a staffer, you have fidelity to the Constitution and fidelity to your principal. Those two things should always align. Unfortunately, over the previous 9 months, they have been drifting further and further apart. One always assumes the best about their principal and attempts to protect that principal's interests, even at your own expense. When I saw that the subpoenas had been issued outside of the normal process of our office to pursue criminal process against private citizens to benefit one individual, it became clear to me that there was nothing more I could do, that the Attorney General was determined to harness the power of our office
And
to fulfill the interests of a single individual against the interest of the state.
And Judge, I would object to that answer. That answer is speculation about his opinion of what the intent was of other parties.
Overruled.
Now, did y'all try to decide what to do in terms of whether you hire outside lawyers yourself? Or what kind of issues were you concerned about as a course of action going forward, you yourself?
We had stepped into the void at that point. There's no roadmap to follow when that happens.
It's sort of like what we're doing here, right?
Yes.
There's no real roadmap except for something 100 years ago and something in the 70s. You were writing on a clean slate, weren't you?
Yes, much against our will, but our hand had been forced.
So what drove you to make the decision to go to law enforcement?
In my view, there was simply nothing more we could do. The course of actions had played themselves out. The Attorney General was determined to follow this course of action in favor of Nate Paul, despite all of our efforts to persuade him otherwise. The power of our office had been fully, at that point, harnessed to advance Nate Paul's interests, and we had lost the ability to, as senior staff, protect our principal.
Mr. Bangert, there's been suggestions repeatedly in this proceeding that why didn't you just go to the Attorney General? Why didn't you go to the Attorney General? Just talk to him. Did you?
Concerns were raised repeatedly and consistently by multiple members of senior staff over a course of several months. There is no question in my mind, based on my personal experience with him, that he was well aware of our objections.
And in fact, after you went to the FBI on the 30th of September, on the 1st of October, did you as a group send a text message to the Attorney General asking to meet with him?
We did.
And before that, had you been aware that he was out of town when all of this happened to begin with?
Yes.
And when I say to begin with, on the period of September the 28th, 29th, do you know where the Attorney General was?
He was on a business trip out of the state. I don't recall which state he was in, but he was out of state.
And on the 29th or 30th, were you, what was the hurry that you experienced about trying to call this to the attention of law enforcement? Were you concerned what Mr. Kamek was still serving subpoenas out there to private people, or what was your concern?
My
Objection
concern.
leading about Kamek, he's insinuating the answer in the question, Judge.
I asked what his concern was.
Okay.
Overruled.
My concern was we did not know what we did not know. We knew that he had already been serving subpoenas on banks. We were learning of additional subpoenas. In my view, we had lost our ability to speak into the situation as senior staff. We had no ability to end the use of our office to advance private personal interests, improperly using the criminal process. The only way we could deal with that situation was to make a report to the FBI. At least that was our judgment at the time.
Do you happen to recall why you picked the FBI rather than some other agency?
My recollection was that we had a relationship with some agents at the FBI who we trusted and we knew. And also the FBI, in our view, would have jurisdiction over these kinds of matters.
And in addition, DPS at that time was one of the groups, was it not, that Mr. Paul was seeking to investigate?
Yes.
At the end of the day, how long when y'all decided to go to the FBI, how many of you went and how long were the interviews?
7 of us went. We were interviewed together.
All right. And how long do you think the interview?
Multiple hours.
And once that interview was over, I mean, did you go yourself, knowing one way or the other what type of crime might or might not be involved?
I did not have the precise. I had a fairly good idea what was happening based on the evidence I had collected. Yes.
But did you, one way or the other, as a person not experienced in criminal law, did y'all sit down and decide what statute it was or anything like that?
Objection to improper opinion about what kind of crime this witness believes was committed.
That's fine. I'll withdraw that question.
Sustained.
Thank you, Your Honor. Let me ask you this. Did you consider what he had been doing on behalf of Nate Paul an abusive office?
Yes.
Objection to improper opinion. It invades the province of this jury's decision in this case.
Let me put it in.
Sustained.
Let me put it another way.
Counselor, try a little bit better.
Thank you, Your Honor. Did you yourself, when you went to the FBI, have an opinion that drove you to the FBI about what this conduct by the Attorney General did, that the Attorney General was involved in, as to whether or not he was violating the oath of office that you were familiar with and believed he should be following?
Objection to that question. Again, same objection, Judge.
Overruled.
Yes.
And what did you think? Just you personally?
Objection to improper opinion about in relevance to what this witness thought.
Overruled.
I went to the FBI because I believed that the Attorney General.
Just put the microphone up or move forward, but just move up a little bit if you don't mind.
I went to the FBI because I believed, based on my experience over the previous 9 months, that the Attorney General had abandoned his obligation to work on behalf of the interests of the people of Texas to serve the interests of one person, Nate Paul. And that was based on a series of events that occurred over several months.
Objection to non-responsive. He asked his opinion, not what he based it off of.
Sustained.
Now, after you folks went to the FBI, were you all together when you sent an email the next day to the Attorney General wanting to meet with him?
We did.
What was the Attorney General's response?
It was a very odd response.
What was it?
It was a text message saying that he would be happy to meet with us to address any concerns we may have or something to that effect.
Well, then did he agree to?
No, we did not meet with him.
How did that go? Did you know whether he was able to meet? Can I have the two exhibits? May have just a moment for Stacy. May I have just real quick?
Sure, Counselor, we're at our break time. Do you want to? I don't know how much longer you have with this witness.
I think only 5 or 10 minutes is all I have left with this witness.
Okay, we'll go about another 10 minutes.
Thank you. Stacy, can you, I believe this is in evidence, is it not? We check.
Before we put it up on the screen.
I'm told it is in evidence.
No objection, Judge, to 225.
No.
Continue.
All right. I want you to look at Exhibit 225 and explain to the jury if you can see it clearly on the screen.
Yes, I see the document.
All right. Do you recognize this document and this exchange of text messages?
It's been a while, but I recognize it.
All right. What I'm going to ask you to do, each text message identifies the sender. I'm going to ask you to publish this to the jury and the public, but keeping your voice up. It's a trick because you got to look in there. First of all, if you would, just start out with Mr. Mateer, identify the speaker, and publish this exhibit to the public.
Yes, the text message is dated September 29th, 2020. It begins at 3:02 p.m. The first text message is from Jeff Mateer to a group of us on a group text. Quote, "We have a major problem. The kid has served a subpoena on a bank. Showed up there in person at the bank." Jeff then sends a separate text with someone from World Class. And then he sends...
Did you later discover the person with him
Michael Wynn.
was Michael Wynn, Nate Paul's lawyer?
Yes, Michael Wynn.
So you have him out there serving subpoenas with the lawyer of the person that's asked for the investigation, correct?
That is correct.
Who you know is under federal investigation as you're going along.
That is correct.
Go ahead.
The next text from Jeff, "I need you guys to come back."
All right, then let's go to the next time and so.
Same day, September 29th, 2020, 9:05 p.m. Jeff Mateer writing to the group from Maxwell.
And what does that, do you have any idea what that's referring to? Do you remember?
I believe Maxwell had been communicating with us at that time about the events of the day and had provided his evaluation as to a letter that we had been writing.
And he was actually in Colorado on vacation, was he?
He was
not?
vacationing.
Yeah. All right, go ahead.
Then Jeff pastes in this language, "Read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today that is documented."
And what letter are you talking about there? Or is he talking, that you're talking about? Do you recall?
My recollection is that there was a letter that had begun to be circulated amongst senior staff, but I am reaching into my memory to recall this specific time frame.
Were you at that time drafting a document to be told to be sent to either law enforcement or to the Attorney General announcing? Do you recall? If you don't recall, just tell me you don't remember.
At some point during that date or the next, I was more or less helping scriven. I was a scrivener writing up documents, including allegations concerning what had happened that day. Yes.
All right. Go ahead.
There's a text from someone who is unidentified. It's the person from whose phone this text was produced. It says lots of undue influence. I'm assuming that's Mr. Brickman.
All right. So now read go ahead.
I then respond, "Okay, sounds like we need to beef up the specific allegations."
Go ahead.
I then text again, "So do we need to lay out the facts that led up to today's events, KP taking NP," that would be Ken Paxton and Nate Paul, "to Moore," that would be Margaret Moore, "obtaining the referral, demanding that we investigate facially bogus charges, refusing to take our advice that there is no prosecutable offense, demanding that we hire outside counsel, overriding our advice a second time, and apparently now authorizing an improper fishing expedition by private attorneys into a civil matter."
All right, and then you have another one right after that, do you not?
I do.
Go ahead.
I then continue, "Or do we need to go further and describe the constant demands that we put the resources of the office at the service of NP's private interest," that's Nate Paul, "personally intervening in open records issues, demanding intervention in a charitable dispute over the objection of staff, demanding an informal opinion to apparently, parentheses, after the fact, benefit Nate Paul, and now finally seeking criminal investigation of federal officials involved in a criminal investigation of Nate Paul."
Keep on going.
Could you please scroll?
Down.
I then send another text. "All the while over the objection of staff, its pattern and practice evidence strongly suggestive of an improper motive."
All right, let me stop you there a second. Did you believe at this time that the Attorney General that could enter into contracts, even if all members of his staff objected? Did you have any question about that in your mind?
He is the principal, and I believe he could.
All right. What was your position as to whether either ultimately, however, there might come a time where the Attorney General, in exercising what he believed he had the legal authority to do, could do something that became illegal by being used for an improper purpose? Did you have an opinion on that?
I did.
And what was it?
Yes, the Attorney General could use the lawful powers and authorities of our office for a patently improper purpose, such as using the power of our office to benefit the interests of one individual citizen at the expense of the public interest. That is improper.
If, in fact, you reach a conclusion that that has repeatedly been done, in spite of consistent advice against it by the staff, what is your opinion where there ever comes a time that staff has to complain and say, enough is enough? You can't.
Objection to improper opinion.
All right.
I'm sorry, overruled. He has the opportunity to offer his opinion.
Yes, Judge.
Yes, and that is precisely what we did.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
What was the stated awareness of all of you that knew the consequences of what you were doing when you staked out this position and decided to go to law enforcement?
We understood the gravity of that act. We were fully cognizant of it. It was something that we did not want to do. It was something that we tried earnestly to avoid ever having happen. But when the moment came and we realized there was no other choice, that is the duty of a public employee, to ultimately make that incredibly hard choice to serve the public interest, even at the expense of your principal, because he has insisted on an improper and we believed unlawful course of conduct.
Mr. Bangert, did every single one of you pay an extreme price for what you did?
Objection to improper opinion. It invades the province of the jury with regard to an article.
Sustain. Rephrase.
Bangert, what happened with you? How did you end your employment with the Attorney General's office?
I resigned from my position immediately after the 2020 election. By the time I resigned, all of my duties had been taken from me. I was simply an employee in name only.
When you, after you went to law enforcement, how do you mean your duties were taken from you?
Over the course of several weeks, I was excluded from and ultimately removed from any responsibility by the new first assistant. And then subsequent to that, in the middle of October, I was informed that I would no longer be overseeing the special litigation unit. I objected to that, and that was to no avail.
Counselor, you said about 10 minutes were for the benefit of the jury and the staff. Do we want to break here, or do you need a
That's
few more
fine.
minutes?
I want to have a few minutes, but that's fine. That's
You
fine.
want to if you have a few minutes, finish with the witness. If you're going to go longer, then tell me and we'll break.
Thank you so much. I never want to be in the way of people taking a restroom break.
All right.
Thank you.
We will break until 11 o'clock sharp. That's a 20-minute break, members.
very well.
Okay, so wow, pretty consequential testimony here. I want to kind of recite a couple of the things he said. I went to the FBI because I believe the Attorney General, based on my experience over 8 or 9 months, that the Attorney General had abandoned his obligations to serve the citizens of Texas on behalf of one individual. And then, of course, him describing that he believed he had signed that they had all signed their professional death warrant. That's just, some amazing statements talking about how using words like harnessed and hijacked that, on behalf of one person. So I want to start with Mike, your reactions to what we've heard this morning.
This has been really effective testimony. Rusty Hardin has planned for this to land well. As a lawyer, one of the things you're trying to do is make sure that you're making your strongest points when the jury is most apt to listen. You want to finish strong, and so having a witness mid-morning, you're about to hit a break, and you know that ahead of time, and so you planned to make these really strong points, which they are, right as the jury is really focused in. So I think this has been incredibly effective, and it'll be interesting to see what the cross looks like.
Yeah, and this guy comes across as squeaky clean.
Yeah.
Well, not only that, he was visibly emotional about this testimony toward the end, particularly. This was a struggle, a personal struggle for him between his ethics and his loyalty to his boss, his principal.
And that's going to be one of the big things. We saw a preview of it yesterday from the defense, attacking disloyalty and that sort of thing. And so that they are, the prosecution side is getting in front of that disloyalty tact, disloyalty argument, and trying to say, I have a duty to the people of Texas, the state of Texas, but also I have a duty to protect Ken Paxton. And I did everything I could, and I signed my professional death warrant. That's how strongly I felt this was wrong. It was wrong for the citizens of Texas, and it was wrong for Ken Paxton himself, and I did everything I could. I think this really lands strongly.
I agree. I think that this man was struggling, and it's visible on his face. This is a man who, as we've talked about, is squeaky clean. He has a clear moral center, and that is integral to his faith, which he has already testified imbues everything he does. And to be caught on that horns of a dilemma between two loyalties, and to finally come down on the side of loyalty to the public, to the larger good, you can imagine the struggle that must have been, because he was aligned with Ken Paxton's goals, and I think clearly that's why he went to work for him. So he had to feel that betrayed by Paxton, and that has to have been incredibly painful. And I think we saw that with Mateer as well, that both of them went to work for this man because they agreed with him, and they were wanting to work with him to achieve the things Paxton said he was going to do. And then all of a sudden to see Paxton go down these unprecedented roads of using the authority, hijacking the authority of the office.
To use his words.
To benefit one man. And the astonishing thing of having a warrant served with that man's lawyer there also present had to have been jaw-dropping to the attorneys.
Because that doesn't happen.
That doesn't
No, it doesn't
happen. And that is a consistent theme through his testimony, was how outside the norm for the Attorney General's office. Right. That this was really abnormal, and it all was benefiting one man. And that's Nate Paul. I also think what's interesting about this is, just like earlier I was saying, the defense's strategy is to speak to a certain subset of the jury, of the senators. The prosecution is clearly trying to do that too. They're clearly trying to communicate these are good conservatives, these are good Republicans, They care about the state of Texas. They're not rhinos or any of that stuff. They felt strongly that this was their duty to do, and that they did that, and that's how outside of the law and the norm Paxton was.
These were the people that were trying to uphold law, the rule of law. Yeah. Something that the people in that room, the Republicans in that room, have staked their claim to.
Care deeply about.
Right. Well, and one of the things he said was he addressed that. He said in trying to explain why they decided to go to the FBI, and they were struggling to determine how did what do we do? And he said, we had stepped into the void. Mm-hmm. We had no roadmap to follow.
Let's go to Chris at the Capitol.
Oh, we're going to go to Chris.
Yeah,
okay.
Sorry.
Okay, so we're gonna do a video call with Chris Sadeghi, who's there at the Capitol.
Yes, Tanya, right here outside the Capitol, and everything you guys were just talking about as far as the powerful testimony from Mr. Bangert about how they were trying to protect Ken Paxton. That is trying to head off one of the defenses that his team has put forth so far in this trial, that these were what they would like the senators to believe, rogue employees who were trying to further their own interest, who were trying to stage a coup, who had ulterior motives. They're making sure, the House Board of Managers, Rusty Hardin, he is making sure that they testify that that was not their motivation, that in fact they made every effort to protect the Attorney General, try to get him away from Nate Paul, who they felt was a troublesome figure that they didn't want the AG office having anything to do with, and that those pleas fell on deaf ears. So right now they're not only making their case, but also trying to take any possible rebuttal or any possible assertions from the defense that these employees had other ideas, perhaps trying to further their own career interest, or as you guys were just talking about, Mike and Katie, that they are rhinos. They're having them testify to that to make sure these senators know that that is not the case, that they're including that in their questioning as to try and undercut any cross-examination that might be coming.
Chris, are you seeing much reaction from the senators in terms of how they're reacting to what they're hearing from Ryan Bangert?
Kind of hard to tell from our vantage point what their reaction is. They're in there. They have their own individual area and desk, and it looks like they're listening intently. Every now and then you might see one of them jot something down on a piece of paper, but it's kind of difficult to get a sense of whether or not they're being swayed. And it is interesting, we brought up the point yesterday, the fact that Ken Paxton is not showing up to these proceedings. Does he perhaps think that these votes are already secure, whether they're for him or against him? Certainly if there were swing votes at play, it doesn't help his cause if he's not even showing up to these proceedings at all. So that makes you wonder, perhaps he thinks that his fate is already sealed one way or another.
Yeah, it's hard to say, what his thought was. One of our legal experts we had yesterday, Matt Yarbrough, said that he thought, if you have Paxton there, the other problem is that every motion he makes, every look, every gesture, that everything will be judged. So there's also the potential downside of being there. So there's that at play as well. So who knows? It's are there many people there coming to watch these proceedings, like the actual public?
That day one, there was a lot of people. They were lined up before the sun came up. In fact, a lot of them were pro-Paxton. They were here with their red shirts. And then day 2 and day 3, there's been next to nobody waiting in line on the general public side. Still quite a few on the media side, but the gallery, for the most part, is empty. It's kind of funny. There was one college class that showed up today. They had a plan. Every semester they visit the Capitol. Just so happened that they planned this visit today, and so they're sitting in on the proceedings. But aside from them, no, the public interest, or at least the public section of the gallery, aside from that first day, has been empty.
Well, they certainly picked a historic day to come visit, or a historic time period, because I suspect we're not going to see another one of these for a long time.
I mean, you wouldn't think so. We haven't had one in over 100 years for a statewide official. So yeah, just they're getting a very unique educational experience right now.
Absolutely, a real Texas experience. Well, hey, Chris, thank you so much for jumping in with us, and we'll look forward to talking to you again later.
Great, thank you.
That's interesting. It's interesting to hear that, we're not seeing like a lot of people sitting up in the galleries, that it's mainly the press. That's kind of fascinating.
Well, and one thing is people have to go to work. Right. So
this is true.
It may be that they just can't take off to be there every day, no matter how devoted they are to Ken Paxton. So
I also think
that's real life.
Yeah. I also think that for a lot of people, their experience with trial is what they see on TV. And when you show up that first day and it is a swearing in fest and then a
motions
fest. I think that probably a lot of people thought, oh my gosh, if this is what this is going to be like, I think I'm going to take it off. But it is interesting. Talking about the senator's reactions, every lawyer, every trial lawyer tries to read the jury's minds, tries to, are they with us, are they against us, who's for us, who's against us. I have found, and I think most trial lawyers would agree, that is, while we all do it, it's a fool's errand. You just never know with people. But one thing that is interesting and that he said that I think is interesting is the level of attention. That's what you can tell. If your jurors are looking off, they look like they're nodding off, they're falling asleep, staring off into the distance, that's bad. If you're the prosecution and it's your witness that you think is landing good testimony. But the fact that they largely seem interested, attentive, they're writing things down. If I feel like my witness just made a really strong point and I see my jurors taking note, that's really all you can ask for as the lawyer making a presentation.
One thing we haven't talked about is we were somewhat critical of Patrick, Lieutenant Governor Dan Patrick's, as in his young judicial career here, and I have some sympathy for him, because this has got to be tough. I mean, he is not a lawyer, and he's coming into this, and it feels like he's finding his sea legs a little bit.
Oh, I think so, and I think he is getting more comfortable in the role. I think that the overruled mantra today, he's also getting a little irritated at the defense.
Anthony Oso. The young lawyer that's been doing all the objecting is a guy named Anthony Oso, who is an associate or a lawyer in Dan Cogdell's firm.
Right.
So Dan Cogdell, of course, has represented Ken Paxton in the the securities board, the securities indictments for a number of years. So he's been, I think, maybe involved in it the whole time, and so he's the one that's been leading that. And you can tell that Patrick is getting annoyed.
It's interesting as a trial lawyer, and especially as a defense lawyer, lodging objections during the state's presentation of their evidence is a tactic. You want to disrupt the flow, you want to break things up, you want to make it hard to understand. Just like I said, the prosecution wants this to flow and be an easy to follow factual narrative, so you want to break it up. But you have to weigh that strategy versus am I losing my judge? Am I losing my jury?
Is he losing the judge?
I think he has lost the judge. Interestingly, at the beginning of the morning, it was more sustained than overruled, and then I lost count at one point. It was 10, 15, 20 overruled in a row, and then I noted some exasperation in Dan Patrick's demeanor. Also, one thing I noticed that is never a good idea, although we get fired up, it's hard as lawyers to not do this. I saw Oso physically reacting to losing an objection. And what I mean by that is big eye rolls.
Petulance.
He was acting petulantly. And look, I'm not critiquing him. Lawyer to lawyer, you're in the midst of battle, you get frustrated, you feel like you're right on the law and the judge is wrong. I get that, but it is never a good idea to roll your eyes at the person
especially
who has the
not
authority.
Lieutenant Governor Dan Patrick.
Exactly. Who is very used to running
and
his roost.
This is his chamber,
house.
his house.
Yeah.
And let's look at the jury that is being talked to. In reality, only half of that, well, a little more than half of that room is their target. It's the Republican side of the room, because we're pretty sure the Democrats are going to hang in there solid. So those Republicans are having to look at this not only in terms of this particular case and Ken Paxton's reality, but their political reality and their political future. And it is a numbers game. We've talked about that. But the numbers that are going through their heads is the number of votes and being primaried. And what is the risk? What are the odds that because, Jonathan Stickland's out there threatening all sorts of money being loaded into.
And explain who Jonathan Strickland is.
Well, he is the head of the PAC that is defending Ken Paxton, that is being funded by the millionaires out in West Texas. And they have a lot of money. And certainly Stickland says they are willing to spend it in retaliation against any Republicans who vote against Ken Paxton. I mean, they're saying it all the time. It's not, it's a bald threat. So they're weighing a whole bunch of realities in their lives.
This is a political trial. It is what it is.
It is what it is. And their political futures are wrapped up in this. But you also have the demonstration of these two witnesses, staunch Republicans, who reached the point where, political realities aside, they had to step up and push back against Ken Paxton. And that may actually inspire some of the Republicans in the room.
I think that definitely has to be the strategy from the House managers and Rusty Hardin and Dick DeGuerin, is that basically pushing the narrative towards those Republican senators.
The rule of law.
That Dan Paxton has abandoned the rule of law.
Ken Paxton.
Dan
we keep
Paxton.
mixing poor Dan Patrick.
Poor Dan Patrick. That Paxton has abandoned the rule of law. He has violated the code of ethics that we as Republicans hold dear. He has stepped away from his core Republican values, all to to benefit his mistress, the guy who's supporting his mistress. These are things that make him no longer a good Republican, and that would make it safer for them to vote.
For either the business Republicans or the faith and values Republicans. They're hitting it on two levels here. The infidelity and then you have the whole law and order. They're going at it two-pronged to get those two wings of the Republican Party on their side. And I think they're doing a good job of it.
I think so too.
Yeah, I think that Bangert in particular is a very effective witness.
I think so too.
Very effective. Mateer was clearly much more visibly nervous.
Well, and Mateer's, he was just a little bit of a dork. and I mean that in an affectionate way. He says, I don't do tech.
I think he would probably, he'd probably acknowledge it, actually.
And I think he came across that way, which was in a way
kind of endearing.
And added to his credibility in many ways. Today, we're seeing expertise and confidence and a moral center that is so visible, it practically shines off this young man.
So so if you were on Ken Paxton's team and let's say you were Anthony Osso, how do you cross-examine Ryan Bangert?
I think you want to stick to your script. You want to stick to your script of disloyalty. You want to try to insinuate that this was a power grab.
This was a coup.
That this was a coup,
right.
A mutiny. I think you're going to hear those words ring.
Well, you heard it with Mateer.
That's right. So I think you're going to hear that
because
same
Busby
thing.
said that. Busby said this was a coup.
This was a
coup, wasn't it? And of course, Mateer responded back with absolutely not.
Right, and I think that's why you hear Rusty Hardin this morning. He actually said, "Was this a mutiny?" So I think the prosecution knows that that's the defense's best hook, and that they're trying to get in front of that.
And they want to embed certain language in the minds of those Republican witnesses.
Because that's what I expect. If I'm Oso, who I expect would be the one crossing by the normal rules of a courtroom in trial. Of course, this isn't a normal trial, but in a normal trial, the lawyer that objects has to be the lawyer who does the cross-examination. You don't get to team approach a witness.
Right.
So of course that wasn't the case yesterday. So who knows? But yeah, if it's Oso, I would definitely want to try to tone down my petulance a little bit while attacking the witness and my themes would be, disloyalty, personal advantage.
Try to
that
get a
sort of thing.
rise out of him,
That's
that kind of
right.
thing.
What will it show us if it's not Busby doing the cross?
That is interesting because, this is a junior lawyer compared to Busby.
Right.
And so as a strategic move, I could see them trying to say this is an unimportant witness. We're going to give this to our junior lawyer. Personally, I think that's not a wise play
It's a
because I
risk.
think
But
this
in a
is
normal
real
criminal case, the person doing the objecting is going to be the person doing the questioning.
Right.
Normally.
So so in a normal, if this was happening in a state district court, then you couldn't say, this guy's heard us, let's switch who we had doing the cross to Busby. It would have to be Oso.
And the only reason I asked the question is because this isn't normal.
Right.
That could indeed happen, and I just thought that would be interesting.
Yeah, I don't know. Well, yeah, and of course, I don't know if that is addressed in the rules or not. I mean, I don't know exactly.
yeah.
I don't know.
I
mean, it might
read the
not.
rules
I doubt
pretty
it.
carefully. I didn't see that specifically. There was a lot of deference to the normal rules of criminal procedure. So, my reading of that would be that it should be the same lawyer who objected doing the questioning. Being that Judge Lana Myers, the judge, or the former judge who is advising Dan Patrick, I would expect her to say that that's the norm. But yeah, I guess we'll see.
Well, I think their strategy has been to just spray fog all over the room.
Yeah.
And
which is what I would be doing.
Yeah.
As a defense lawyer,
right,
you want to make it hard to follow.
right.
All right, they're back in session. Let's. Okay, so real quick before they get started back up, let's talk about this truth of the matter thing because that's been a big thing. Explain to the folks.
Court will
that
come
way-
to order.
Oh, never mind. We'll do it afterwards. It was on my list. We'll do it next.
Court will come to order.
We'll do that the next time we have a break. Go ahead. Hope your dogs.
Mr. Harden, you can continue.
Thank you very much, Your Honor. Stella, can I have hard copy exhibits for the court and the other side on Exhibit 571? And can you give the witness one so that it doesn't have to be put up on the screen?
Is this already in evidence?
It is not. That's what I'm going to seek to introduce. Thank you, Your Honor. So now, without going into specific contents, do you recognize this exhibit?
Yes.
And without talking about the contents as to what it says, how would you identify it in terms of what it is?
This is a text message that was sent
Microphone, I'm sorry.
This is a text message that was sent by the group of us to the Attorney General.
All right. And does it also contain the Attorney General's response?
Yes.
Are you aware of people, of any instance where there's been criticism that you did not seek to meet with the Attorney General? Are you aware that there's been that criticism?
I'm aware of that, yes.
All right. Now, Your Honor, we move to introduce 571, the understanding this witness participated in sending this along with the other group of people we've been talking to as the whistleblowers.
Any objection?
No objection, Judge.
Continue.
All right, can I have it up on the
submit it to
screen,
evidence.
please? The first page, would you show who all is, would you, for the record, explain who all it says is sending this?
The beginning at the top of the
Yes.
page
Yes.
Lacey Mays, Deputy for Administration, is sending this email, which contains a screenshot, to Jeff Mateer, Blake Brickman, Ryan Vassar, Brian Bangert, myself, Mark Penley, and Darren McCarty.
All right, if you would look at this screenshot on that first page, and we turn, does this exhibit contain a screenshot of the text messages that you as a group, the addressees up at the top, sent to the Attorney General?
Yes.
And did you send it on what date, if you would look up there?
The date is not listed, but this would have been...
The screenshot is dated, is it not?
The
Can you see it?
screenshot...
Yeah, the first page.
Yes, this is the email is dated October 1st.
Right. The email has been sent around, but if you look at the second page of this exhibit, does it contain correspondence with where each of you let me back up. Strike that, and I apologize, Mary, ma'am. If you just give the jury the background of why y'all sent this and when you sent it.
Yes. We sent this message to the Attorney General after we had made a good faith report to the FBI. We wanted to speak with him. We wanted to bring him back to the office, or we wanted to invite him back to the office to speak with us so that we could address these concerns head on. We were hoping that we could finally resolve these issues and, in our view, end this unlawful use of our office's resources.
All right. Now, the screenshot was dated October 1st, and in fact, your group went to the FBI, I believe you testified, on September the 30th, correct?
That's right.
This email that Jeff Mateer sent on behalf of all of you, would you read that out loud, published to the jury, please?
The text message?
Yes.
Yes. Jeff Mateer at 12:49 p.m. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law.
Nice and slow.
I'll begin again. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law by you to an appropriate law enforcement authority concerning your relationship and activities with Nate Paul. We request that you meet with us today in the 8th floor conference room at 3:00 p.m. to discuss this matter.
Now, at that time, since when it says yesterday here, and I believe you testified that the two of you went to the FBI on the 30th, correct?
The group of us did.
Yes, and then on the 1st, you send this text. So when we see on there today, 12:49 p.m., this message from Mr. Mateer on behalf of all of you would have been sent on what day?
The following day, the 1st.
October the 1st. And at that time, did you know whether or not the Attorney General was back in Austin from his trip out of town?
Yes, my recollection is that he had returned late the previous evening.
Late the evening of the 30th?
Yes, that's my recollection.
Okay. Would you publish to the jury what he responded to you about 3 hours after you sent it?
Yes, at 3:08 p.m., Jeff, I am out of the office and received this text on very short notice. I am happy, as always, to address any issues or concerns. Please email me with those issues so that they can be fully addressed.
And so did you email him with those issues?
I don't believe we did. I don't recall. We wanted to meet with him personally.
And if you did not, why would you not have?
He was well aware.
And how did you take that, asking for the issues?
I interpreted that message as he was not going to engage with us on this.
Did he ever reach out to and try to?
No, not to me.
And as a former deputy first assistant, You remain still with the office, available to talk to him for how long?
I remained with the office until after the 2020 election in November, early November.
At any time after you sent that text, did the Attorney General ever attempt to discuss any of these issues with you?
One time.
When was that?
I had turned in my notice of resignation. I was in the process of gathering up the things in my office, and I was alone in my office, and he walked into the office unannounced and closed the door behind him and was pacing to and fro in the office. He was very agitated, in my view. And he said to me, "Ryan, I just want you to know that you're only sitting in this office today because of me."
What else did he say?
He said, "This was not Jeff Mateer who put you here, it was me."
He said what?
He said, "Jeff Mateer didn't put you in this office. It was not his decision, it was my decision. I put you here."
Okay.
And it was a very odd conversation. I wasn't quite sure how to respond, so I just told the Attorney General that it was my hope that God would work things out in the end. That was the only time that he spoke to me alone about these issues, and that was it.
What is your observation as to whether in encounters of unpleasant or difficult issues, the Attorney General's characteristic is as to how he acts in issues of conflict or whether he avoids them?
Objection to relevance.
Sustained.
After you left, could you describe for the jury the impact of all this has been on you?
Yes, that month was a very unsettling month. I was waiting to be terminated. Instead, I just had my job duties stripped from me and was left more or less a man without portfolio in the office. I watched as my fellow whistleblowers were placed under administrative leave and investigated. I watched as certain members of the staff, the new staff, treated them in a belligerent manner, including myself. And ultimately, I resigned. It was incredibly heartbreaking because I had believed in Ken Paxton and what he had been doing for years. I had moved my family here to Austin specifically to go to work for him. And I watched all of these things that we had done as a leadership team slowly begin to unravel. And it was absolutely heartbreaking to see that happen to an office that had been, in my view, a beacon for the conservative legal movement for years.
Have you noticed he's not even here today?
Objection to relevance.
That's very relevant. I want the record
Objection
to
to
reflect.
relevance.
If I could, I'll ask that question
Sustained.
again. All right. I want the record to reflect that Attorney General Paxton was not here entirely. I'm just making this for the record. I think we're entitled to point out.
I'm objecting to the attorney testifying.
Excuse me, let me finish, please.
Quit talking over each other. Court reporters cannot record. I sustained his objection.
Yes, sir, I understand. And I'm not any longer trying to ask that question. I do want the record to reflect that neither yesterday nor today has the Attorney General graced us with his appearance. That's all. I wanted to make that statement, please, for the record. I thank you very much, Your Honor. I'll pass the witness.
Judge, may I have a moment to just prepare my exhibits up on the bench or the
Yes.
podium? May I proceed, Judge?
You may proceed.
Mr. Bangert, we heard a lot about your background. Obviously, you have a very esteemed career and resume, correct?
My resume is what it is.
Okay. Mine's not like yours, and so I'm just going to try and do a courtesy to you and ask you short and simple questions, okay? And I'd ask that if I ask you a yes or no question, that you simply respond yes or no, all right?
Understand.
Okay. Now, you are currently represented by an attorney, correct?
I am.
Okay. That attorney is Johnny Sutton.
Yes.
That is the same attorney that represents Jeff Mateer, correct?
It is my understanding that he also represents Jeff Mateer.
Okay,
Yes.
So you and Jeff Mateer both have the same attorney.
We do.
Okay. As a matter of fact, Mr. Sutton is here today in the building, right?
Yes.
He's probably watching your testimony.
I assume so.
Okay. And as a matter of fact, the two of you were just in the restroom together about 15 minutes ago?
You would know that because you were there too.
I know, right? But that's a yes, correct?
That is a yes.
Okay. So you guys have been in contact during your testimony in this trial?
We have.
All right. Now, you stated on direct examination that you did not provide any statements with regard to what you've testified in court today, right?
Could you please reframe? I don't understand the question.
Sure. And I think the record reflects when Mr. Harden asked if you made any statements in this case, and when Judge clarified if you had made any statements before this testimony, you said that you hadn't.
I do not recall testifying to that effect.
Okay. So you've made statements previous to your testimony today, right?
Again, when you say statements, have I spoken to anyone?
I mean, you have made an out-of-court statement, Mr. Bangert.
Are you talking about under oath?
I'm asking you yes or no, have you made statements about this case to anyone?
You may answer the question. What's your objection?
My objection, Your Honor, is if he would just please express what he means by statements. That has a legal significance and a practical one.
Overruled.
This witness is not aware of the issue.
Overruled. Answer
Yes.
the question.
So
It's a yes or no question.
it's not a yes or no question.
Well, then
sir.
let me ask you a more specific question. Were you interviewed by the House Board of Managers in their preparation investigation of this case?
Yes, I was.
Okay. Were you interviewed by Mr. Harden and Mr. DeGuerin prior to your testimony for this case?
Prior to my testimony today?
Yes.
I was, yes.
Okay. So those are two statements that you've made to people about your testimony in this case, right?
I'm not trying to fight with you, counsel. I'm simply pointing out that the word statement carries legal significance,
Well,
typically
hearsay-
under oath.
Well, hearsay is
Those are
any
not
out of-
under oath.
Yes.
Witness,
Yes, ma'am.
answer the question. Not argue with the counsel.
You've made two interviews prior to testifying today, right?
I have given interviews, yes.
Okay. Two of them.
I have spoken both with the House Managers Council and I have spoken with Mr. Harden and Mr. DeGuerin.
Yes or no, Mr. Bangert? Were either of those interviews recorded?
No.
Did you ask that those interviews not be recorded?
No.
Did your lawyer ask that those interviews not be recorded?
Not to my recollection, no.
So you don't know why they were recorded? Why they were not recorded?
I do not.
Okay. If Mr. Harden or Mr. DeGuerin had had any objection to you being recorded during your interviews, would that have been a problem? Yes or no?
I don't understand the import of the question. Would that have been a problem for me?
My question is, if Mr. Harden or Mr. DeGuerin had said, Mr. Bangert, you're giving an interview with regard to testimony in an impeachment trial. Can we record you? Would that have been a problem for you or Mr. Sutton?
I can speak for myself. I would have no problem with that.
Okay. And despite your lack of objection to that, Mr. Harden and Mr. DeGuerin chose not to interview you during your interviews with regard to this case?
Chose not to record me.
Yes.
I assume that was their choice, but I was not recorded.
Okay. And additionally, prior to that interview, when you met with the House Board of Managers, safe to say you wouldn't have had an objection to them recording you either, correct?
I can't think of any at the time, no.
Okay. And it just so happens that the House Board of Managers, the investigators in this case, chose not to record your statement either.
As far as I know, they did not.
Okay. So you would have to agree that there are a lot of things that you testified to when Mr. Harden was directing you that we were hearing for the first time on this side of the trial, correct?
I honestly cannot answer that question. I do not know what you know and what you do not know.
Okay. Well, you had information that you produced actually to both sides of this trial within the last 2 days, correct?
There was a text chain that was produced by my counsel.
Okay. We didn't see Mr. Harden produce those text messages during his direct, did we?
Mr. Harden producing his text messages to whom?
During his direct examination of you, he did not ask you about text messages that you produced yesterday during this trial. Yes or no?
No, he did not.
Okay. Your Honor, may I approach the witness?
Yes? Don't speak to him now. Just give it to him and then speak from the microphone. Thank you, Counselor.
I'm handing you.
Hold on. Everyone wants to hear you.
I'm handing you what has been pre-marked as Attorney General's Exhibit 1000 and I believe 3, correct?
It is marked AG 1003, yes.
Okay. Now, you recognize this document, do you not?
I do.
These are text messages from your cell phone, right?
Yes.
You produced these to both sides in court yesterday.
Mr. Sutton, my attorney, produced them yesterday.
Okay. And you would agree that these are a fair and accurate...
Counselor, excuse me, we do not have a copy of
Yes,
what you
Judge.
have.
Get a copy for the court.
Continue.
Yes, Judge. You would agree that these are a fair and
Your
accurate
Honor,
reflection...
pardon me, Your Honor, we were not given a copy of those. Could we have a copy of them, please?
They gave it to us, so whatever.
Thank you.
I'd ask the record reflect that I have tendered to opposing counsel a copy of their witnesses' text messages.
Let the record reflect.
Now, Mr. Bangert, you would agree that these are a fair and accurate reflection of the text messages between you and Ken Paxton in July and August of 2020, correct?
Give me a moment. With the only modification that the first text message is in June.
Okay. Well,
It goes through
your
August.
attorney produced these, so presumably he got them from you, right?
Yes.
Okay. Otherwise, fair and accurate reflection?
Yes, they appear to be.
Judge, at this time, I would move to admit AG Exhibit 1003.
Any objection?
No objection, Your Honor.
Show the exhibit being entered into the record.
Okay.
Admitted to evidence, excuse me.
Thank you, Judge. Mr. Bangert, you talked about two very, very, very specific conversations that you had with Mr. Paxton that I think stood out during your testimony. The first one of those was a conversation at Polvo's, correct?
We did, well, Nate Paul was part of that, but
Right.
we were at Polvo's at lunch together with Mr. Paxton, Drew Wicker, and Nate Paul.
And the second conversation was essentially a conversation that you overheard Jeff Mateer was having, right?
The conversation at the Raga meeting in Atlanta, yes.
Okay. Two separate conversations.
Yes.
Did you provide, I don't recall, did you provide dates of those, specific dates of those conversations during your direct examination?
I do not believe I did.
Okay. Now, you talked a lot about your experience and your resume. I think you've clerked, you've worked at, was it Baker Botts as a partner, right?
I have both clerked and worked at Baker Botts as a partner, yes.
You've worked at executive level positions in 2 attorney general's offices?
Yes.
You didn't get there because you don't have an attention to detail, right, Mr. Bangert?
I'd like to think that I pay sufficient attention to detail.
Right, and you document things that are important to you, do you not?
Not always.
Not always? Okay. Well, let's talk about that. You had documented in this case something that you thought was very important, the foreclosure opinion, did you not?
I made a document that outlined my concerns about, oh, sorry, you said the foreclosure letter?
Yes, the foreclosure letter.
Well, I was shown the foreclosure letter today, yes.
Okay. At this time, I would ask Eric if you could publish the House Board of Managers Exhibit 119. Mr. Bangert, this is an email that you sent to Ryan Vassar on September 30th.
Counselor, excuse me, has this been entered into evidence?
My understanding is it has. If not, Judge, I'll ask to enter. It's the House Board of Managers exhibit. At this time, I would offer.
We do not object, Your Honor.
Okay. Admitted into evidence.
Thank you, Judge. Now, Mr. Bangert, this is an email that you wrote to Ryan Vassar on September 30th of 2020. True?
Yes.
September 30th of 2020 is after you had the meeting with the other executives about going to the FBI with regard to Ken Paxton. True?
This is at 9:29 a.m. that morning. We had not visited the FBI at that point.
Okay, it's the same day that you had a conversation with the other executive level AGs about going to the FBI, right?
We did on that day.
Okay, and September 29th, September 30th, that's 2 months after you ever drafted the foreclosure opinion that you talked about during your direct examination, correct?
Slightly under, but about 2 months later, yes.
Do you typically write memorandums about things that happened 2 months ago? Yes or no?
No.
Does it stand out to you, or does it seem odd to you to wait until the day that you go to the FBI or the day before you go to the FBI to write a memorandum about something that happened 2 months ago?
No.
Not odd at all?
No.
Okay. Now, to be clear, yesterday during Mr. Hardin's testimony, he at one point said, I think by the end of July, beginning of August, you had been a part of 3 issues that related to Nate Paul, right?
Well, depending upon how you count the open records issues as 1 or 2.
Okay. Well, you have the open records issue, correct?
Yes.
Your involvement in MIDI.
I was involved in MIDI as well, yes.
Okay. And then you've got your foreclosure opinion involvement.
Yes, that is correct. I was involved in all.
And as a matter of fact, a lot of those almost overlapped each other, true?
At the edges and at the margins, they did overlap.
Okay. Now, yesterday you testified to the jury that you had a boiling concern about this, correct?
I did have boiling concern about this.
Now, to be clear, House Boards 119, your email to Ryan Vassar, is the only memorandum and summary that you drafted with regard to any of your involvement with MIDI, open records request, or the foreclosure opinion. Yes or no?
I can't recall.
You can't recall. Okay. Well, we didn't see any other memorandums, have we?
I haven't seen any in the trial today.
Okay. Well, you would have produced it, so you'd know about it, wouldn't you?
I produced everything I had.
Okay. And all we got was this email.
I produced far more than this email.
Okay. Now, I want to backtrack a little bit, and we'll go back to that correspondence between you and Mr. Vassar. You talked a little bit about the time from when you guys came out to the FBI and what happened to you after, okay? I want to talk about that. Eric, would you mind pulling up Article 6 of the Articles of Impeachment? Article 6 accuses Mr. Paxton essentially of terminating or taking adverse personal action against employees for making a good faith report to law enforcement. Would you agree with that, Mr. Bangert?
It says he violated his duties of his office by terminating and taking adverse personnel action against employees of his office in violation of the state's whistleblower law.
Okay. So kind of what I just said, right?
I defer to the document.
Okay. Well, if we read from it, it talks about terminating or taking adverse personal action. So I would like to talk about what happened to you. Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
Now, I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Did Ken Paxton say you are no longer an employee of the Office of Attorney General?
He did not say that.
Okay, thank you. As a matter of fact, you resigned from the Office of Attorney General as the Deputy First Assistant Attorney General, did you not?
I did resign.
Okay, and you resigned under the title Deputy First Assistant Attorney General.
That was my title at the time I resigned.
Okay, so you were not demoted from your position as First Assistant Attorney General.
I did not lose my title.
Okay, and as a matter of fact, you were never suspended after you reported to the FBI, were you?
I was not.
Okay. You talked about Mr., I think maybe Webster, but certainly Ken Paxton stripping you of some of your responsibilities, right?
Yes.
One of those responsibilities was the fact that you were in charge of the Special Litigation Division, true?
I was.
Now that role was actually moved out from underneath you, correct?
That is correct.
And they put it in charge of the division chief that was running that division at the time, right?
My understanding was that Patrick Sweeten was put in charge of that division, yes.
So essentially Brent Webster promoted an under-level assistant attorney general? Yes or no?
I do not know if he promoted Patrick or not.
He certainly added some responsibility for Patrick, correct?
That was my impression, yes.
And that bothered you? Yes or no?
It came without explanation or warning, so yes, it was troubling to me.
It's possible that Mr. Webster just was promoting somebody that had been, I don't know, giving an exceptional performance at their job.
That was the excuse that he attempted to give me.
That's not what I asked you. I asked you if it was possible.
I don't think so.
Okay. Certainly they wouldn't take a job from Ryan Bangert, right?
That's not exactly what I said.
Okay. Sounded like it. You said that the environment, did you describe it as being hostile after you reported to the FBI?
Yes,
maybe
it was.
Toxic, right?
It was.
Affecting the ability for people to get their work done?
It was.
Okay. Now, you left and you went to work for the Alliance Defending Freedom, didn't you?
I did.
And in your time, well, that would have been 2020, true?
Say again?
When you left the Office of Attorney General and you went to Alliance Defending Freedom.
Counselor, can you raise that mic up a little bit closer
Sure.
to you? Okay.
Is that better, Judge?
That's much better for
Okay, I'm going to
all
lean
the
in here.
jurors.
Yes.
When you left the Office of Attorney General and went to Alliance Defending Freedom, that was in October, November of 2020.
November of 2020.
November of 2020. And since your time in November 2020, all the way up until, I believe, 2023, isn't it true that you have brought cases from the Alliance Defending Freedom to be co-handled with the Office of Attorney General?
We have.
Okay. And some of those cases you have worked directly with Brent Webster, have you not?
There have been some, yes.
Specifically, State of Texas versus Xavier Becerra.
I believe that's the title of the case in Lubbock, Texas.
Okay. And that was one of a few cases, true?
Yes.
And all the while that you were bringing cases from Alliance Defending Freedom back to the Office of Attorney General, Brent Webster was acting as first assistant, true?
That is my understanding,
Okay.
yes.
And Ken Paxton was acting as Attorney General.
Yes.
All right. I want to talk to you about the open records request, okay? You kind of gave us an explanation of how the process works, so I just want to rehash that out. My understanding is that if an individual makes a request to a state agency, that state agency has a certain time period to go to the Office of Attorney General and make a request for a ruling, right?
There is a statutory time period to request a ruling, yes.
Right. So in this case, the statutory time period, well, for example, when Nate Paul went to the Department of Public Services in March of 2020, if that was March 3rd, they had till March 13th essentially to request your office give an opinion, true?
I do not recall the specific dates, nor do I recall whether it was Nate Paul or one of his attorneys who made that request.
Okay. I just want to clarify, you do not recall the specific dates in which the DPS request by Nate Paul's attorney was made?
It was in the spring of 2020, but I don't recall the precise dates. I'd have to see some documents around that.
Eric, would you mind pulling up Article 3? And while we're doing that, just for a little background, Mr. Bangert, the requests by Nate Paul's attorneys for the records involved in the investigation, it was for initially the Texas State Securities Board, right?
Yes, the initial request went to SSB.
That was in 2019.
Is that a question?
Yeah, that was in 2019.
Yes, it was.
Then you've got DPS. That request was made in the spring of 2020.
That is correct.
And sometime later, arguably end of May, there was a request made for FBI's comment or brief on the DPS request that was originally filed in the spring, right?
I believe that was part of the second request.
Okay, so we're talking about 3 different records requests, correct?
I would classify it as 2 with a secondary request attached to the second.
Okay. And then you also have to throw in the request for reconsideration, right, on the Texas State Securities Board.
That was part of the first file.
So essentially, the Office of Attorney General makes 4 separate decisions about records relating to Nate Paul.
We made at least 3. I don't know if it was 4.
Okay. Well, let's go back to fall of 2019. Texas State Securities Board. At that time, was Ken Paxton the office of it? He was the AG of the Attorney General's office, right?
Yes, he was.
Now, when Nate Paul made that request through Aaron Borden, his attorney, in fall of 2019, that initial request was denied by the Office of Attorney General, was it not?
Yes, the ORD did, well, when you say denied, it sustained the request for exemptions and exceptions by the board.
Sure, meaning that the Texas State Securities Board, while Ken Paxton was AG, was not required to turn over records to Nate Paul.
That's right, the November request did not require turnover of records.
Let's move forward to 2020. You had a conversation with Justin Gordon about a request for reconsideration of the Texas State Security Board records, true?
I did.
And ultimately, you ended up having conversations with Ken Paxton about that request for reconsideration.
I did.
And ultimately, the Office of Attorney General again did not rule that the Texas State Board, the Texas State Securities Board was going to have to turn their records over to Nate Paul, did they?
We did not require them to turn their records over.
Okay. So up until, that puts us in February or March of 2020, would you agree?
We're ballpark in that area, yes.
Right, ballparking it because yesterday you stated it was right around the time COVID started.
Yes.
That's a whole nother convo we'll get into in a little bit. Okay, so Texas State Securities Board records are not given to Nate Paul. Let's move on to DPS. Now, to be clear, the ultimate decision by the Office of Attorney General with regard to the DPS records was that they refused to rule in that situation.
It was a no decision.
Okay. Now, I want to talk to you about what that means. If the Office of Attorney General refuses to rule on a records request, that means that the state agency that was requested does not have to turn their records over to the individual, right?
We did not require disclosure based on that ruling.
Okay. And so, as a result of that ruling, the Department of Public Safety did not turn their records over to Nate Paul or his attorneys, true?
That ruling did not require disclosure.
Okay. Well, you're aware that there was a writ of mandamus filed by Nate Paul's attorney for those records they were trying to get from you, correct?
You're going to have to, the writ of mandamus, I believe, occurred with respect to the initial request. I don't recall one on the second request, but it may have happened.
You would agree there was a writ of mandamus filed?
At some point, it was my understanding that a writ had been filed.
Okay, and you're not going to tell this jury when that suit was resolved, are you?
No.
For a matter of fact, it could have been pending into the winter of the next year, true?
As far as I know, and for clarity, when you say writ of mandamus, I'm assuming you're talking about federal practice.
No, I'm talking
about
writ of mandamus in the district court for the Department of Public Safety records.
You're talking about the second issue then? Okay.
Yeah.
No, yeah, there was a pending action in the district court.
Okay. So they weren't just going to Office of Attorney General to try and get these records that they were after, right?
Could you repeat one more time?
They weren't just going to the Office of Attorney General, Nate Paul and his lawyers. They were also going to the district court to try and get the records they were after, correct?
That was my understanding.
Okay. Now, DPS was not required to disclose records after this refusal to rule, right?
Our refusal to rule did not require them to disclose.
You stated that that was contrary to precedent at the Attorney General's office, true?
I did.
But you would have to admit that this specific request made by Nate Paul and his attorney Joe Larson had some unique circumstances, true?
I don't recall any unique circumstances.
Well, you worked with Justin Gordon pretty closely on this case, didn't you?
I worked with him very closely on the first file for SSB and somewhat, but less closely on the second file.
Okay. Could you kind of, so you really delegated it to Justin Gordon to handle, right?
No.
He was the man in charge of this decision, was he not?
He was the head of open records, answering to Ryan Vassar, the deputy for legal counsel at the time.
And he drafted opinions, and he drafted the opinion to refuse to rule that you edited, true?
I did edit the opinion.
Okay. Your Honor, may I approach the witness?
Yes, you may. Just don't talk on your way up or back.
Yes, Judge. I guess the point I'm getting at, Mr. Bangert, is that not every, like you said yesterday, you said that pretty much all of these requests are kind of the same. They're easy to rule on when it comes to law enforcement material, true?
They're not all easy, but we get a lot of them.
Right. You referenced the opinion, the law enforcement exception, true?
Yes, I believe that's correct.
That doesn't
When you say
necessarily...
the opinion, which one are you referring to, though? I want to make sure I'm answering accurately.
Well, the DPS opinion.
I believe that's correct. I need to see it again.
And the FBI comment.
Again, I need to see the document.
To be clear, there was an initial request for DPS records in spring of 2020, true?
That is my understanding, yes.
Okay. There was a later, you're aware that DPS did not notify the FBI about the records, true?
I don't recall that. You'd have to refresh my memory on it.
So it sounds like you don't know every little detail about the records request, do you?
No, and that's perfectly normal for a senior executive not to know every detail.
So yesterday when you said that the decision was not consistent with precedent, you didn't know every little fact about what was going on within this request, did you?
I knew enough to make that determination.
Well, you didn't know everything, did you, Mr. Bangert?
I am not omniscient, so no, I did not know everything, but I knew enough to make that determination.
And it's fair that maybe Mr. Gordon had a different opinion about what went on with regard to those records requests.
Mr. Gordon was working on that. I do not recall what his opinion was.
Okay. Are you aware that ultimately the Office of Attorney General did disclose the FBI comment?
I do not recall that.
Okay. Are you familiar with June Haddon?
June Haddon, the name is familiar. I believe she worked in the Open Records Division.
Okay. Would it surprise you to find out that she ruled that the FBI's brief on the DPS record should be disclosed to Nate Paul and his attorneys?
I'm not aware of that, but I'd have to see the ruling.
Okay. You hadn't heard her name with regard to this litigation or case today, have you?
No, not until today.
Okay. And you have no opinion as to whether Ken Paxton prodded June Haddon to turn those records over to Nate Paul, do you?
You'll have to ask the question again. It was coming fast.
There's no evidence, you don't know of any evidence, or you have no opinion that Ken Paxton told June Haddon to turn the FBI comment over.
I'm not aware of any conversation to that effect.
Okay. Safe to say that in conclusion, every single request for records from Nate Paul's lawyers, none of those resulted in him getting the records with regard to DPS and Texas State Securities Boards, right?
I'm not aware of any disclosures that were made.
Okay.
At least by our office formally.
So essentially every ruling that was made with regard to those records was the same, had the same effect as if you refused to require DPS or Texas State Securities Boards to turn those records over.
The net result was they did not have to disclose the documents.
Okay. You were involved with midi as well, right?
Yes.
Now, you talked about the fact that Ken Paxton directly ordered you to intervene into the lawsuit, true?
Yes.
Now, you would agree that if you thought something was illegal, you wouldn't want to delegate it to a lower level attorney, true?
That I don't even know how, no, that does not.
Yes or no? Would you delegate illegal activity to a lower ranking attorney?
The question doesn't make sense because I wouldn't carry out illegal activity.
Judge, I'd asked a non-responsive. I've asked him a question.
Answer the question.
Yes or no?
I would not instruct anyone to carry out illegal activity.
Right, that's why you didn't have Ryan Vassar sign that opinion in July of 2020.
I did not have him sign that opinion because I had a very bad feeling of where that was headed.
Okay. Well, let's talk about what you did in the midi case. You had no problem instructing, well, let me rephrase that. You did instruct Josh Godby to intervene into the midi case, did you not?
I did.
And when Ken Paxton asked you to file a motion to stay, you told the jury that you were opposed to filing that motion to stay, did you not?
I did.
But you turned around and you asked Joshua Godby to file a motion to stay in that case, did you not?
I don't recall that.
Okay. He filed a motion to stay, didn't he?
That is my understanding. Eventually, a motion to stay was filed.
Okay. You didn't walk up to Ken Paxton and say, Ken, I don't agree with what you're doing, and so I'm not going to do it.
I did not have that conversation with him, no.
And at no point did Ken Paxton say to you that if you do not intervene into the midi case, that you're going to be fired.
No, we never had that conversation.
You are aware that midi has been previously of interest to the Office of Attorney General, true?
You'll have to refresh my recollection.
Okay, well, when Greg Abbott was the Attorney General, you're aware that the Office of Attorney General filed suit against midi.
Yes, that did happen.
Okay, so you are aware that their background isn't necessarily squeaky clean.
I wouldn't put it that way.
Okay. You would not tell, you got no knowledge that Ken Paxton was entering into the midi litigation for the purposes of benefiting Nate Paul, would you?
Well, I disagree with that.
Okay. Do you have personal knowledge? Yes or no?
I do.
You do?
Yes.
Well, Jeff Mateer made you aware of the fact that Jeff Mateer made you aware that World Class was disgruntled and not happy with Joshua Godby's performance in the intervention in midi. True?
That was some time later, but I received an email, I was copied on an email, in which Jeff responded to current counsel for World Class, complaining about Joshua Godby.
Okay. So World Class was complaining about Joshua Godby, true?
They were.
Okay. Now, at some point, you stopped talking to Joshua Godby. I want to say that was, let me back up. You stopped talking to Justin Gordon about the open records request, true?
At some point, the issue came to a rest,
Right,
so I would have no occasion to talk to him after.
Probably when you made the final ruling not to disclose the records in the Department of Public Safety request.
When the no decision was issued, yes, that's when it would have terminated.
Now, about 1 or 2 days after that, it might have been June 2nd, you started talking to Joshua Godby about the Midi Foundation case, true?
That sounds about right, yes.
And Ryan Vassar has his hands in the open records request at that time too, true?
He was overseeing the open records division.
Because he took your position, right?
He did when I was promoted.
Okay. So Ryan Vassar is also probably aware of these different interactions with Nate Paul between the Office of Attorney General and Nate Paul, correct?
You'll have to ask him that question.
Okay, well, safe to say that he worked on the open records request with you, right?
He worked on it, yes.
And he worked on the foreclosure opinion with you, true?
He did.
Okay, so those are two different scenarios where you and him both worked on Nate Paul issues, true?
At least those two.
Okay, and it's fair to say that you and Mr. Vassar were discussing the fact that you both had been involved with Nate Paul.
At what time?
At some point when you were working on these cases.
We had discussion around those two instances. We discussed the work that we were doing.
Okay, so you would not tell our jury, the senators, that the executive level attorney generals did not know that different divisions or facets of the office were involved with or working on cases regarding Nate Paul, would you?
We began to piece together the linkages between these matters over time.
Okay. But you didn't do anything about it until September, I want to say 30th of 2020, true?
That's false.
Well, you didn't go to the FBI until September 30th of 2020?
We didn't go to the FBI.
Let's talk about that foreclosure guidance. Eric, would you mind pulling up Article 2? And to be clear, Ken Paxton is allowed to intervene into a lawsuit if he thinks it's appropriate, true?
Our office has authority to intervene.
Okay. And he's in charge of the office, is he not?
He is the elected Attorney General.
Okay. So if he wants to intervene in a lawsuit, he is allowed to do so.
He has authority to do so.
Okay. Looking at Article 2, it alleges that Mr. Paxton misused his power to issue written legal opinions under Subchapter C, Chapter 402 of the Texas Government Code. You're aware of this, right?
Yes, I see the article on my screen, yes.
Okay. Now, we actually looked at a copy of that exhibit. Eric, would you mind entering Exhibit 192, AG 192? And Judge, for the record, I believe it is an exact copy of a House Board Manager exhibit that they've already published. Would you scroll to the second page, Eric? And just to be clear, Mr. Bangert, when we talk about that very last paragraph, you actually signed this opinion, right?
Yes.
Okay. And by signing it, you would agree that you have adopted the statements within it, true?
Not necessarily.
Okay. So you just signed things at will?
No.
No? Okay. And you signed this document, right?
I did sign this document.
And the very last sentence or paragraph in that document says, it is not a formal opinion under Subchapter C of Chapter 402 of the Texas Government Code, true?
Would you scroll down to the last paragraph?
Well, you wrote the opinion and you read it a minute ago. You would agree with that.
I would like to see the document.
I think I've got a copy.
There it is.
Got it. You wrote, we trust this letter provides you with the advice you were seeking. Please note this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance.
Yes.
You wrote that, right?
I did.
That was on this letter when you issued it in 2020, right?
It was.
Okay. So the very face of the document that you signed specifically states that it is not an opinion under 402, true?
No, that's not correct.
Specifically says it's not a formal Attorney General opinion under Section 402.042 of the Texas Government Code.
It is not a formal Attorney General opinion.
Okay.
Under Section 402. It's very different.
Okay. Let's talk about formal opinions. There's a specific place on the Attorney General website for a formal opinion, is there not?
Opinions that are issued are listed on our website, yes. They were assigned KP numbers and they are accessible by the public.
They are signed KP numbers. At this time, Judge, I would move to offer AG Exhibit 6 after I provide a copy to opposing counsel.
if you have one more copy for us, we'd appreciate it.
I've got one more copy for the court.
I have no objection, John.
We'd still like to see it.
Yes, Judge.
Just so we can follow along. All right. Thank you, sir. Admit this exhibit into evidence. No objection.
And Eric, if you would publish and just stay on the first page. So up here in the top left corner, we've got opinion number KP0322. True?
Yes, it says opinion number KP0322.
Okay. And that is an opinion number that is associated with a formal opinion.
I have not seen the rest of this document, but I'm assuming that this has the form and shape of an informal opinion.
Okay. Did you state yesterday during direct examination that Ken Paxton doesn't have a hand in signing or dealing with formal opinions?
I don't believe I said that, no.
Okay. So you would agree that he does pay attention to what he signs and what he issues on his office letterhead, correct?
He is required, or, well, I should say, he has a practice of signing formal opinions himself.
Okay. And that opinion has his name on it, true?
I cannot see it, but I would be welcome to look at the signature block.
Eric, would you flip back to the signature line? Okay. You see Ken Paxton's signature on that opinion, right?
Yes.
Okay. He has to sign these formal opinions, does he not?
I believe that is the practice of the office.
Unless he's been recused, in which event Jeff Mateer would sign the formal opinions, true?
That was the practice of the office.
Now, I want to talk to you about the opinions in this case. Originally, Ryan Vassar drafted the the informal guidance letter with regard to foreclosure sales, correct?
Yes, the informal opinion that was issued on August 1st, he did draft the initial draft, yes.
Now, the way that that letter ruled was essentially that you didn't attack the 10-person restriction from the executive order, right? You just said that judicial foreclosure sales were accepted from the rule and could go on with that restriction.
I would need to see the document to refresh my recollection on the precise contours of the opinion.
Eric, would you pull up Exhibit 192? I mean, Mr. Bangert, you drafted this opinion, did you not?
Well, Mr. Vassar drafted it, and I provided edits and corrections to it.
So you're familiar with the content?
I was 3 years ago.
Okay. Well, if you take a look at it, you would agree that it ruled that foreclosure sales could still go on despite the fact that there was an executive order restricting public gatherings outside to 10 people. True?
Please go to the next page. There were very limited circumstances under which foreclosure sales could proceed, but we were subjecting those to the hard 10-person cap.
I mean, you testified with regard to the subject matter of this yesterday, didn't you?
I did.
So you would agree that you said that despite the fact that 10 people at max can gather in public, foreclosure sales can still occur, true?
That misrepresents the opinion.
Well, you said that foreclosure sales could still go on, did you not? Is that not what that opinion says?
No.
It doesn't seek to invalidate the 10-person rule, does it?
You need to go to the next page of the opinion.
Go to the next page, Eric. Thank you.
the second full paragraph on page 3 has operative language.
Elaborate on that.
Pardon me?
Tell us about that.
If a foreclosure sale is subject to and not exempted from the 10-person attendance limit imposed in Executive Order GA-28, it should not proceed if one or more willing bidders are unable to participate because of the attendance limit.
Okay. So, how are you saying that when Ken Paxton asks you to change the opinion, that it is contrary to precedent and the position of the Office of Attorney General at that time?
It made the ability to proceed with those types of sales more restrictive under the COVID limitations than our previous draft would have.
It made it more restrictive?
Yes.
Right, which means that, in a sense, it benefited people that maybe didn't have their jobs at the time and didn't have money to pay their mortgages off, true?
I do not know who this was benefiting. At least at the time I was writing it, I didn't know who it was benefiting.
Well, did you lose your job during COVID, Mr. Bangert?
Say again?
Did you lose your job during COVID?
I did not.
Did you struggle with the ability to pay a mortgage during COVID?
I did not.
You would have to agree with me that many people did lose their jobs during COVID, true?
I understand that that did happen.
Okay, and as a result of losing their jobs, many people probably couldn't afford rent and they couldn't afford their mortgage, right?
I also understand that financial institutions were suffering because of restrictions on their ability to foreclose on their loans.
Objection non-responsive.
May he please answer the question, Your Honor? Maybe let him be allowed to answer.
Is that an objection, or are you just making a comment?
It is objection.
It will overrule, but let him clearly answer the question, but answer the question directed.
Yes or no? My question was yes or no. Could that affect people and their ability to pay their mortgages and their rent?
Could what affect them?
A ruling that that COVID was in existence.
COVID was in existence at that time.
And it caused people not to have money and not to be able to afford rent and not to be able to pay their mortgages, true?
I believe the economic disruption caused by COVID had some of those effects.
Okay. And the job of the Office of Attorney General is in part to protect the public, true?
The Attorney General's office is a sacred trust and it's always to be used for the public benefit.
Right. Now,
all of the public.
Eric, could you publish Exhibit 119 again? This is your memorandum of what happened with regard to the foreclosure opinion. And you stated in Exhibit 119 that you were not certain why Ken Paxton wanted this foreclosure opinion issued. True?
There's no exhibit on my screen.
119, Eric.
May we see it, please?
I think it's been entered, Rusty.
I said, we don't have it.
Oh, I understand. Eric's pulling it up.
We don't have a copy.
It's y'all's exhibit.
Is it in evidence? I don't think it's in evidence.
It's in evidence, Judge. I've already referenced it during this examination.
He submitted it earlier. You didn't object, I believe. Oh, I believe that's the case.
If that's
yes,
the case.
No, this I
if
recognize.
that's the case for an error, but I don't think we had it marked as an evidence. Thank you very much.
Yes, sir.
You stated that you were uncertain why Ken wanted the foreclosure opinion issued. True?
He had provided me a rationale.
It's a yes or no. You said in this memorandum right here, you were uncertain.
I was uncertain.
Okay. Now, you did not include the fact that Ken Paxton was texting you all the while you were editing and drafting that report, did you?
I don't believe I mentioned text messages in this document, no.
And yesterday you told all the senators that it was contentious between you two on the phone at some points, did you not?
Oh, I don't recall saying that.
Okay. So it was calm and collected the entire time?
It was not calm and collected the entire time.
Okay. Well, you stated to them that you were objecting vehemently over the phone with Ken Paxton, true?
I did not say that.
You were objecting to Ken Paxton, were you not?
I was having conversations with him in which he was frantically telling me to make edits, corrections, and ultimately changes.
It's a yes or no question. It's a yes or no question, Mr. Bangert. You disagreed with Ken Paxton over the phone, true?
I had conversations with him about the contours of the opinion.
Okay, so you're not saying you disagreed with him then, are you?
I was trying to understand what he wanted as his subordinate.
Okay. You didn't mention text messages yesterday, did you?
I did not.
All right. Eric, if you would flip to AG 1003 for me. Now, Mr. Bangert, you stated on direct examination yesterday that, quote unquote, Ken Paxton was acting like a man with a gun to his head. Did you not?
I did say that.
Okay. Now, looking at the last set of text messages here, if you'd flip to the last page, Eric. I'm just going to read from the exhibit. Thank you again. I can't express in words how much I appreciate your work, especially over the weekend. I am grateful because I feel like hundreds of people will be protected from harm and maybe devastation. You and Ryan deserve all the credit. Thank you. I hope that your Sunday is relaxing and enjoyable with your family. He texted that to you that day, didn't he?
12:19 on Sunday. Yes.
Okay. Now, did you mention that to the House Board of Managers when you were interviewed about this case?
I don't recall if I mentioned this text message.
Did you mention these text messages in your interviews with Mr. Harden or Mr. DeGuerin when you were preparing for testimony and trial?
I don't see why I would have.
Okay. And did you include it in your memorandum to Ryan Vassar that was produced?
There's no reason why I would have.
No reason to include a text message of him showing gratitude and why he wanted to have this foreclosure opinion worded the way he did?
I don't believe this was what he actually, I don't believe that he was telling the truth.
Well, there's
here.
certainly not a text message from you in these texts objecting or saying that you disagree with Mr. Paxton, is there?
I do not agree. I do not disagree with him here.
You don't disagree with him here?
I do not state it in writing here.
Okay. And you signed the opinion that was ultimately issued in this case, true?
I did sign it.
And that opinion has no binding effect.
It is a persuasive opinion.
Persuasive at best.
Persuasive opinion.
Okay. Did you tell the FBI about these documents?
I believe they were provided to the FBI.
Okay. We just didn't get a copy of them until today?
I did not have them in my possession.
Oh, okay.
They were in the possession of my counsel who found them.
Did you delete
recently.
your texts?
No.
So you would have had them on your phone, true?
No, I did not intentionally delete my texts.
Okay.
My texts are no longer.
Your texts were deleted, yes or no?
Gentlemen, don't talk over each other.
Your texts were deleted, yes or no?
I no longer have access
It's
to
a yes
text.
or no question.
I no longer have access to texts past 1 year.
Okay. So in the year, you didn't think to take screenshots of these?
Excuse me?
You didn't think to screenshot these messages?
These were screenshotted back in 2020.
Okay. You just didn't keep a copy?
I did not.
And you're not going to sit here and tell us that you know that the foreclosure opinion ultimately affected or benefited Nate Paul, are you?
Oh, I believe it did affect and benefit him.
You have no personal knowledge of that, do you?
I have since learned that it did benefit him.
You wrote in that memorandum that you learned through the Austin Statesman, did you not?
May I see the memorandum again?
Eric, would you please pull up the memorandum? That's a newspaper, correct?
The Austin American Statesman?
Yep.
Yes.
Okay. So you got your information from a newspaper, did you not? If we're believing your memorandum.
If I could see my memorandum, I can tell you.
Oh, Eric, would you? 119, Eric. Thank you. I think it says on the following week, on August 4th, the Austin Business Journal, I stand corrected. The Austin Business Journal reported that World Class had placed several properties into bankruptcy.
So it did.
Are you aware of when the foreclosure was supposed to take place?
I was not aware of any foreclosures of Nate Paul properties when I was writing the opinion.
No, I'm talking about after. I'm talking about August 3rd and August 4th. Were you aware?
I subsequently learned that that was taking place.
That the foreclosure was supposed to take place on August 4th.
That I don't know for sure, but it would have been the statutorily appointed date, whatever that was, in 2020. And yes, now that I'm looking at my document, I do say August 4th, so that would have been the date.
Okay. May I approach the witness, Judge? Just to hand him
Yes,
the
you may.
document. And Judge, at this time, I would offer AG Exhibit 295.
Any objection?
May I have just a second? I'm
Sure.
sorry, Judge. Thank you. No objection?
We'll enter, what was the number on that? I don't have a number on that.
295, Judge.
Enter 295 into evidence.
Eric, would you mind publishing AG 295? That is a letter from Sheena Paul to the judge regarding the the foreclosure proceeding occurring the next day, dated August 3rd of 2020, correct?
This is executed by Brian Elliott.
Attorney for World Class, right?
I assume so because it has World Class's one of their property names at the top of the letterhead.
You would agree that this document has the letterhead of August 3rd, right?
It is dated August 3rd.
Now, you were not present in the district court when this document was filed, were you?
No.
So you have no idea what impact it had on the district court judge in that proceeding, do you?
I have not talked or spoken with Judge Campbell about this, no.
Now, the very next day, the day that the foreclosures are supposed to occur, you find out that a bunch of Nate Paul World Class properties are put into bankruptcy, right?
That's what the Business Journal reported.
Okay. You've been in civil practice for quite a long time, true?
Over a decade at that point.
You are very, very aware of what happens to properties when you file bankruptcy, are you not?
I was not a bankruptcy practitioner.
Well, you're aware that when you put a document, you file bankruptcy on something, it causes a motion to stay, does it not?
There's an automatic stay that's applied based on my recollection.
There you go, which would prevent any type of foreclosure sale, would it not?
Again, I am not a certified bankruptcy practitioner. I know that there are exceptions to that. I can't even begin to speak to the legalities of these properties or how those would have applied in these cases.
Well, you knew a lot of law, on direct examination with Mr. Harden, and now you don't know about bankruptcy proceedings?
Mr. Harden did not ask me about bankruptcy proceedings.
You had no problem putting in your memorandum that the properties went into bankruptcy.
The properties were going into bankruptcy, that's correct.
Okay.
They were going to foreclosure.
It's possible that the bankruptcy filings did not, or those are what prevented the foreclosures, true?
I don't know.
Okay, well.
But I think it's interesting that World Class submitted a copy of our
Objection to non-responsive.
Opinion.
Objection to non-responsive. May I approach the witness, Judge?
Yes, you may.
I would like to offer AG exhibits that I've handed to both opposing counsel as well as Your Honor. I believe it's 262, 265, 275, and 283.
Hold on, slow down. 283, 275, 265, 262?
Yes.
I can shorten this a little bit. If he represents that these are their exhibit numbers that were originally agreed to, that we said we would not object to any of your exhibits.
Okay.
If they're covered by that objection, if they're covered by that agreement, then we have no objection.
Are they covered?
They are covered, Judge. Well, take that back. No, they're not. That's why I intend to offer right now. We have not previously agreed to these.
I understand. Just give me a couple more minutes then. I don't care. No objection, Your Honor.
Can you just clarify for the record, we have one with a number and what the other numbers are? You may have the copies back.
So for purposes of the record, we're offering 262, 283, 275. I only gave you, and then also 269.
No objection. 269 was a new number from the one you repeated back to me.
Yep.
Just want to be clear.
269, 275, 283, and 262.
I think I said 265. You repeated what I said. I was incorrect. It's 269.
Okay.
There's been no objection? I believe they said no objection. Mr. Hardin, you said no objection, correct? Yeah.
Sorry, Judge.
Please enter those documents into the record.
Just gonna okay. Thank you.
Into evidence, excuse me.
May I approach the witness, Judge?
Yes, you may.
There's got to be something.
These are all bankruptcy filings by Nate Paul and his attorneys made on August 4th and August 5th, okay?
Say so.
All right. Now, if these bankruptcy filings were filed on August 4th, the date that the foreclosures were supposed to occur, that would stay the foreclosure sale, would it not?
I don't know.
You don't know.
Perhaps.
So it's possible that Ken's issuance of the informal guidance letter didn't cause the foreclosure sales to go away. It's possible.
I do not know what effect that letter had
Okay.
on the foreclosure sales.
Are you a Trump fan?
I'm sorry?
Are you a fan of Donald Trump?
I voted for President Trump.
Okay. You're a staunch conservative, are you not?
I am.
Are you aware that only a week after you guys issued this opinion, he issued an executive order that basically mimicked the attitude towards foreclosure sales?
I'm not familiar with that executive order.
Okay. And so that brings us into the fall of 2020, right? August, September?
September is the beginning of fall.
Okay. And you didn't really have any contact with issues regarding Nate Paul from August of 2020 up until September 28th, right?
Oh, I disagree with that.
Well, you weren't working on the
The
foreclosure
witness,
opinion.
please speak up when you're...
Yes, I disagree with that.
You were not working on the foreclosure opinion.
That was completed on August 1st.
Okay. You weren't working on MIDI.
Mr. McCarty had assumed responsibility for that.
You were not working on MIDI.
I was not working on MIDI at that time in August.
And you were not working on the open records request, true?
Those were finished.
Okay. So you were not personally working on any matters that involved Nate Paul at that time?
I was actively speaking with other members of the executive team about what was happening at that time, which was the desire to hire outside counsel.
So everybody, I assume, is on the 8th floor at this time, right?
We had COVID orders were still in place. I don't recall who was there every day. I was there every day the office was open.
And let's talk about that, because OAG's position at that time was that everything should open up, was it not?
We wanted everything to be as open as possible, consistent with public safety and the governor's orders.
Even after you left the Office of Attorney General, your employees at the Office of Attorney General weren't even present.
There were some who were not present.
There were some? There were most of them that were not present.
My recollection was there were periods of time where large majorities of them were not working from the office.
Periods of time that postdated your employment at the Office of Attorney General.
I cannot speak to that.
Because you weren't there.
Because I was not there.
So that's not really inconsistent with the situation that was going on at the Office of Attorney General, was it? Yes or no?
That the attorneys were not present?
Yes or no?
Oh, that had nothing to do with our policy.
Okay.
Nothing.
So you were not personally a part of the hiring of Kamek, were you?
No.
You found this out on September 29th of 2020.
That he had been retained by the Attorney General directly?
No, that he was filing subpoenas with Michael Wynn.
Yes, I learned about that on the 29th.
And you're saying that that is the very point that it kind of stood out to you all what was going on, right? That was the tipping point.
That crystallized a number of things.
Okay. Now, when you say it crystallized a number of things, you did not have all the facts with regard to that investigation, did you?
I personally did not.
Okay. You didn't investigate that case, did you?
Was I... What do you mean by I wasn't investigating that case?
You didn't investigate the referral that was given by the Travis County District Attorney's Office, did you?
I was not the primary responsibility for that.
Everything that you took with regard to that investigation came from Mr. Penley or Mr. Maxwell?
No.
Those were the people responsible for investigating it, were they not?
They were responsible.
Okay. You were not responsible.
That was not part of my responsibility at that time.
Okay, so you weren't responsible. Now, despite that fact, you went to the FBI on September 30th, correct?
I did go to the FBI on September 30th, yes.
You went to the FBI without talking to Ken Paxton first, true?
Oh, I talked to him many times prior to that.
You didn't talk to him about the fact that you were going to go to the FBI, did you?
We did not talk to him. We did not tell him we were going to the FBI immediately prior to going.
Right. So when you and Mr. Harden were talking about the conversations you had with Ken Paxton about the fact that you wanted to talk to him, that was all after you had already gone and reported your boss to law enforcement, true?
The text messages that we reviewed today were sent after we made our good faith report.
Okay. So you did not take the time to hear his side of things out before you went to law enforcement?
I disagree.
And at that point, you took it upon yourself to send a letter to Brandon Kamek as well, did you not?
If I can recall correctly, I was the one who did send the email containing Jeff's letter. Again, I'm stretching my memory, but I think I was the one who sent it.
Okay. Now, prior to doing that, you talked earlier about a set of text messages. I would ask to admit, to publish House Board Managers 225. Eric, would you? It's been admitted, Judge.
And Counsel, we're going to be going to the lunch break. I've gone a little longer, a few more minutes. Do you want to break now, or do you want to continue for a few more minutes?
I'm fine right now, Judge.
Is good for you now?
Yep.
Okay, we'll break for lunch now.
Your Honor, I apologize. Can I raise one issue? I apologize, Your Honor. Can I raise one issue before we break for lunch?
Yes.
That may just help speed things along with this witness. You admonished Mr. Harden at the beginning of the day that if there were any statements that Mr. Bangert had provided that we haven't seen, that he was to turn them over to us. The witness has testified that there were actually 2 interviews that he gave to the House. We still don't have any information related to those. To the extent that there's work product mixed with that, I think they can redact that and provide us the statements. But I just request that we get those over the lunch break, and that may allow us to not have to recall the witness later.
Just continue to look during lunch break for those documents if you have those.
Thank you very much.
And if you do, turn those over by the end of lunch.
Certainly. We do not have, but I'll continue to be sure.
Okay.
Thank you.
We will return at 1:10.
I don't either, because this is our whole theory. I think.
Okay, so Mike, you're the trial guy. How effective was this cross?
I don't think very effective. One of the big rules of cross-examination is that you want to develop and maintain control over the witness. There are a lot of ways to do that. Short questions, maintaining pace, question, answer, question, answer.
Making them do yes, no, yes, no, yes, no.
Right. Asking short one-fact questions that give you no wiggle room. You have to say yes or no. And I basically, it's almost like I'm testifying, and all the witness is doing is yes, yes, yes. That is one method, but probably the most effective method to develop control and essentially testify. That is the opposite of what Mr. Oso is doing. He's asking kind of free-form questions that are very long. He's giving Mr. Bangert, the witness, a lot of room to wiggle.
And you're not going to shake this guy.
No, this guy.
No.
I mean, look, you're talking to
He's immovable.
Another lawyer who is obviously very smart and knows how to not let himself get backed into a corner. And so, for instance, we saw repeatedly, Mr. Oso asks about a document. Can I see that document? I'm not going to offer an opinion on
And
something
then
I haven't
would read
seen.
it.
And then
Slowing things
he's
down.
taking time, right? So he's reading the document. I don't think this witness is actively trying to sabotage, the other side. I wouldn't expect that, but he's not going to let you get him to say something that he's not sure about.
And he's going to slow it down
Yeah.
and think about that answer in his head.
Absolutely. He has had control of the pace
Yeah.
of this cross-examination from his first answer. And the guy goes, true or false? Is that true? And he won't
give it.
say true. He won't say false.
And
He will give his own reply in his own words.
as a witness, sometimes that can come across as petulant. But Bangert has done a very good job of not giving him yes, no, without seeming like he's doing that intentionally.
He's
Right.
not being antagonistic.
Right.
With
He's
the
not
lawyer
splitting
at
hairs
all.
over silly things.
He's thinking through his answers.
Right. And he's giving very particular answers. Even when it's a yes, he will say, as I recall it, yes, that's true. Even doing that, you are just getting the lawyer used to, I'm not going to give you yes and no.
I'm going to give very precise, very perfectly calibrated answers. And that's what he's doing.
Yeah, and pretty quickly, Oso tried to, the very first thing he did is, I'm going to ask you yes or no questions, and I expect you to answer yes and no. That told me as a trial lawyer, okay, he's going to really try hard to maintain control, and when the witness steps off and shows that you're not in control, the idea is you punish the witness for that. You make him look bad. And he immediately gave up on that and never punished the witness for it.
Right.
And then the witness just kept doing it over. And
It seems like, and Katie, I don't know if you agree with this, it seems like it's kind of the no harm, no foul cross. And there's this idea that, the no opinion on the open record situation and the foreclosure order, it wasn't really an informal opinion. So no harm, no foul, no harm was done.
Well, they went down that road for a while, and then they started going down the road. But what about all these poor people who lost their jobs and
Kind of a
couldn't pay
populist thing.
It went down to the populist route then. So he's scatter shooting. It seems like his approach, and that doesn't strengthen him, because he'll go down a road and then drop that,
Right.
and then come back to something and try another line of attack. Now, if I heard right, I think for the first time, Trump's name was dropped into this
Right.
trial.
He asked him if he was a Trump supporter, and then he
which,
said yes.
Yeah, I'm a little surprised it's taken this long.
and again, I talk about kind of the rules. First rule of cross. And anybody goes to law school will tell you the first thing they tell you about asking a question is don't ever ask the question you don't know the answer to.
Exactly.
And so here's the thing, unless they've researched his voting record, why ask that question? Because then you get to say as the witness, I'm not a rhino. I voted for Trump. I'm bona fide right wing.
I'm one of you.
Yeah, exactly. And then that basically signals, you as the defense have allowed the witness to signal to all of the Trump supporting Republicans in the Senate that are
I'm
your
with you.
jurors, right, that I'm with you. The defendant has violated our trust. I'm not some
Our
outside
values,
liberal.
Right.
Right.
Yeah.
I thought
Right.
one spot where I was kind of surprised that he didn't keep going down the road was when because I thought it could have been effective, was he asked him, well, your group, Alliance Defending Freedom, y'all taking cases to the AG's office, and it felt like I was waiting for the follow-up to say, well, if Ken Paxton's so corrupt, why are you taking cases to him? I was surprised that he didn't.
And he just dropped that.
Yeah.
It was surprised. Yeah, I was waiting for that kind of the 1-2 punch, and it didn't happen.
Yeah, it's possible that he's planted the seed and he's going to water it later, coming back to that with other
Maybe.
witnesses or coming back to that
Yeah.
in closing argument. That's a possible strategy. Personally, I think if you're going to plant a seed, it can't be hidden.
You want to bloom it.
Right.
You want it to
Yeah,
bloom. You want it to
right.
to grow and become a flower.
Because otherwise, what you risk is the jury, says, I don't remember that. It becomes some obscure thing someone said days and days ago that you want me as the jury to remember. I don't know. It's possible. I think that would be a good
and the other thing
argument.
you risk letting Trump into the room is all of Trump's legal baggage walking into the room too, which could affect Paxton. I mean, the indictments related to anything on January 6th, Paxton was there too, speaking. That's a little bit risky because Paxton has worked hard to tie himself very closely to Trump. Has filed suits challenging the 2020 election in 5 other states besides Texas. I mean, he is deeply linked to Trump, and Trump is having a few issues these days.
As his defense, I wouldn't be so worried about that because public opinion of Trump is one thing.
Well, and
what
it's
matters is
supportive.
the jury,
Right.
right? And if I'm
Well,
the
that's
defense,
true.
I don't care about the Democrats. I know they're against me. I just
That
I
is
I
their
assume.
core
Yeah.
audience.
I'm
Right.
trying this to hardcore Republicans that are very MAGA, very Trump, and so frankly, I think I don't object to, and I would do the same thing if I was them, trying to tie Paxton to Trump, legal trouble, notwithstanding.
And
if
But-
you had been doing that cross,
Yeah.
you'd have been doing the yes, no. You'd be
Yes,
trying
absolutely.
to
But they
lock
also
him
then
in.
tied that witness to Trump.
Right. That's what I would not have let. I would have made this Paxton is a Trump guy, and I wouldn't even give them a chance to side
Because
with
they're
Trump.
traitors and
Right, because they're
Because
traitors,
these guys,
rhinos,
they
all
were
that.
trying to have
as
a
the
coup.
defense, you'd want to set this narrative that this was a mutiny.
Yep.
This was a bunch of unelected
Attempted coup,
bureaucrats
right.
trying to, they didn't like what their boss was doing, so therefore they decided they were going to do a coup, basically.
Yeah, because ultimately you got to remember the Senate is full of people who served in the Senate with Paxton. He is one of them, and the Senate is
Some of them served in the House with Paxton.
right, and they are. This is a more conservative body in Texas than the House, and so I would definitely be tying him to Trump. But yeah, I think that was just sloppy. Maybe he felt it in the moment. Oh gosh, I can't believe I let him do that. I gave the witness the opening, because once the prosecution gets to tie their witnesses to we're good Trump God-fearing Americans, that's a bad look for
Because
the
it's hard to
defense.
say he's a rhino when that's what's happening. And one of the things, comments I saw, somebody was asking, one of the questions somebody asked, did the prosecutors out-strategize the defense by the order of the witnesses? And I think what they meant by that question was your first 2 witnesses, Jeff Mateer, and Ryan Bangert.
Right.
Neither of them participate in the lawsuit. And then Bangert also, furthermore, can say, I was stripped of my job duties, I resigned, I felt like I signed my death warrant. Thoughts on that?
Yeah, absolutely. I think that's really smart strategy. One, you want to start strong, and I think they've done that with good, compelling witnesses. But also, you take away the ability of the defense to say, these people are suing, these people are,
Right.
they have a vendetta, they stand to gain from this.
Right. They're going to get some money. They're getting that part of that.
Part
They're
of
getting that
money.
part of the $3 million that
Right.
they wanted the
Right.
taxpayers to pay.
Yeah.
Right.
And then,
Yeah.
with Bangert, you get somebody who, again, we talk about bona fide conservative credentials, he goes to the Alliance Defending Freedom. I mean, it's not like he jumped ship and now he's a Democrat.
Well,
or
and
he's,
Mateer went to the Liberty Legal Institute.
Right.
Again, we are not.
These are very,
They
very
went from a
solidly
conservative place to,
conservative.
you could make the argument these are much more deeply conservative
Yeah.
organizations that they
Right.
went
Yeah.
to, both of them.
And
Again,
I
kind of like the
guarantee-
right of the right, like
Right.
And I think
guarantee
even
Rusty
Mateer
Hardin-
described himself that way.
Yeah,
Yeah.
I mean, he's a very, very, very conservative guy, and so is Bangert. I mean, these are very. It's hard to
back
see how
your
you can even
original
make the
point,
claim.
They did
Yeah.
put up their strongest.
Right.
Their one. I mean,
Yeah, back
there's
to the
no
question,
way
that's
they
right.
have no weak spots really for them to go after.
That's right.
And they've set the tone now for the other witnesses that do come up.
One thing I want to bring up before we go eat lunch is that we have something we didn't get to talk about right before, which we were the issue of the offered for the matter. Can you kind of walk us through that, because that was the whole thing that was kind of arising there with.
Yeah. So hearsay is one of those things that regular folks who don't practice law have an idea of what hearsay means. But hearsay in a courtroom is a very particular thing. And so hearsay is an out-of-court statement that is offered for the truth of the matter asserted, which is frankly, a very lawyerly way of saying, this is a statement, and I want the jury to hear it because I want the jury to believe the statement. Okay, that's hearsay. Not all out-of-court statements are hearsay. Me saying Tanya told me yesterday doesn't necessarily make it hearsay, unless my argument is, and I want you to believe what Tanya said.
Right.
When
And you should believe what I said.
Okay, well that's hearsay.
There we go.
So, objection sustained. So when we heard Rusty Hardin say, well, wait a minute, I'm not offering it for the truth of the matter asserted. Frankly, I had been sitting here saying, I don't know why they're not making that argument, because a lot of the statements weren't, and I want you to believe what these people were saying. It's for the effect on the listener. That's one of the exceptions to hearsay. It's for to show the state of mind of the person making the statement.
Right.
I could be.
And that was a specific question that was asked
That's
at
right.
one point. What was the state of mind?
Right. And so Dan Patrick, I think, correctly ruled there, regardless of, how you see this case, talking about just purely the law. If I'm saying, I want to introduce a statement that Joe told me it rained yesterday, right? That doesn't necessarily make it hearsay. Now, if I'm trying to say, and therefore you should believe it rained yesterday, that's hearsay. But if I'm trying to show that Joe is clearly crazy, because we all know it didn't rain yesterday, or that Joe has a, whatever, then that's not hearsay. And so that's what was going on there, and I understand that. That's something that even, frankly, a lot of lawyers struggle with that aren't in the courtroom practicing trial law.
So after lunch, you think they cut bait with this guy, or do they keep going?
I would.
Well, he says he's going to keep going, but
Yeah.
you saw that Busby's in the room. He's there now.
Yeah.
He wasn't earlier.
But they can't switch horses, right?
They can't switch horses, I don't think. I think you're right.
Assuming the
Well, about
standard
the
rules
rules.
of trial.
Well,
yeah.
that's true. We're not
Right.
We're not
in
dealing
Kansas.
with it.
We're not in Kansas anymore. Who knows what
Right.
they're going to allow? Although I think, again, Judge Lana Myers, who's advising Dan Patrick, I would be shocked if she advised him that was a good idea. But yeah, if I was the defense, I would say, look, we've made. We planted the seed, here. We made an argument there. We're not really landing any good body blows here. Let's just
cut
get
our
out.
losses.
Right, yeah. Because the concern is jurors, whether they're senators or everyday citizens, are regular people. If you bore them, if they think, why are we talking about this nonsense, they're going to stop listening.
Right.
And you are teaching them that I'm going to go on about nothing, and you can just disregard. And then the risk is you land a really important point later and no one's listening.
Right.
And so that's why
They've all zoned out. Yeah.
Unless, maybe he has a real zinger left and he's going to come out and hit his home run, and then, but unless he has that, I would, if I was Busby,
And I don't
I'd
see
tell
that
him.
happening with this witness.
Bangert seems like the kind of guy who is very methodical, very careful. It's kind of hard for me to believe you're going to have a zinger with this guy.
Yeah. He has demonstrated over and over that he's not going to let you back him into a corner, that he's going to be very careful with his answers. Unless you just have something that's unimpeachable, point
Right.
to make, I don't
No
think you're
pun
going to get it.
intended.
Yeah.
Absolutely. Okay, folks, we're going to take a lunch break. We will try, depending on how quickly we can eat, to come back at 1 o'clock or maybe 1:05 and try to get started a little bit before they get back in session. But we'll be back, and please keep watching.
A little bit on scheduling. We will go 6:30 to 7 this evening, depending on where the right break is. Tomorrow, I had planned to adjourn at 5, but a number of members said traffic, if you leave at 6, you don't gain any more traffic leaving an hour earlier, so we'll go to 6 tomorrow. And I've had a request to extend lunch to 60 minutes for the court, so people have more time, so we'll start that tomorrow. So today, 6:30 to 7, tomorrow to about 6, and then an extra 20 minutes for lunch. So we are ready to resume.
Ready.
Counselor, could you come forward for one moment? Bailiff will bring in the witness. You may begin.
I'd like to approach the court and opposing counsel with just a piece of law, Your Honor. Statute.
Can I have an exhibit number again, please?
It's not an exhibit. I don't intend to offer it as an exhibit. It's just a statute. I'd be happy to if you'd like me to.
I'm not sure I'm going to object, but can I understand what the purpose? I mean, you're going to ask the witness about it, or?
I do intend to ask the witness about the law on non-judicial foreclosures.
Are you perhaps having it here for him to refer to in case he doesn't know it?
I have a copy in case he's going
Counselor,
to.
if you can address the court.
Sure.
Both of you can address the court.
I'd be yes, Rusty, and I'd be happy to offer it as AG 1005.
If it's not being introduced to evidence, I don't have any objection to what we're doing, I don't think. I just don't know what a statute, if the court has it, I don't know whether the court has it.
Okay, we do have it. I thought I heard you just say if it's not being offered as evidence, you have no objection.
That's correct. That's correct.
Okay. So?
At this time, I don't intend to offer it into evidence. Mr. Bangert, are you
We're on the same
aware?
page?
Yeah.
Okay.
All right. So did you just say now that you are offering it?
No,
You're not offering it.
I wasn't offering it at this time.
Thank you.
I might change my mind here in a second. We'll see.
All right. Fair enough.
Mr. Bangert, you are somewhat familiar with non-judicial foreclosure law, correct?
Did you ask, am I familiar with non-judicial foreclosure law?
Yes, I asked you if you were familiar with non-judicial foreclosure law.
It's been a while.
Okay. Well, you did write a memorandum about it and issue an informal legal opinion on the matter, correct?
If you're referring to the August 1st letter, I did assist Mr. Vassar in putting that together.
Okay. And in doing so, you probably had to research the law on non-judicial foreclosure opinions, true?
Not necessarily.
Okay. You're aware of when non-judicial foreclosures take place, correct?
Based on the document that I prepared, I believe it was the first Monday or Tuesday of every month, but that's my recollection.
Okay. If we said it was Tuesday, would you agree with that?
I would have no reason to disagree.
Okay. Now, the fact that that occurs every single Tuesday, that singular Tuesday of every month, that's a reason that Ken Paxton could have said, Mr. Bangert, we need to get these done this weekend. True?
Yes, that could have been a reason.
Okay. And to be fair, Nate Paul is not the only person that had properties that were subject to potential foreclosures on that date, was he?
I don't know for a fact, but it seems reasonable to assume there would be other properties that would have been subject to foreclosure.
Okay. Potential homeowners, correct?
Again, I don't know of any particulars, but it's entirely possible.
So it's safe to say that it could have been someone that didn't have a job and didn't have money to pay their home loan, correct?
I have no reason to agree or disagree with that. I don't know.
Okay. After that informal guidance was issued, and to be clear, Eric, would you mind pulling up House Boards 119? That was not issued like a legal opinion was normally issued, correct?
Are you referring to?
No, I'm asking you personally.
Which
that was
document?
not issued like a formal legal opinion, correct?
It did not go through the formal process.
It was really
To the witness, excuse me, if you can just answer yes or no when you can. Okay.
It was just a news post, right?
Which document are you referring to?
I'm referring to the informal guidance regarding the non-judicial foreclosure sales that you signed instead of Ryan Vassar.
No.
It was a post on the website, right?
I believe it was made available to the public via our website.
Okay. And if we look at House Board 119, you state, we compromised by urging that, we agreed to compromise by placing a short, noteworthy post on the website, correct?
Yes, I wrote those words.
Okay. Now, after that noteworthy post was issued, we're in August of 2020, true?
We are in August of 2020, and I do think I need to correct the record on something
just
that
a
you
yes or
asked
no
me.
question. Was it August of 2020?
We are in August.
Okay. You had no knowledge about anything to do with the renovations with regard to Ken Paxton's house at that time, did you?
The knowledge I had would have been through conversations with Mr. Mateer via Mr. Wicker.
You have no personal knowledge of that, do you?
I did not discuss that with Mr. Paxton, nor was I at his house.
You do not know who paid for the renovations to the Paxton's house?
At that time, I was unaware of who was paying for the renovations.
You don't know. You haven't seen any documents, have you?
I have seen documents that include testimony from individuals who have described.
It's a yes or no question.
I have seen
Have you seen documents that specifically show and prove who paid for those? Have you seen receipts?
I have seen documents strongly suggestive of who paid for that.
Okay. When did you first send your application for the Alliance Defending Freedom?
It would have been sometime in October.
Okay. Was it prior to leaving the Attorney General's office?
Yes, I was in conversation with ADF prior to leaving the Attorney General's office.
Okay. So when you said earlier that what you did with regard to reporting Ken to the FBI, going to the FBI being a death warrant for you, it did not affect your ability to get another job, did it?
It ended my ability to be employed by the Attorney General's office.
Well, no, because you resigned. You didn't get terminated, true?
I was constructively terminated.
Okay. You submitted a letter of resignation, did you not?
I did.
And then you went to work for a company or a firm that you had already applied for, true?
I did.
All right. In the end of the day, you would have to agree that Mr. Paxton makes the final call on what opinions are issued by the Office of Attorney General, true?
I wouldn't put it quite that way.
Well, he has to sign the document, doesn't he?
Mr. Paxton has authority to make the final signature on the document.
So in the context of a senator perhaps, if there's a piece of legislation that they don't like, or let me rephrase that, if there's a piece of legislation that one of their staff members does not like, and they want it to go through, the senator overrules his staff member, true?
I do not know how the senators make their decisions. I can only assume that senators, much like statewide elected officials, have ultimate authority in their offices.
Have you had any conversations with any statewide officials or legislatures regarding this case?
Nothing specific.
Nothing specific. Is there any record of that, of what you actually said?
No.
So it's kind of like your conversations with Mr. Hardin and the House Board of Managers?
No.
May I approach you, Your Honor? At this time, Judge, I would offer Attorney General's Exhibit 1004.
No objection. It will be admitted into evidence.
May I approach the witness, Judge?
Yes, you may.
Mr. Bangert, I've highlighted in orange on this document. I'm going to hand it to you. I'm going to ask you to read it, okay? The highlighted portion, okay? I want you to read it aloud, Mr. Bangert.
The highlighted portion.
One moment. Does Eric have it?
Eric does not have it, Judge. This is more of a rebuttal exhibit, if you will. So, Mr. Bangert, if you could read it aloud so that our jurors could hear the highlighted portion.
Pardon me, Your Honor. May I approach him and ask him to highlight the portion that he's highlighted for the witness so I know what he's talking about? I just want to highlight on my copy. Thank you. Thank you.
I'm going to ask you to read the highlighted portion now. Aloud, Mr. Bangert.
The highlighted portion states, accordingly, my administration, to the extent reasonably necessary to prevent the further spread of COVID-19, will take all lawful measures to prevent residential evictions and foreclosures resulting from financial hardship caused by COVID-19.
That is an executive order issued by the Trump administration, Mr. Bangert. Were you aware of this executive order when you filed or sent Mr. Vassar that email on September 30th of 2020?
Look at the date of the order. It's August 8th. I don't recall if I was aware of this order, but it was irrelevant.
It was irrelevant?
Yes.
Okay. It was a week after you just issued an opinion with regard to foreclosure sales, was it not?
It was 1 week after the August 1st opinion.
Okay. But it's your opinion that it's not relevant to your summary of what happened on that foreclosure opinion you drafted?
Completely irrelevant.
Okay. I'll take that back from you. May I have a brief moment, Judge?
Point of inquiry, please, Your Honor. I'm looking at the record as it was. Maybe counsel wants to have an opportunity to correct it. I think he referred to the order in a question. That is an executive order issued by the Trump administration, Mr. Bangert. I suspect he meant to say the Abbott administration, but I just want to make sure the record is correct. I don't know which he meant.
No, it's a federal order. I meant the Trump administration.
Pardon me?
It's a federal order. I meant the Trump administration.
Thank you. Okay.
I want to talk to you more about your representation by Johnny Sutton, Mr. Bangert. Was it after you ended your employment at the Office of Attorney General that you hired Mr. Sutton?
I began working with him prior.
You began working for him prior?
I began working with Mr. Sutton prior to ending my employment, yes.
Okay. You searched for Mr. Sutton on September 22nd of 2020, did you not?
He was recommended to me.
Okay.
I can't recall searching for him on September 22nd.
Okay.
Thank you.
This time, Your Honor, I would offer Attorney General Exhibit 312.
Any objection?
No objection?
It is admitted into evidence.
Okay. Mr. Bangert, this is a download of your computer, and I'm going to approach you with it. I'm going to have you look at it and refresh your recollection. I didn't realize Eric had. Eric, you got it published, don't you? Okay, thank you. We see here on September 22nd of 2020 that you actually searched Johnny Sutton's law firm.
That's what the document represents, that I searched for the ashcroftlawfirm.com.
And that is where Johnny Sutton is employed, true?
He's one of the named partners there.
Okay. That is 8 days before you decide that you're going to go to the FBI and report Ken Paxton.
We went to the FBI 8 days later. Yes, that's correct.
So you were searching for an attorney before you even knew that Brandon Kamick was issuing subpoenas at those banks.
Oh, no, I don't believe this had anything to do with looking for Mr. Sutton to retain him.
Oh, it's just a coincidence? Yes or no?
It probably is, yes. There's no reason. We were not searching for a counsel prior to that. I was not.
I'm going to ask you a question that Mr. Busby has stated earlier. Have you ever heard the term, there's no coincidences in the city of Austin?
I've never heard that term before. And there are plenty of coincidences.
It was a yes or no question, Mr. Bangert. You said you'd never heard of it.
Never heard of it.
So September 30th, you guys go to the FBI, true?
We did.
All right. Now, that is before you become aware of a second referral made to the Travis County District Attorney's Office, true?
Trying to recall when we became aware of that second referral. It may have been, I just don't recall precisely the order of events, but I believe it was.
I mean, you seem to have a great recollection of the order of events when Mr. Harden had you on direct examination. Are you saying that you're forgetting now?
No, I'm telling you that I'm trying to recall specifically when I learned that fact, but I did learn that there was a second referral.
Okay. And it was after you went to the FBI?
That is entirely possible, yes.
Okay. And then the next day, that is when you guys decide to reach out to Ken Paxton, after you've already outed him to the feds, right?
We reached out to him the next day.
Okay, that's what I said. So that's a yes, right?
We did reach out to him the next day.
You were pretty active.
The witness, but once again, witness, when you can answer yes or no, if you can, answer yes or no.
I cannot answer yes or no to that question. I'm answering what I can.
Okay. You were pretty active on October 1st.
I was active on October 1st, yes.
Okay. You guys, when I say you guys, I mean the executive level administration. You had a group chat going, did you not?
We did.
And you participated in that group chat, right?
Yes.
We heard you talking to Mr. Harden about some of the text messages in that group chat, right?
Yes.
And specifically, they were talking about a draft that was circulating between you and the other executive level attorney generals, right?
Yes.
Eric, would you mind pulling up House Board 225? And in that message, well, it's safe to say that the first draft that you all created did not go to the FBI, right?
I don't know. This letter that's
Right.
being referred to here?
It
No.
was revised and edited to an extent.
The document, I don't recall if it ever went to the FBI. We were working on an internal document
Okay.
to memorialize our complaints.
Right. And the first version of that complaint, well, from what we look at in House 225, Jeff Matier says, from Maxwell, read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today, and that is documented. Is that true?
You added the word "and."
Okay.
Apart from that, you read it
Excuse me?
correctly.
But that's what the text says, right?
That is what the text says.
And
with that addition.
presumably that's regarding the initial draft that you guys created to memorialize your complaint to the FBI, right?
I don't recall specifically that that's what this was.
Are you forgetting all of a sudden? Because you had a crystal clear recollection when Mr. Harden had you on direct examination, Mr. Bangert. Do you not remember this? You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did
Yes
not
or
go
no?
behind the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton you were going to the FBI? Yes or no?
I cannot answer that question with a yes or no.
Witness, you'll answer the question.
Yes or no, Mr. Bangert?
Provided him with ample opportunity.
That's not what I asked you. Did you tell Ken Paxton you were going to the FBI? Yes or no?
We gave him ample opportunity.
That's not what I asked. Objection non-responsive, Your Honor. I'd ask that he answer the question before him.
Witness is ordered to answer the question, yes or no.
Mr. Bangert, it's a very simple question. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th, we did not.
It's a yes or no question, Mr. Bangert.
It
It's
is
a
not
yes or no.
a yes or no
It is a yes or no question.
counsel.
Excuse me, sir. Your Honor, he answered the question, but because he was talking on top of him, he didn't hear it. He said on September the 30th, we did not. And he starts interrupting him halfway before, and the court reporter probably had trouble hearing. We did not. So I just asked him to let him finish what he's saying and not talk on top of him, if for no other person than the court reporter.
You can ask the question one more time.
Mr. Bangert, it is a yes or no question, and I want a yes or no answer. Did you tell Ken Paxton that you were going to the FBI?
I did not tell Ken Paxton before I went to the FBI.
Okay. We're not done with that. Your next message after we're talking about the first draft of y'all's complaint says, okay, sounds like we need to beef up the specific allegations. Does it not?
Yes, that's what I wrote.
So you actually had to go back in there and put more words and more filler into that complaint, didn't you?
No.
No? Well, the first complaint clearly wasn't sufficient if we're to go off your text messages, right?
You said the word filler. That's an inaccurate characterization
You had to
of what
amend
we
it.
were doing.
Well, let's look down there. Eric, if you could hop off of the zoom in. It says, sound like we need to beef up the specific allegations. You needed to beef them up, right? You needed to make them sound stronger. True or no?
We needed to include additional allegations to substantiate what had happened.
Okay. And so it's after that that you started talking about other things that Ken Paxton had done previously that you didn't think to include in the first version of the complaint, right?
I wouldn't put it that way.
You wouldn't put it that way. And to be clear, this is all coming to fruition because Brandon Kamick is serving subpoenas on a bank. True?
That was in part, but not entirely.
And all the while, you didn't even know that the Travis County District Attorney's Office sent a complaint directly to Mr. Kamick that did not go to the Office of Attorney General.
That would have been much more concerning if I'd known that.
So you didn't know that?
No.
Okay. Eric, would you mind pulling up Article 6? Or excuse me. Article 5. The allegation in Article 5 is that Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorney pro tem. You would agree with that, right? That that's the allegation?
Yes, that is the allegation.
Mr. Bangert, Brandon Kamick was not an attorney pro tem. True or not true?
It's difficult to classify what he was.
True or not true?
I don't personally believe he was properly ever appointed a prosecutor pro tem.
And the Travis County District Attorney's Office never recused themselves officially and formally from the complaints made by Nate Paul to their office. True or not true?
I'm not aware of any recusal.
Okay. May I approach you, Your Honor?
Yes.
I want to go back to your last answer, and I'm going to re-ask you this. Brandon Kamick wasn't just not improperly appointed as an attorney pro tem. Brandon Kamick was not appointed as an attorney pro tem at all.
Not to my knowledge.
At this time, Judge, I would offer AG Exhibit 95.
I think that's on our list of already admitted.
It is. No objection.
Okay.
It's already admitted.
Thank you, Judge. Eric, would you mind pulling up the first page to AG 95? Mr. Bangert, we talked about you being heavily active on October 1st of 2020, and you agreed, right?
I was.
And one of the many actions you took that day was that you took it upon yourself to email Jeff Mateer's letter to Brandon Kamick terminating his employment, did you not?
I did not take it upon myself. I agreed with Mr. Mateer that this would be an appropriate way to handle this.
Okay, so you and Mr. Mateer were both of agreement to do that.
We were in agreement to do this.
All right, I want you to flip to the second page of that correspondence. You would agree that, and Eric, if you would do the same, you would agree that that is the letter that Jeff Mateer provided to terminate Brandon Kamick's employment, right? It's produced by the House, Mr. Bangert.
Correct. I want to make sure that the word terminate is accurate here. We were told him to cease and desist.
Third line, notice of termination effective immediately.
Yes, we do say that.
Okay.
Yes.
And just to be clear, you don't know all the work that Brandon Kamick put into that investigation, do you?
At that time, I was not aware of what he was up to.
And you were willing to just fire him without even thinking to pay him or compensate him for his time and his services as a lawyer?
We terminated him in this letter and told him to cease and desist.
Without even thinking about giving the guy a little bit of money for the time and effort he spent on this investigation? Yes or no?
I would not put it that way.
Okay. You didn't pay him, did you?
No, we did not.
All right. But the thing I really want to focus on, Mr. Bangert, because you're a man that has attention to detail, right?
I do my best.
I want you to look right under that Attorney General seal at the top of that exhibit, okay? Do you recognize anything that should be there?
It's been several years since I worked with letterhead. It has the seal of the Attorney General's office there.
How about your boss's name? You see that there?
His name is not here, no.
Yeah. You went ahead and sent it without his name, didn't you?
I'm trying to recall. I think there was a version.
You're looking at the document, Mr. Bangert.
Excuse me, he's trying to answer the question. Can you please let him before he jumps?
Overruled.
You're looking at the document. Is Ken Paxton's name on that document you sent to Brandon Kamick or not?
His name is not on the letterhead, no. But just for the record, I do want to point out his name does appear in the letter.
Objection, Judge, to non-responsive. I didn't ask this witness a question.
Sustained.
And I'll pass Mr. Bangert.
Mr. Bangert, I want to start to try to ask you a few questions again to go back to this opinion that sometimes has been referred to as the midnight opinion. Originally, if I can, I would like to bring up, please, Stacy, Exhibit 112. Now, can you look at this and determine and help me out and tell me whether or not this is the original draft that y'all did on and presented to the Attorney General on that Saturday afternoon? You need a moment to look at it, or would it help you to have a hard copy?
A hard copy would be helpful, yes, sir.
Can we? And Stacy, do we perhaps have a hard copy for the court?
But I can tell you without looking at it that this is not the original version that we sent.
Now, let me follow up on what your observation is. What order would this draft have been?
I'm assuming this is the final draft. It would have been the very last thing that was produced.
Would you look at the first page, please? And the last page, if that helps you.
No, this is not the final draft. I can now see there's no signature on it.
Right. Would you look at the opening paragraph and see what that seems to be saying in terms of the original position you took?
Yes, this refreshes my recollection.
Pardon me?
Yes, this does refresh my recollection as to that.
And now that you look at the language in the first paragraph of Exhibit 112, what does that tell you in terms of which draft or order it was?
This was one of the early...
Now, let me tell you a problem for you to keep in mind. When you look to the left for the iPad, there you go. Perfect. There you go.
There we go.
All right.
Yes, this was one of the early drafts.
And in the first paragraph, would you look at the sentence that begins with "we conclude"? Would you highlight for me, Stacy? Read this paragraph out loud to the jury, please.
Yes. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA 28. And local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right. Now, at that time, what was the legal basis for you concluding that there wasn't a restriction and that it could be conducted?
It was GA 28, the governor's order.
All right. And what was it about GA 28, the governor's order? And I may have a copy there. I couldn't locate it on my desk. If somebody finds it, they can bring it up to me. But what was it about the governor's order, and when was that order, that you concluded would allow essentially the foreclosure sales to go forward, particularly outside? Thanks. Thank you very much.
Yes, there were a number of exceptions in the governor's order to in-person gathering restrictions.
With the court's permission, I'm going to mark this as an exhibit number 621. Thank you so much. 631 or 633? 631. Thank you. I'm going to tender it to counsel, Your Honor, because I don't have an extra copy right now.
No objection, Judge.
631 shall be admitted into evidence.
Thank you, Your Honor. Do we have a copy by chance for the court to have up there?
Always nice for the court to have a copy.
This only came up during the lunch hour. I apologize.
Thanks, sir.
And one for him. Thank you very much. Now, I don't know whether or not, and I'm going to ask as we go along, whether Ms. Manella can figure out a way to balance these. First of all, if there's a way to do a split screen here, Stacy, 112 and 115, and I believe I will represent that 115 is the final order. and I believe 115 is in evidence. Now, if you could look at these two orders, is the one on the left, the draft we talked about, Exhibit 112, what your first finding was?
Yes, our first finding is summarized in the first paragraph. We conclude that a foreclosure sale. Yeah, there we go. Thank you. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA-28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right, now I'm going to ask you if you could leave that up, please, Stacy, first. And then I want you, if you would, I want you to look over to the government's executive order on page 3.
Okay, and I don't have a copy of the order.
Do we have one more, Mark? No.
Thank you, sir.
Thank you. And I believe that 112 was just never discussed as one of those that you did not object to. I want to tender it to you again to look at. I just looked to make sure. I'm told that 112 is not in evidence, and I apologize. The headlining is not. This is the original draft they proposed to him.
No objection, Judge.
No objection, 112 will be submitted to evidence.
And I apologize for having published that before I realized it. That's my fault, not anybody else's. Now, I want to ask you, you referred in your testimony just a moment ago that in your first draft, in which you basically had a ruling that said these foreclosures, particularly outside, would be allowed. And then you said that was partly based on the governor's executive order that he had previously issued. And you talked about it as General Order 28, correct?
Yes, no occupancy limit applies.
I'm sorry?
Yes, no occupancy limit applies under
All right.
GA-28.
And what role can you point us in the governor's General Order 28 to the section that you relied on in that initial opinion that said they could be open to the public? They could foreclosure proceedings could be open.
Yes. May I see the second page of
Pardon me?
exhibit? May I see the second page of Exhibit 112?
All right. We move to second page. Thank you, Stacy.
Yes. Yes, we reference it here. We address your question.
No, I'm sorry, Stacy. What I want to do now is go to, if you have ordered, I don't know if you have 631 loaded, do you? If you do have 631 loaded, could you go to the second page of that? And you can sacrifice the one on the right. You can take down 115 and put in the governor's general order. And by the way, the executive order, before you move, Stacy, that is dated. Can you see on there what date it is? Is it June? Can you see June 20th?
I can. It's June 26th, 2020.
All right. Now, so that executive order, did it not, existed at the time that you were drafting your opinions at the request of the Attorney General?
They did.
All right. Now, what is it on page 2 of the governor's executive order that led y'all to conclude and say in your first draft that foreclosure sales could be conducted?
Yes, if you will go to page 2 of Exhibit 112.
All right. Stacy, if you go to page 2 of the
first
general
full
order.
paragraph.
Pardon me?
The first full paragraph. We point out that Executive Order 28 has a baseline limitation that does not apply to...
I don't... I'm confused here, and it's probably my fault. Stacy, may I approach, please? As usually, Ms. Manello is more on top of it than I. You directed me, and it's my fault, you directed me to page 2 of
Exhibit 112.
112, your initial draft opinion.
The initial opinion.
And I was trying to go over to the governor's order. But let's
yes.
stay with 112 first.
Okay.
So now, Stacy, let's put up 112 and the governor's order. Those are going to be the two on the screens. Go ahead. All right. Tell me what it is about 112 that you think is relevant to what we're saying.
Yes. This paragraph that is highlighted,
All
the
right,
second
move
paragraph.
it away from that microphone. You got to move it to
Yes.
you. There you go.
The paragraph calls out the executive order's baseline limitations on gatherings. It then says this limitation does not apply to any services listed by the U.S. Department of Homeland Security's Cybersecurity and Infrastructure Workforce version 3.1 or subsequent version. CISA guidance is how we referred to that. Among the services listed in version 3.1 of CISA are residential and commercial real estate services, including settlement services.
And then if we go down to, you go down to about a sentence or two down there, you say, do you not? And there is no better indication of that intent than the words that are chosen, correct?
That is correct.
All right, now let's stop there and let's go over to the second page of the general. And by the way, could you just explain to us lay people what CISA is, CISA? What does that stand for?
It's the Cybersecurity Infrastructure Workforce. CISA is I'm trying to recall exactly what that acronym stood for, but there was a guidance document issued by an agency within the federal government that called out essential services and infrastructure that should be exempt from COVID limitations.
Okay, so for us lay people, essentially, are you saying that you are going from your draft that you did to show why the governor's proclamation or executive order would have exempted it as far as you were concerned when you dropped the original draft? Is that right?
That's exactly right. We were trying to demonstrate, and we did demonstrate here, that a straight application of the governor's executive order excluded these types of foreclosure sales from limitations.
All right, stay with me. I don't want to tell everybody how to build a Swiss village when we're trying to just do what time it is. But if we go to page 2 of the governor's order, where in there does it point people to the legal basis you made for your original order?
Paragraph 1A.
Stacy, can you, on the left, can you do 1A? Thank you. Can you highlight 1A for me? There you go. Mr. Donnelly wants to make sure that I let you know that we can't give you a copy of the CISA document because it's a government confidential document, okay? But having said that, would you explain in this highlighted language how this tells you...
Objection to that sidebar about the CISA document. I don't believe it's confidential.
Sustained.
Can you explain in the highlighted portion here?
Say again?
Yes. Explain in a highlighted portion how that impacted your original opinion you recommended in a draft to the Attorney General.
Yes. This was part of the exemptions from occupancy limits, and the CISA guidance called out a number of essential services, infrastructure, among which, as we point out in our original draft guidance, are residential and commercial real estate services, including settlement services.
So explain to the court what that meant as far as the conclusion that you ultimately reached and recommended to the Attorney General.
Based on a plain text interpretation of the governor's order, foreclosure sales would not be subject to occupancy limitations.
If it affected any real estate?
Yes, and that was a straightforward textual interpretation.
So in your original one, did you actually base it upon an exception the governor's executive order had given to say that it should be open to the public?
Yes, it was a straightforward application of the governor's executive order.
Now, how did you get around that then when you were ordered to come up with a different answer? And if we can, Stacy, let's now put take down the governor's executive order and put up Exhibit 115, please. Now, tell us what it is about what did you do that, since you had based it on a specific reading of the governor's statute, and now you're being asked to give an opposite view? How did you do that?
Could you go to page 2 of Exhibit 115?
Yes. Where do you want to be?
If you'll look at the third paragraph. We simply jump straight to the general occupancy limits.
Pardon me?
We jump right to the general occupancy limits, excluding conversation about CISA.
Direct us and Ms. Manella where to highlight that you're talking about.
The language, this general limitation, however, is subject to several exceptions.
Where you read?
One such exception is found in paragraph 5 of the order, which limits outdoor gatherings to 10 persons or fewer without approval by the mayor or the unincorporated territory. So we switched out the applicable exceptions in the order to eliminate any reference to the CISA guidance.
So what you did is you just wrote out a paragraph, did you not, of the governor's order?
We determined, based on the Attorney General's instructions to us, that we would no longer apply the exception that had been granted by the governor's order.
When you say based on his instruction, did he actually talk about that language?
No, he told us to reach a different conclusion, and that was the only way to do it.
I don't need it, but thank you. All right. Now, finally, I want to make sure, I don't know that I need to introduce this, but had you read, may I approach the witness very briefly?
Yes.
I want to approach you and show you what we have just marked as a new exhibit. House Board of Managers Exhibit 632 is a new listing. I'll tender to the court and the counsel with the admonition that I don't intend to read all this. So my question to you, though, without having introduced it yet, I will actually make it for ease, move to introduce it. We move to introduce House Board of Managers Exhibit 632.
Judge, I would object to this witness testifying to this document, and additionally, this document has not been produced. There's no bait stamps on this document.
No, that's certainly right. It has not been produced. We never foresaw this issue. So we've just gathered this during the lunch hour and printed it out here, and we've tendered it to him. Whatever his position is fine, but he's certainly right. It's never been produced. We did not foresee this issue.
It's a 40-page document riddled with hearsay, Judge.
It's a government record, I think. Probably stands on its own. It's a public government record.
Mr. Rosso, do you need time to review this 40-page document?
Judge, if I could have 1 or 2 minutes.
If I may, I think that's a reasonable question. So if I could speed it along, what I'll do is I'll withdraw, or wait on the motion to admit it, see if I can elicit testimony that gets the same, it may not become an issue ultimately. But if I do want to, I'll give him notice so he gets time to read it.
Hold on 1 second.
Judge, we're ready to go.
All right. Thank you. Now.
Do you withdraw the objection then?
No, Judge. Judge, may we have 5 minutes to just look through this document real quick?
Yes.
Okay.
Yes.
Fine.
We'll stand at ease for 5 minutes.
Okay, so Mike, I'm going to go to you first because I want you to explain kind of what are we seeing here.
So this is what you would call redirect testimony. After the cross-examination, the lawyer calling the witness gets to ask more questions. It seems like Rusty is trying to close up some holes that the defense has drilled into the case a little bit. Right now, we're taking a break because Mr. Hardin has introduced a document that has not previously been tendered.
Is a government document, can it be hearsay?
So a government document can be hearsay. So, again, for the listeners, quick legal lesson, hearsay is an out-of-court statement that is offered for the truth of the matter asserted, right? So whatever that statement says, again, I used it rained yesterday. If the statement is it rained yesterday and I'm trying to say, therefore it rained yesterday, that's hearsay. But there are a bunch of exceptions. Even though it's hearsay, if it's one of these exceptions, it comes in even though it's hearsay.
And a government document is one of them.
And a certified government document is one of them. So I think Rusty Hardin is right that it's admissible even though it's riddled with hearsay. As Mr. Oso said, I like that little flourish. As a trial lawyer, anytime you can be a little snarky, that's fun. I get what he's doing there. But because it hasn't been previously tendered, so again, this isn't exactly a criminal trial, but under the rules in a criminal or criminal-ish trial, the idea is that the defendant should have full access to all the evidence so that his lawyers are not ambushed. And as Mr. Hardin said, this had not been tendered because they didn't think this was going to come up. This is obviously in response to something.
Well, it's because they brought up the whole thing about Trump, right? I mean, that Trump had signed this executive order a week later, so they're having to kind of.
That seemed to come out of nowhere.
Right, so they're having to deal with that.
And and he said we had to deal with this during lunch.
Right.
They had to go out and find this and sort of hold it up to, if there were any holes poked, they want to put this right over that hole and say, no harm done.
This explains that.
This explains.
You were misled, jury, a few minutes ago when the defense tried to insinuate this or that.
Right.
That was misleading, and here's the document that shows that. So that appears to be what he's doing. The defense has asked for 5 minutes because this is a big document and they want to review it. I found it interesting that Mr. Hardin then came back and said, you know what, Judge, I can save us all a bunch of time. I always think anytime a lawyer on either side does that, that's kind of a masterful lawyer move.
He reminds me of Matlock.
He does, and in the best
I'm
possible way.
showing my age here.
No, I'm with you. In the best possible way, because he's signaling to the judge, I can help you, and then he's signaling to the jury, I don't want to prolong this. I'm not going to waste your time like the opposing counsel is doing.
Like they're doing.
Right, which is, whether that's fair or not, that's kind of the insinuation. Both sides are going to score their points where they can. And so I found it interesting that the defense still said, no, we want to look at this document, which basically, again, I would worry if I was them that I just signaled to the jury, no, I'm willing to waste your time, even though he's willing to save your time.
Right.
But
this is not a traditional jury.
Right.
No, and you also don't want to risk in that 40 pages there being something that's going to bite you in the butt. And
sure.
The defense is not going to risk that
Sure.
at all,
Right.
even in the slightest seemingly inconsequential thing.
Every lawyer's different. What I would do is I would try to signal, and I would say it straight to the jury, frankly, I don't want to waste anybody's time. Sure, we can go forward. Because ultimately, you are going to be able, this trial's not going to end in 5 minutes. Right.
No.
I mean, you could read it and let things proceed, right?
Then you could come back tomorrow, and frankly, again, this is why I would do it this way. Then you get to say to the judge and jury, Rusty Hardin misled you. We hadn't been able to read this, but now I've got this perfect comeback that's in these documents, and he's lying to you. You could kind of play that card.
You can't trust anything he tells you.
Exactly.
Right.
And so you can always, again, when a witness has been done is finished with their testimony, the judge will generally say, may this witness be excused. When they're excused, they're gone. but you can say subject to recall. So again, the defense can always say, hey, this witness needs to be on call in case I need to bring him back after I have a chance to read this big document.
Right.
What do we think of letterhead gate?
That seems like a lot of nothing to me.
It seems like a lot of nothing to me. Every organization I've ever worked for has more than one letterhead, because letterheads are used for different purposes by different people in the offices.
Right.
And
I feel like there's a reasonable explanation
I
for this
think
that we
there's
have
a
not heard yet.
reasonable, and that it will turn out to be a nothing burger, because there are all sorts of possible explanations for
And
it.
from a defense standpoint, I completely can see what they're doing, right?
Right.
You want to poke any hole in the water balloon you can and hope that's enough. And you're also trying to draw the prosecuting attorneys
Right.
away from their case and have them start answering you tit for tat. Because once you can draw the other side into answering you tit for tat,
Particularly on
they're
some
playing on
rabbit
your
trail
ground.
like this.
Exactly.
Yeah.
So if I'm Rusty Hardin and Dick DeGarrett, one of my big concern is,
Right.
is this really worth, do I feel like that really resonated with anybody? And therefore, okay, if I'm worried about that, then sure, let's issue up this
part of their,
Lettergate thing.
This was a coup thing.
Right.
That they took their boss's name off
Right,
because they
right.
were going behind his back and they were disloyal and traitors. That's part of where this letterhead thing
that's
is.
clearly the theme, right?
Right.
I mean,
Yeah.
that's the whole thing about.
Right, and the letterhead thing is part of it. You took his name off this letter.
Well, and there's obviously they're gonna. I would almost lay odds that in the closings, this whole "there are no coincidences in Austin."
It's going to show
Oh,
up.
that's going to be in it.
It's going to be a theme.
For a lawyer to quote his opposing or his co-counsel in some cliche that didn't really land yesterday and do it again.
It's coming back.
Right. Someone clearly said, all right, we have to work in that saying. Let's try to do it every day.
Just like I think it was obvious that Oso had a locker room talk from his coaches during the lunch break.
He was definitely more effective.
He came
his
back.
pacing was better. He was more aggressive. Now, frankly, I think he was, at times he was signaling with the tone of his voice and his kind of aha that he had scored a big point when I don't feel like he really had. But I'll give him A for effort. He was in there more alive.
Okay, we're back.
Mr. Osso, you.
Your Honor, I have no objection to this exhibit. Just for clarification, it was House Exhibit, what's the number, Rusty? No objection to House Exhibit 652. Excuse me, 632.
No objection to 632. Do you want to admit it into evidence?
Yes, please.
Okay.
All right.
House Exhibit 632 is admitted.
If I can, I'm going to walk up to you and I'm going to show you a page. By the way, I mistakenly called this a confidential document. I've looked at it. It is not. It's a public document. There's nothing confidential about it. That's one of 230 mistakes I'll make during this trial.
Objection.
Okay? So now, thank you.
Object to that sidebar.
Excuse me, what is the
Move to strike.
objection?
Sidebar, and I just moved to strike Mr. Hardin's comments.
Yeah, sustain.
Thank you.
You know better than that. There you go.
That makes it 237. Thank you. I'm going to walk up. I'm going to show you where the tab. I'll show counsel where I'm pointing it to. I'll go by him, show him what I'm about to address you to, because I can't send you to a page number. Just a second. Now, on Exhibit 632, is there a provision of it, and I showed you a tab, so there's no secret about this. Is there a provision in this document that you relied on in coming to your conclusions that you presented in your first draft to the Attorney General?
Yes.
And shown in Exhibit? Can you explain? And I don't know that, Stacey, you don't have this loaded, do you? Do you really? All right. Let me show you where I'm going, Stacy, because again, I don't have a page number. May I approach her? Now, if you would, on the screen that she's already anticipated, is there somewhere on this screen that you can direct the viewers to that has any language that you used as a basis for your original opinion that you delivered to the Attorney General on that Saturday afternoon?
Yes, the very last bullet point. Residential and commercial real estate services, including settlement services.
And what did that mean to you?
We interpret that in the original opinion.
And then can you read the portion of Exhibit 112? Stacy, can you split it for me? 112, in your opinion, that was really based on this segment, this one little excerpt out of 632.
Yes. Second paragraph, second page. A court's main objective in construing the law is to give effect to the intent of its provisions. And then we footnote, and there is no better indication of that intent than the words that are chosen. Then we footnote, where text is clear, text is determinative of that intent.
Microphone. All right. Keep going.
One dictionary defines a service as work that is done for others as an occupation or business. Real estate is defined as land and the buildings and permanent fixtures attached to it. Thus, real estate services include services performed for others as an occupation or business that pertain to land or the buildings and permanent fixtures attached to the land, insofar as the performance of auction or foreclosure sale services related to commercial or residential real property. Such services are one specific iteration of residential and commercial real estate services.
All right. So, to reduce it down to its basics, in recommending or in your drafting to the Attorney General, saying that there should be no restriction on the foreclosure sales, did you rely on a government document as guidance as to why it would be considered an essential service or activity that was exempted based on the governor's executive order?
Yes, the specific government document referenced and incorporated into the governor's order.
All right. So in effect, in y'all's opinion at that time, was your recommendation that it would be open and they could have foreclosures based on a combination of the governor's order, and if you go to the basic item that they're referring to in the governor's order, that would have said essential services that would have included foreclosure sales for either commercial or real estate property?
Yes.
Residential property, excuse me.
Yes, we conclude that it is not, there's no occupancy limit applicable pursuant to Executive Order GA-28.
Now, when you then were directed to come to the opposite conclusion in the drafting, that is the final product in the exhibit that we've been using, I think is 115, you had a challenge to write around the basis for your first opinion, so what did you do?
Objection to leading and assuming the answer in the question.
Sustain, rephrase.
What did you do to come up with the opposite conclusion you had originally arrived at?
A couple of things. If you go to page 2 of Exhibit 115, you first point to the general occupancy limitations in the third paragraph. Next, we do point ultimately to CISA at the bottom paragraph. And if you would go to the next page, at the very bottom of the first full paragraph, and this is really the kicker, the court's main objective in construing the law is to give effect to the intent of its provisions.
Slow down, please. On behalf of court reporter.
Yes, my apologies.
And the volume on behalf of the people on the floor. Could you speak a little louder, please?
Yes. We repeat our commitment to textualism, which was a guiding star of our office at all times. We then point out that based on our analysis of the words, we believe that outdoor foreclosure sales, last sentence, are not exempted from the 10-person attendance limitation.
And
we completely reversed it.
Excuse me, I'm sorry. What was the only thing that had changed since you had the original opinion?
The direction from the Attorney General.
All right. Now, you had questions about whether or not it would have happened anyway because of other subsequent events. At the time that you drafted these two opinions, did you have any idea that Nate Paul had bankruptcy hearings scheduled?
Objection asked and answered. And this witness said he didn't have specific knowledge, so speculation.
Sustained.
In this particular matter, did you yourself know about any bankruptcy hearings that were set any foreclosure hearings that were set in the foreseeable future? Just you yourself, were you aware?
Objection asked and answered.
Not by me.
And lacked specific knowledge.
Overruled. I sustained your first objection, which forced him to ask the question a second time.
Thank you, Your Honor. Did
No.
you yourself?
I had no specific knowledge of any specific foreclosure sales.
All right. You were there when he introduced a certain document. And if I can I have Exhibit AG Exhibit 295, please, Stacy? You have heard earlier questions on direct as to whether or not, have you not, sir, these opinions would be of help to somebody who was somebody that was opposing a foreclosure hearing, right?
I recall those.
All right. Now, if you could, can you identify, had you seen before we showed you this Attorney General exhibit, had you seen it before, this exhibit that he's entered into evidence?
No, this is the first time I've seen this document.
All right.
With the cross-examination.
All right. Now, I want you, I'm going to read this to you and ask you what the import of this when you look at the exhibit is. Judge Gamble, August 3rd, 2020. As it is relevant to these proceedings, please see the attached guidance just released by the Attorney General's office. Had been just released, hadn't it? What date was it released?
The 1st.
1st of August. That was a Sunday, was it right?
I believe midnight the 1st. I think that's right, yes.
So this is just Tuesday after you released the opinion or after you provided the Attorney General the opinion on Sunday the 1st, correct?
It's 2 days later, yes.
Keep your voice up away from the microphone.
2 days later, yes.
All right. Regarding the foreclosures may not proceed unless specifically authorized by the mayor and the city of the foreclosure, given the standing 10-person restriction would violate Texas Property Code, Chapter 51. Does the attachment include the opinion that we have just been so laboriously going over?
Yes.
Would you look to the last page of that opinion and see if that's the final one that we identified as Exhibit 115?
It is.
With your signature?
It is.
Does the cover page identify on behalf of whom this particular this particular pleading was filed in a court here in Travis County?
Yes.
And who was the person that represented whom was presenting this particular pleading and urging that your opinion was relevant to their case?
This is one of Nate Paul's companies.
Do you even yourself personally know how the judge ruled one way or the other on this motion?
Not in this case, no.
All right. And in fact, are you familiar with any other cases? Nate Paul cited this opinion and seeking to foreclosures in that year of 2020 after you rendered your final opinion.
Only through news reports that came out after.
All right. Was it multiple places?
Yes.
Objection to hearsay, Judge.
Through.
Do you withdraw that question?
I think actually he meant to say leading. It was leading, it wasn't hearsay.
No, I meant to say hearsay, but I'll retract the objection for Mr. Harden.
That's all I have.
Recross?
Yes, Judge.
Mr. Rosso?
You just cited the Cybersecurity and Infrastructure Security Act pretty precisely to Mr. Harden on direct examination, did you not?
I had it in front of me.
Okay. You also cited the day of the week that you issued that opinion, did you not?
The day of the week was August 1st when we issued the opinion.
I'm just surprised because you showed an uncanny ability to remember things when Mr. Harden was asking you questions, as opposed to when I asked you about the same documents during my cross-examination. Can you explain that?
I disagree with your characterization.
Okay. We'll agree to disagree. I don't have an e-copy of this CISA document that the House has just produced, but I think Mr. Harden had you reference page 16 of that document, did he not?
He did.
He had you reference the very bottom part that I have highlighted in orange, and I'm going to show the jury. And it says settlement services, correct?
One of the things it says is settlement services.
Now, behind the term settlement services in this document, there is no definition as to what settlement services are.
I do not see a definition.
I don't see the word foreclosure sale or non-judicial foreclosure sale behind it, do you?
The word foreclosure sale does not appear.
Do you have a real estate license?
No.
Okay. Would it surprise you to know that people that have real estate licenses oftentimes engage in settlement services to close on homes?
I would not know.
It deals with title work and things of that nature?
I would not know.
Okay. You won't find the word foreclosure sale in that definition, sir.
This definition? It is not in the word foreclosure does not appear there, but that's why you engage in legal analysis and construction.
Legal analysis and construction, which means that somebody else, another attorney, perhaps the Attorney General, could have a different viewpoint as to what a settlement service is, correct?
He could have any number of viewpoints about that.
That's why they call it the practice of law. Zone of reasonable disagreement. That happens a lot in law, does it not?
Not in this case.
Okay. Well, that's your opinion, but let's talk about facts. Are you aware of whether or not the opinion that you wrote that you said was unconscionable and opposite of Attorney General policy, did anybody challenge that in a court of law?
Did anyone challenge the opinion?
Yeah, the opinion in a court of law.
I'm not aware of it being challenged. I don't know how you would do that under standing doctrine.
Okay.
The witness may step down.
Judge, I have one more question if the court would entertain it.
Will the witness come back? One more question.
Prior to your term as a politician, did you or did you not practice real estate law? No. Paxton practiced real estate law, did he not?
I believe he had some real estate experience back in his past.
Okay. So when you guys are going back and forth regarding the definition of things, it's possible he had some background knowledge of what settlement services meant?
In this case, that was not the best interpretation.
Okay. That's your opinion, sir, correct?
No, that's the law.
That's your opinion.
I disagree.
Okay.
You may now step down. House, call the next witness.
We call Mr. Ryan Vassar.
Yeah, please do.
Mr. Vassar, were you sworn in the other day in the group? Okay, I need to swear you in. Please raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment, charges against Warren Kenneth Paxton Jr. Shall be the truth, the whole truth, nothing but the truth. So help you God. You may be seated.
Good afternoon.
Good afternoon.
Mr. Vassar, you and I have met at least once or twice, correct?
Yes, sir.
But I don't think we've talked about this subject. And that is, we have some microphone issues that you and I have to worry about. If you will try to make sure that you're speaking into that microphone to where everybody in the back of the room would hear, and I will try to make sure that I don't talk on top of you, and we go from there, okay?
Yes, sir.
Your full name?
Ryan Vassar.
That's going to work, if you can just stay with that. How old a man are you?
I'm 39.
And you married?
I'm married.
How many children?
4 kids.
How old? What ages?
Ages between 3 and 7.
Wow. In 2020, how old were they?
I had a 6-month-old, a 2-year-old, a 3-year-old, and a 4-year-old, I believe.
How are you employed now?
I'm general counsel for a local nonprofit organization in Austin.
When you left the Attorney General's office, and we'll get to that, how long were you unemployed before you found a place to land?
6 months.
What was your source of income?
Savings, but I was not employed as a lawyer for that 6-month period.
Did your wife work outside the home?
No, sir.
Let's go back now, a little bit of an autobiographical sketch review for about 1.5 minutes if we can. I'm not going to time you, but just roughly. Like where you grew up, your parents, what your background was?
I grew up in Big Spring, Texas, a small town in West Texas. I'm the oldest of 3 siblings. I attended Texas Tech University and majored in accounting. My father and grandfather are both certified public accountants. They both attended Texas Tech. They've had a CPA practice in Big Spring for the past 40 years, where they serve 3 generations of farmers and ranchers and salt of the earth people.
So how many years has your family been living in Big Spring?
My whole life.
All right. Now, when you finished as an accountant at Texas Tech, what did you do?
I moved to Dallas and worked in finance for about a year and decided I wanted to go to law school. And so I started working at Jones Day as a litigation assistant and during my application periods.
Does litigation assistant mean a runner?
Essentially, yes, sir. I was in charge of the documents.
And did you clerk or get to know anybody else of the legal profession while you were there? Other than the lawyers at Jones Day?
No, sir.
All right. Now, and then after you graduated, what year did you graduate from law school?
Law school was December of 2012. I'm sorry, December of 2011.
2011. And Mr. Vassar, were you involved in any outside, either political or social activities in addition to going to college and law school?
I was a member of the Federalist Society for Law and Public Policy Studies while in law school. And then I interned for 2 federal judges, one on the Southern District and one on the 5th Circuit.
Which judges did you intern for?
Judge Lynn Hughes on the Southern District, and then Judge Jennifer Elrod on the 5th Circuit.
And those were both college, law school internships, correct?
Yes, sir.
Were you involved in Republican politics at that time?
Not at the time, no, sir, other than just typical voting.
All right. And then after you finished law school, what did you do?
I served in Governor Perry's office of general counsel as an attorney fellow.
How long did you do that?
It was, I think, 6 weeks. It was a summer.
And then what?
And then I was invited to clerk for Justice Don Willett of the Texas Supreme Court.
So Justice Willett was on the Supreme Court. How long, to your knowledge?
How long had Justice Willett been on the court?
Yes.
He might have been appointed by Governor Perry at the time, maybe around 2010 or sooner.
I haven't sought to introduce it, but is it a fair statement that that Justice Willett had a extremely complimentary letter for you to have you go off and seek employment elsewhere when your service was over?
Objection, relevance.
Sustained.
Right. Now, at the end of the day, how long did you work for Justice Willett?
3 years.
And was that always exclusively on the Supreme Court, or did you work for him after he went to the Fifth Circuit?
Just the Supreme Court.
Now, at the end of those 3 years, what was your internship supposed to be? How long was it supposed to last? Your clerkship, excuse me.
Right. Justice Willett had asked that I commit to 2 years. 2 years came and went, and he said I could stay as long as I wanted to. But just with the circumstances that had changed, when I joined the court to work for Justice Willett, I was single. My wife and I got married while I was working there. And then about a year and a half later, we were pregnant with our first kid. So I think it was just a necessary transition from the court to other opportunities.
Right. So where did you go to work after clerking for Justice Willett?
I joined the Office of the Attorney General.
And who interviewed you? Who hired you?
Amanda Crawford, at the time, was the division chief of the General Counsel Division.
And what year was it that you joined the Texas Attorney General's office?
It was July of 2015.
You recall what your first assignment was in the office?
No, sir, I don't.
Okay. And then as time went on, by the time we reached the period of 2019, what was your position?
2019, I was chief of the General Counsel Division.
What does that mean? What would your responsibilities be?
So I advised the agency as the General Counsel, whether it was employment matters or contracting matters, state procurement law, just the typical day-to-day business legal advice.
And then as you went along there, and did you continue to move up within the organization?
Yes.
When was your next promotion?
It was April of 2020.
Now, was Attorney General Paxton already the Attorney General when you joined the office?
Yes, sir.
So your entire career at the Attorney General's office was under the guidance and service of General Paxton?
Yes, sir.
How well did you get to know him?
I might have met him for the first time at an office Christmas holiday party where he and Senator Paxton were taking photographs with employees. That might have been 2 years into my employment, so maybe around 2017. From then until I was promoted to deputy for legal counsel, I might have seen him once or twice at a division chief's meeting, but nothing.
And then what about by the time we approached, let's say, January of 2020? How much contact by that time in your different positions that you had with General Paxton?
He might have contacted me once about a matter, but other than just the typical monthly division chiefs meeting or holiday party, it was nothing substantive.
All right, so we in the jury and the court assume that you yourself did not personally know Mr. Paxton that well at the time.
That's correct.
All right. Were you around him socially other than a periodic office gathering?
No, sir.
All right. Now, when we enter the year of 2020, whom did you have under your supervision in the office?
April of 2020, I was promoted to be the Deputy Attorney General for Legal Counsel.
Does that mean that you were one of the top 8 deputies, or 12 deputies rather, up on the 8th floor?
Yes, sir.
Would you describe, I'm not sure we've broken it down to people, when we talk about the 8th floor, what does that mean in common vernacular for you?
So the 8th floor refers to the 8th floor of the Price Daniel building, where the majority of the executive staff of the Office of the Attorney General have offices.
All right, so when we talk, if the jury is to hear about people where General Paxton dropped into this person's office, this deputy's office, that deputy's office, were all of these offices along the same area, or what was the physical layout?
So if you can imagine, there's 2 elevator banks in the middle of the building, the middle of the floor. And the offices are spaced out around the perimeter of the inside of the building. So each deputy would have an office. There were roughly 3 or 4 offices on one span or one length of the building. So each deputy would have an office.
So my reason for asking, and I'm asking you the answer to this, is that where the office is readily accessible to each other and to the Attorney General, where any of those folks were within a very short distance on the same floor of dropping in or out on each other?
Yes, sir.
All right. Now, when did you first hear, if you ever did, of a person named Nate Paul?
I think it was May of 2020.
And what was the occasion for you to first come? Well, let's back up. What was your position in May of 2020?
I was Deputy Attorney General for Legal Counsel.
Now, how much contact did you have with Mr. Mateer?
We had weekly meetings, one-on-one meetings with Mr. Mateer, Mr. Bangert, and myself.
Now, you're dropping off. I want you to remember that microphone. And maybe you need to move up just a little bit, or... All right. You had these weekly meetings, staff meetings, where there's a day scheduled of the deputies and Mr. Paxton?
So there are deputies meetings that occur weekly, and then there are also one-on-one deputy meetings with Mr. Mateer. So I would meet in all of the deputy meetings, but then I would also meet individually with Mr. Mateer and Mr. Bangert.
And at that time, how old were you?
I would have been 37 or 36 at the time.
And you would have been there at the Attorney General's office since you were about 32 or so?
Yes, sir.
Would you agree that you had moved pretty fast in the organization?
Objection leading.
Sustained.
Sure.
You asked differently.
Yeah. Now, at the end of the day, when you entered into, say, your new position as Deputy General Counsel, what type of matters would that have put you primarily over?
So the Deputy Attorney General for Legal Counsel oversees the opinion writing process, the Open Records Division, the Public Finance Division, the General Counsel Division, and I believe that's it.
All right. So in May, or April or May of 2020, what was the occasion with you becoming familiar with the name of Nate Paul?
There was a pending open records matter involving the Department of Public Safety that had been connected to Nate Paul's name.
Now, at this time, how well did you know Mr. Mateer?
I believe Mr. Mateer joined the office in 2016, if I'm not mistaken. So I'd become familiar with him just in my experience over the past 5 years working at the agency.
What was he like as an administrator and first assistant?
He was great. I mean, he was a people person. He wanted to know how staff were doing. He wanted to connect with each person. He was invested in what they were doing, what they were interested in. He would host book clubs where he would select a book, whether it was a managerial book or leadership book, and we'd meet over a brown bag lunch and just talk about a chapter of the book and how we could implement it in our work and at home. So he was a role model.
Was he religious?
Yes, sir.
How about you?
I am.
In what way?
Objection relevance, Your Honor.
It's very relevant to who these people are in the light of who they've been accused of. Thank you.
My wife and I attend an independent Baptist church here in Austin. We've been members at different churches here in Austin, and I've been a member throughout my life.
What did you view your duty as an assistant AG to be?
Assistant AG, or as far as Deputy Attorney General for Legal Counsel, I was responsible for providing legal advice to the agency through the various functions of the divisions, whether that was the Open Records Division, the Opinions Division, the Public Finance Division, or the General Counsel Division.
You've heard, have you not, or have you heard, you're being referred to by the Attorney General, all of you, as rogue employees?
Yes, sir.
What was your reaction when you heard that allegation?
It was hurtful.
Why? Tell me.
Sorry. I worked for the state for 8 years as a public servant, as one who values.
Your Honor, may I approach the witness?
Yes.
Thank you. As one who values the commitment to public service, to set an example for my kids, the people that I worked with, the people that I managed, and it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
How did you become familiar with Nate Paul?
Well, as I mentioned, the first time that I had heard the name was connected to the open records request that was pending at the agency, the Office of the Attorney General, involving the Department of Public Safety.
And did you learn what the issue was about this open records request?
Yes, I did.
And what was the issue?
The Department of Public Safety had received a request for public information. Under the Public Information Act, agencies that desired to withhold information for a valid purpose have to ask for the Attorney General's ruling on withholding information within 10 days. The Department of Public Safety had requested a ruling from the Attorney General's office on whether it could withhold information under the law enforcement exception to disclosure. So in other words, if there is information in the request that qualifies as law enforcement information that is not required to be disclosed, the agency is requesting the Office of the Attorney General to make that determination so that that information can be withheld.
At the time that you began to have awareness of Nate Paul, how would you describe your sense of loyalty and support of the Attorney General?
It was my understanding that General Paxton had met personally with Nate Paul. He considered what had happened to Nate Paul to be wrong, and he wanted us to find a way to help Nate Paul.
And when was the first time? Did you have conversations with the Attorney General about this matter?
Yes.
When did personal conversations with the Attorney General begin in person? Either, well, let me put it in person or by phone or by text, any of that way. When did you first have contact of some type with the Attorney General about Nate Paul?
It was in the month of May of 2020.
And what form did that take, and how did it happen?
I believe it was all in person. There were no phone calls or text messages or emails, to my knowledge.
All right. And when they had these phone calls, do you recall what the Attorney General said in the first one and what the occasion was for that call?
The initial call was a request to pull the file, basically.
By whom? Who asked you?
General Paxton.
Do you recall what he said on the call?
Well, I say it wasn't a call. It was generally in person.
Oh.
So stopped by the office, asked me, I would like to see this file, And so I contacted Justin Gordon, who is the chief of the Open Records Division, and asked him to bring the file to my office.
Now, at that time, had you had any contact with Nate Paul's case yet, or was the General Paxton's request of you the first time you had become involved?
That was the first time that I was involved in the DPS file, the request at that time.
So, did you get the file?
Yes, I did.
What did you do with it?
I reviewed it and notified the Attorney General that I was prepared to meet to discuss it.
How did you do that? How did you notify him?
Normally, it would have been an email to his scheduler, just to see if he was going to be in the office, to see if we could schedule a time to meet. I don't recall specifically if I emailed the scheduler or contacted his aide. All right.
Did you, when you reviewed it, what all did you do? I mean, how much time did you spend reviewing this file?
It's my recollection, everything was drafted. The initial draft of the ruling was already complete, and it was a standard law enforcement exception was raised, law enforcement exception applies, the information should not be disclosed. So it was a pretty straightforward review.
Did you learn one way or the other whether there had been a previous ruling and finding from the department as to whether or not the law exception applied to the same event that was now happening with DPS?
Mr. President, I believe the objection would be this question calls for the solicitation of hearsay.
I don't agree it's leading, but I'll withdraw it because I don't think it was understandable. So I'll take it back.
For all the questions.
Thank you very much. So let me ask you this. When you reviewed the file, did you find out anything about whether or not, what event was being complained of that they wanted access, whose files they wanted access to?
The subject of the event was the August 2019 raid of Nate Paul's home and businesses.
All right. When you reviewed the file, did you find out one way or the other whether this issue had come before the agency once before about the file on the same event?
At the time, I did not connect this event to any previous determination by the office, but subsequently, I did connect the two.
All right. So ultimately, did you discover or connect, as this was the second time around for Mr. Paul and or his attorneys seeking information to overcome the law enforcement exception?
That's right.
Objection leading.
All right. Now.
Sustained.
All right. Now, let me ask you this. After you reviewed the file and you informed the Attorney General you were available to meet, was there a meeting?
Yes.
And can you put a time limit on time area for us as to when this meeting occurred?
It was in the middle of May, and the reason that I believe that it was between that period is because when the Office of the Attorney General receives an open records request for a ruling, the office has 55 days, up to 55 days to issue that ruling. The DPS ruling was due June 2nd. That was the 55th day. So we would have been discussing it in the middle of May before it was released on June 2nd.
Now, you made a minute. Was there already a draft opinion regarding the matter that was intended to be issued before July 1?
Yes.
Or was it June 1 or July 1? I've got...
June 2nd was the 55-day deadline.
And what was the preliminary opinion that already existed in the file when you started looking at it?
It was to withhold the information under the law enforcement exception.
Now, when you told the lieutenant, the Attorney General that you were available, how soon did you meet with him if you did?
It would have been a matter of days between notifying him and scheduling a meeting in his office.
You met with him in his office?
Yes.
All right. Was anybody else present in the meeting?
There were a series of meetings at which Justin Gordon, the chief of the Open Records Division, and Ryan Bangert attended.
All right. So at this first meeting, were they both present?
I don't recall if both were present, but there were just in this meeting and the subsequent meeting, they were both in attendance at one or the other.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement. He asked us to find a way to release the information that had been requested to be withheld.
And in your experience and your familiarity with the subject, what was your response to that?
Objection, hearsay.
It's not. This is the witness. This is his
Overruled.
response. Thank you.
I told General Paxton that if we were to reach the opposite conclusion and to require the Department of Public Safety to release the information, it would upset decades of precedent involving the law enforcement privilege, where law enforcement agencies rely on the protection that the Public Information Act gives it to protect ongoing information, to protect confidential information, to protect witnesses who could be compromised if their names or their identities were released. So there's incalculable problems with reversing the decision to withhold the information and require it to be produced, not just across the state, but with the Office of the Attorney General.
Mr. President, if I may, a lot of this is in narrative and not responsive to the question.
That is exactly responsive. I object to this.
Just state the objection, but sustain. Go ahead.
Thank you. What was your opinion, based on your experience, as the potential danger to innocent citizens who had cooperated with the police, thinking that would be confidential?
It could silence people who might ordinarily comply or speak to the police if suddenly their names or identities could be released.
So what was the Attorney General's reaction when you told him all? But first of all, the stuff that you just said, is that essentially, in a sense, the information you gave him in explaining what your position was?
Yes, sir.
Did anybody else speak up as well?
Objection, hearsay.
I asked if anybody else spoke up. That is
Overruled.
not. Thank you. Did anybody else speak up?
Ryan Bangert also spoke. I don't recall exactly what he said, other than that.
And what was the Attorney General's reaction to all this?
He, again, insisted that what had happened to Mr. Paul was wrong and that he didn't trust law enforcement.
And did he make any distinction about which agencies, or did he talk about all law enforcement?
It was specifically the FBI and the Department of Public Safety.
And did he say why he didn't trust them?
He said that he compared what had happened to Nate Paul to General Paxton's own personal situation involving the Department of Public Safety and the State Securities Board and the FBI.
Well, were you aware of who provided his security?
Yes, sir.
And who was that?
The Department of Public Safety.
Did he indicate in his comments what his level of feeling or trust or distrust about them was?
Not to me.
All right. Now, how long did when you expressed what his initial opinions were, did he go any further, or how did the conversation proceed?
He asked me if he could obtain a copy of the DPS file.
Had you ever been asked or know of any other time where the Attorney General had asked to see a particular file that it's a public information request for?
No, sir.
So what did you do?
I said that it was possible for him to receive a copy of the file.
And I believe you said this was around May 15th, did you not?
Yes, sir.
Did you provide him the file?
Yes, I did.
Did it have everything in it?
Yes, sir.
Did you take anything out of it?
No, sir.
Can you tell us whether or not in that file you had, there was any brief from the FBI weighing in as to their materials in the file and their position as to whether it ought to be released?
Yes, the FBI had submitted a brief in response to the DPS request.
What was the process or procedure within your department if you have a request for open records, people want to get some portion of it from another agency? What was your policy as to let the other agency weigh in?
The Public Information Act requires state agencies to notify the third party whose information may be at stake that they have a right to submit a letter ruling or a letter brief to the Office of the Attorney General for consideration.
So in these circumstances, would it be normal or unusual for y'all to have notified the FBI there was this request, that the request was to an agency whose files included FBI materials? Would it have been usual or unusual for them to let them know so that they could respond if they wanted to?
So in this situation involving the DPS request, the Department of Public Safety did notify the FBI that its information may be at stake in this request for a ruling. And the FBI responded by submitting a letter brief to the Office of the Attorney General under the ordinary principles of the statute.
Were you aware through these materials and looking through the file that there was an ongoing federal investigation of Mr. Paul at that time?
Yes, it was clear.
Did you take a position with the Attorney General that there was an ongoing, at least federal, I'm not including right now state because I have no knowledge one way or the other, but that there was at least a federal ongoing investigation of Mr. Paul that release of these documents would interfere with?
Objection, leading.
Sustained.
Did you inform him one way or the other about, did you have discussions with him concerning the topic of an ongoing federal investigation?
Yes.
And what did you tell him and what was said?
It's my recollection that there were discussions about the substance of the brief that the FBI had submitted, the quality of the arguments that they had raised and made.
And did this brief provide details of the ongoing federal investigation?
Objection, that will solicit hearsay, Your Honor.
No, I'm not asking for communication. I'm just asking whether or not it contained details about it.
May I be heard on that?
Yes.
Mr. President, so Mr. Hardin is asking the witness about the contents of some other document that is not currently in evidence, pretty much right down the fairway of hearsay.
I'm not asking for
I'm going to sustain, rephrase your question.
Well, I'm not asking you for specifics of what it said. I am only saying, were there documents and information in this file that were used as the basis of a conversation with the Attorney General concerning the presence of an ongoing federal investigation of Mr. Paul?
Yes, sir.
All right. Now, when you gave the file to him, how did that happen? You go to his office? What did you do?
I believe I delivered the file to Andrew Wicker, who was General Paxton's aide at the time.
And did you later confirm that Mr. Wicker gave it to the Attorney General?
Yes.
And how long was it? Will be some intervening events I'll ask you. Well, how long was it after that event that you retrieved your file from the Attorney General?
Well, as I mentioned, when the Office of the Attorney General has to make a ruling, it's on the clock. So we have a timeline. I was notified by Justin Gordon, the chief of the Open Records Division, that we needed to make a decision because the clock was coming up. It was approximately 7 to 10 days before that when I delivered the file to Andrew Wicker, and Mr. Gordon had emailed me asking for a status update.
And so then how long after, back to the original question, was it from the time you gave it to the Attorney General to you? Let me ask you this, was it ultimately returned to you?
Yes, it was returned to me.
And when was it returned? Approximately when was it returned to you?
I believe it was May 28th or May 29th.
All right. And in the meantime, were you part of any later conversations after the one you just relayed, in which you expressed your opinion, the Attorney General expressed his? Well, let me back up. In that second meeting, counting the first meeting being him asking you to look at the file, okay? The second meeting would be the one we just discussed. In that second meeting, did the Attorney General give you any indication as to what he wanted you to do?
Well, he wanted us to find a way to release the information.
And after you expressed yourself, Mr. Bangert expressed himself, the Attorney General expressed himself, in that second meeting, was there a conclusion as to what was going to happen?
No, sir, not that I recall.
All right, how did the meeting end up?
We were essentially at an impasse on our recommendation not to release the information and the Attorney General's decision to release it in some form. We told the Attorney General that we would review our options and follow up with him to see if there's anything else we can look at.
What was his position as to whether or not he wanted or thought the law enforcement exception should apply?
He didn't necessarily take a position that I recall other than something happened to Mr. Paul, it was wrong, this shouldn't be allowed for the FBI and the DPS to get away with.
All right. Now, after that, when was the next time you had any contact with the Attorney General on this matter?
Again, it probably was a matter of days after that, just in light of the timeline and the deadline. We followed up and let General Paxton know that we looked at it again. We didn't think that we could reach an alternative conclusion.
And who was the we in that part?
Ryan Bangert and myself.
And how did you let the Attorney General know?
We met in his office.
And do you recall when this third meeting was?
I believe it was toward the end of May.
And
Counselor, not to interrupt, we're a little past our mid-afternoon break. Is this a good spot, or do you want to go?
This is
You're fine here?
Sure.
Okay. We'll stand in recess until 3:30.
Okay, guys, so that was some fascinating testimony from Ryan Vassar. I thought, it was particularly interesting when he's asked, how did you make you feel, and I don't remember the exact question, when Attorney General Ken Paxton accused you of being a rogue employee. And I mean, hold on a second. Ryan? Oh, sorry. All right, we're making sure everybody's mic's on, guys.
I am.
So anyway, and he says, and he got emotional and basically said, let me find my notes. I worked for the for 8 years for the state of Texas, and he had a commitment, and you could just see how emotional he got at that statement.
He was in tears. I mean, he started crying, talking about his kids, really, about how he wanted to set anything.
Oh, we got to turn Katie's on. Sorry, guys, we've been up here too long, and we kind of lost track of whose mics are on and whose mics are not on. Well, hey, Mike, what did you think?
Yeah, I definitely thought that he showed real emotion there. From a trial lawyer standpoint, you want your witness to look like a real human being. You want them to not look rehearsed. Any emotion, you don't want it to look like fake emotion. If somebody's going to cry,
it felt very real.
Right. You don't want
real.
the audience to feel like, oh, crocodile tears, this is fake. I felt like that looked real to me. And maybe he's a really good actor. I don't know, but yeah, that came across as real.
It did not feel like an act.
I
it didn't to
thought
me.
he was surprised by how emotional he became.
Right.
That it caught him off guard.
Well, and I mean, look, regardless of how you feel about this, if you feel like I have an oath, I have a duty,
Right.
I take that very seriously. I could be in private practice making all this money, but instead I'm committing myself to government and whatnot, and then because I did what I thought was right, I'm being called a rogue and a traitor and
and this
disloyal.
is somebody that you respect and you believe in the values of what
You
they
share
say
the
they wanna do.
values, right.
Yeah. I think it's pretty fair to say that no one at the Attorney General's office currently or in the last 5 to 10 years is a liberal or anything like that. These folks are they all subscribe to the brand of conservatism that Paxton did, and I think that's why it especially hurts. It's one thing for somebody who's arch conservative to call a liberal a name, that's politics, right? But when you as the witness are saying, look, I'm one of you guys and you're calling me a traitor.
I think another thing that came up that was, I don't mean to step on your question.
No, you go ahead.
But
Go ahead.
was the description of the Attorney General as not trusting law enforcement.
Oh boy, yeah.
That was like, say what?
Yeah.
He is the chief law enforcement officer of the state.
Yeah.
Am I missing something here?
No, I think that's a point that's easily lost maybe by the general public because they hear Attorney General and they think, oh, he's the top attorney but yeah, he is the head law enforcement official in Texas. And all of the senators, the jury would know that. And so, when you are the top law enforcement officer and to say that you think you have no trust in law enforcement, you have no trust in Texas law enforcement, and I thought the question about who provided his security detail by Rusty Hardin was pretty crafty because of course it's the very DPS that are protecting his life that he is telling that people that he thinks are on a witch hunt.
And we haven't gotten testimony yet about how he was, ditching his security detail, which is going to come. I assume.
Right, it's going to come out. The
probably
Uber
when we hear,
account
if we hear from
and,
Wicker, probably from Drew Wicker, who was his kind of his. Like I don't know if they call it a body man, but like basically his assistant.
Yeah,
he was his guy.
Personal,
yeah. He said that he felt that Mr. Paul was being railroaded by the FBI and he didn't trust law enforcement. And Vassar said he told Ken Paxton that if they reached this conclusion that would have allowed the release of these documents, this probable cause affidavit, that it would upend decades of law enforcement principle, and that is true because the law enforcement exception, anybody that's filed an open records request knows that this is a pretty common exception.
Oh, absolutely.
And
for a lot of reasons. Privacy of people who are making complaints to the police, all sorts of reasons.
Well, and as a criminal defense attorney, I have tried to get my hands on police reports early, like any other attorney, and of course the Attorney General's office thwarts you at every turn. And so, yeah, it feels, and I think that's the point of the prosecution here, it feels especially convenient that Paxton has never felt that way in the thousands and thousands and thousands of times people have asked for probable cause affidavits.
I don't think I've never gotten any special treatment where anything I wanted was suddenly given to me.
But this person who's a donor, who's employing his mistress, who, all of a sudden that guy, that guy gets this special treatment, and that's the point, right? Of course, Paxton was quoted in that as saying he thought this was unfair to defendants and that they should have access to that. Again, as a criminal defense attorney who represents those very same defendants, I thought, oh boy, that would have been nice in the dozens and dozens of times I've asked for exactly that and been told, oh no. Of course not.
One of the things that Andrew Murr said, and he's the House impeachment, one of the House impeachment manager that gave the opening statement. He's a Republican. He's chair of that general investigating committee that investigated these matters. And what he said on day one, and I think I got to go back to it, is that he alleged that Ken Paxton had turned the keys of the office over to Nate Paul. Mm-hmm. And what it feels like is, systematically they are the prosecution is showing through the testimony how that happened.
Right, right. Yeah, it's definitely going to be the prosecution's job to show that these extraordinary actions that were completely unprecedented were taken for the sole benefit of Nate Paul and to the detriment of the people of Texas. And if they can do that, they've proven their case. And it's going to be the defense's job to show there's nothing to see here. This is a big misunderstanding. This is a witch hunt.
It's a plot.
Yeah, and if they can do that,
Right.
then they can win. But so far, and I as a defense attorney implore juries all the time to please keep an open mind, and there's two sides to every story, and they get to go first. Please don't make up your mind before you hear from us. So this isn't over by any stretch. But so far, the evidence that these are extraordinary actions and that they're unprecedented and that they benefit Nate Paul, it's been pretty compelling.
And I think another thing the narrative is showing that the defense is presenting is how the gradual realization of the breadth, the width of what Paxton was asking their office to do crept up on them very, very gradually, because their office, one, is big, and it was going into different.
Well, because he didn't say, I want the foreclosure order because I want
Right.
to help Nate
Right.
Paul.
Right.
I mean, Paxton himself has to have been aware that what he was doing was extraordinary. And I think the way he asked for things and the way he phrased them and the way he did a little bit over here and a little bit I don't think any of that was an accident.
Well, and it was happening in different areas. There were some
Right.
people like Bangert who seemed to have been touching more than one thing.
Because of his job, he
Right.
had
right.
access to know
well,
more.
and he had been over open records at one point, which is how he comes into contact with the open records situation, and he was involved with I think also the foreclosure situation and the midi foundation.
Midi
situation.
Foundation.
But he wasn't directly involved in Kamek, I don't think, but he was familiar with it.
But I think
because
that
he's up
was-
on the 8th floor, he's seeing
Right.
all this starting to go on. Of course, they eventually are going to have this meeting,
And that's what Tier was
they're
talking
going to have
about.
the come to Jesus meeting, so to speak, where
Yeah.
they're going to go. And
Wait
that
a minute.
happened.
Right.
Wait,
What's
and he
been
asked
happening?
you to do that? Yeah.
Right.
And again, from a criminal defense lawyer standpoint, I think it's exactly the right strategy for Paxton's lawyers to point out that didn't seem to strike you as odd at the time, and you didn't write that memo at the time, and you didn't go to the FBI right then. Trying to show that this was nothing and that you're making something bigger out of it. And
Right.
again, what the prosecution is doing, and I think, again, doing a good job, is to show that it took a while for these folks to realize what was going on. And
Because they weren't thinking, oh, we need to memorialize this.
Right.
Initially.
Well, they weren't thinking their boss would do anything wrong.
because they all, according to them, if you believe their testimony, they bought in, right? They believed in him.
These were true believers.
Right,
Yeah.
true believers. They love their boss, and they didn't see this coming. And so, I think watching the testimony that so far
They
that
feel
narrative
hurt.
is landing.
It comes through. They feel hurt.
Yeah,
Yeah. And
Yeah.
betrayed.
especially on the heels of two. You described the first witness as a little nerdy. The second witness was very polished and smart, and this third witness, although he's no slouch, he is. I think it's a good array of people. He's very personable. He had that emotive moment where he's showing real emotion. I think it's a good presentation so far.
And one thing we didn't talk about before Vassar got on, but this Anthony Oso, who works in Dan Cogdell's office, it felt like he went to a bit of a master class in lawyering as he's dealing with Rusty Hardin,
Right.
where he goes. Let me go back in my notes here. He says. And Hardin says, I didn't think he meant to say leading, not hearsay. And of course, Oso says, I did mean hearsay.
Yeah. Anytime one lawyer points out your objection, young man, which was kind of
Well,
the
that was
implication,
right. That was basically what he's saying.
Right, the unsaid
you whippersnapper.
thing, right. You got that wrong. Let me tell you what the right objection was, and I'll go ahead and give it to you. That was the tone of it, which,
Right.
I found funny. Look, all these guys are good lawyers. Rusty Hardin is a legend, and I think he's showing it there. The control of the courtroom. I noticed on the feed that Dan Patrick laughed. That clearly. It's one thing to make a joke in the courtroom. Sometimes that's appropriate. Sometimes that's not. But if you can do that, make the judge laugh. And you are showing a control of the courtroom. And for a trial lawyer, so much of lawyering is being the voice in the room that the jury can trust. Mm-hmm. And that is established by, not destroying your credibility,
And think
but,
how many
but
times
by being in
Hardin has
control.
said things like, let me help you with that
Yeah.
to the opposing counsel or to the judge. I'll get that for you. I
Yeah.
mean,
Yeah.
he's being helpful to them all.
Right. Right.
And
And
that's
that's
not
no
an
accident.
accident.
That's no
Right.
accident. Right. And the times that he's gotten testy, the way he presents it is, I've just lost my patient with this young man's incessant,
With the
ridiculous
whippersnapper.
objection. Right. Yeah, exactly. This whippersnapper's ridiculous
I mean, I almost felt like I
objections.
could hear him say it.
It really, right, yeah. And, look, Oso is defending his client. And he is lawyering. And nothing he's doing is wrong. This is trial strategy 101. And, sometimes every lawyer's different. Sometimes it's very congenial, it's very friendly. Other times it can be junkyard dog. I think Rusty Hardin is doing a very good job of showing the elder statesman control of the room and being that voice of reason, and then, having a little bite to his bark every once in a while.
Every once in a while. Yeah, just to don't forget.
Yeah, don't forget who I am. I don't have this
Exactly.
name
Yeah.
for
Yeah.
nothing.
Okay, kid.
Right,
Yeah.
exactly. Yeah.
And also, I think Ryan Bangert showed his chops too.
Mm-hmm.
One point when they're talking about this foreclosure order, and there's some discussion about this whole thing about settlement services and Paxton, and they also brings up, Ken Paxton had previously done real estate law, and he asked him about that, and Oso says, that's your opinion, sir, and Bangert replies, no, that's the law.
That's the law.
And I mean, it was like, whoa.
Yeah. I thought both Bangert and Oso scored points after lunch. I thought Oso's pre-lunch cross was pretty flat.
I agree.
Like you talked about, you think maybe he got a little locker room pep talk because he came out and he was firing. I think Oso did a good job in that cross of getting under Ryan Bangert's skin.
Which part would you say?
Well, especially in that whole exchange where it was a yes or no question and he asks it 20 times and Dan Patrick is on Oso's side telling him answer and he just wouldn't answer.
He would not answer it yes or no.
That was the
and never
one,
did.
Yeah, and that was the one time where I felt like he might have stepped out of bounds there and looked a little petulant himself. And kudos to Oso for drawing him into that. I would have, if I was the lawyer, calling that witness, I would have been sitting there thinking, oh, please, just say yes. It's a minor point. Just say yes. The more you struggle, the more you make this into something
It was
it's not.
almost like Bangert never wanted to say the word yes.
Right. Bangert really didn't, and Oso goaded him into that. And I feel like that was the one mistake Bangert made in his testimony. I think overall he was extremely effective.
And he recovered himself.
He recovered
after
well.
That.
He recovered well.
It was as if he realized,
Yeah.
and pulled back into that total professional demeanor that he had been maintaining.
But I don't want to be unprofessional or not unfair to Oso. We're talking about the elder statesman Rusty Hardin kind of giving a master class and making jokes about Rusty Hardin is treating Oso like he's some whippersnapper. Oso scored a good point there, and I thought that was effective and it worked.
But given the totality of Bangert's testimony.
That's right. I think Bangert's testimony was extremely
It's kind
effective.
of like
I don't think it erases
did you
it.
win? You won a point, but did you win the match?
Right. Exactly.
Right.
You know.
Exactly.
And Oso
Yeah.
clearly did not.
No, I don't think so. Not with that witness for sure.
Right.
And usually who is cross-examining witnesses is thought out well in advance. So I don't think it means anything that another lawyer is crossing the next witness. But it might not be an accident. Maybe they felt like Oso wasn't scoring.
We may get some sense of that if it's a different attorney every time doing the cross.
Right. Because we can't know. It's so easy. I've heard this in my trials. It's so easy for outsiders to think this means this and
Right.
that means that, and then you find out when you actually talk to the lawyers, oh, I was obsessed with this one fact and it had nothing to do with anything. So it could mean nothing.
I have covered. You and I sat together, Mike, and every time I think I know this is what's going to happen,
Right.
I'm never right.
Right.
Because you never really know what people are keying in on.
No.
And
no.
what they think's important, especially, and this is most certainly not your typical jury.
Right.
One thing, though, that in trials often happens is they tee something up because they're going to come back to it later.
Mm-hmm.
And maybe that has happened, but I have not seen much of that in this one.
I haven't seen it either.
They've teed things up, but then it's like it just kind of fell off the table
Well, it's like,
after a
I
while.
wanted Oso to come back to, okay, you think he's so corrupt, but yet your group that you now work for is taking cases to the Attorney General's office.
Yeah.
I wanted...
That would have really been a good
I really
point.
wanted him to just like
Exactly.
take the knife and dig it in.
And
think
I
it
was
was a point
waiting
there.
for that,
Yeah.
and he didn't do it.
It's like he started it. He started to go down the path, and then he said, go on to the next thing. And I was like, no, that's a good point.
Yeah.
If you think this office is so corrupt, you think it's led by this corrupt person.
Why did your own organization?
Right.
come
Why
in?
are you not?
Yeah.
Why are you not? Drawing that point out. Now, maybe you wouldn't like the answer, but it seemed like a pretty good point to be making.
Yeah, and a good, again, like we talked earlier about, one of the rules of cross-examination is to establish control, establish pace, and if you do that, then the answer almost doesn't matter. If the entire jury is looking at me because you're essentially just giving yeses and nos and that's all, and the story is coming from me, I don't care if you say yes or no, frankly, and so where Oso has not done well with that is he's not limited the witness to yes and nos. But so I wouldn't.
Well, and
be
even
as,
when he's tried, Bangert's just
Dug in.
Yeah, and I made that comment. He should have. I talked about it at lunch. He should have punished the witness for not giving him yes and nos early. He did it very well. There, we just talked about that. That was the 1 point he scored. Had he done that in the beginning, Banger's testimony might have been very different. If you teach a witness every time you do this, I'm going to make you look foolish, and the judge is going to admonish you, they put their tail between their legs a little bit. But once you let them embolden themselves, and they figure out the judge isn't stopping me from doing this, I'm in control. Once the witness thinks they're in control, that's a problem.
Well, and I think we saw that with Busby yesterday.
Yeah.
I mean,
we saw the flip yesterday.
Right, yeah. But
Yeah.
Busby was in control.
right.
That's right.
I mean,
Yeah.
that was him. He knew it from the second he opened his mouth.
Yeah.
Yeah.
It seems like that Dan Patrick, has gotten his sea legs to some extent.
Mm-hmm.
So his rulings are a little better
Right.
Yep.
overall. But also, I think it felt, I can't get into Dan Patrick's mind, but it felt like he got annoyed with Oso.
He did.
Yes.
But then interestingly, after lunch, and judges are human beings too. Sometimes they feel
Really?
like, I know
a few judges.
Yeah. So, sometimes judges worry, I'm giving too many calls, or maybe it looks like I'm giving too many calls to one side, and so they start to kind of give
Come
a
to
few
the
the
middle,
other
yeah.
way. Or maybe it was just Oso was doing a better job, but I noticed after lunch, between lunch and
They're
now,
much more sustained.
right, he's getting a lot of his objections sustained, and of course then the other lawyer came in, and I think the other lawyer's doing maybe a little better job with his objections, and that's why he got most of his sustained.
The other guy's not coming across as petulant.
Right, but their sustained rate was through the roof compared to before.
Right.
They
Yeah.
were 10%.
Oh, the difference in
prior to
approach
lunch.
between this current this current attorney, whose name I
I did not catch his
catch
name.
it.
I haven't
I'm
caught it
sorry.
either.
Anybody out there
I don't
on
have
YouTube
his
happen
name.
to catch that guy's name? I didn't catch it.
He seems just very businesslike. Just very. This is it. That's what I need, Judge.
Yeah.
And Patrick responds to that. He doesn't respond to eye rolling or big size. Or,
Most judges
Yeah.
don't. In my experience.
Well, and
It doesn't work well.
And Dan Patrick's deals with all the personalities in that Senate
There's
chamber.
a lot of personality in that chamber.
Yeah,
yeah.
exactly. Oh, yeah. I mean,
Right.
a lot
He's
of
used to a lot.
personalities.
Yeah.
So.
Yeah. And again, as a trial lawyer, there's no one right style. I was watching some of the comments, and people are expecting witnesses to be destroyed, or the lawyer's not doing well because he's not being dramatic. Some lawyers can destroy you as just as soft and quiet and unassuming as possible, and other lawyers come out super aggressive and they're completely ineffective, and vice versa, right? So the main thing for a lawyer is to know who you are and be yourself. And if you're a big showman, be a big showman. If you're understated, be understated. And so, at the same time, you have to, a good lawyer knows how to nudge themselves. I'm not going to become Rusty Hardin, or I'm not going to become, Busby, but if I recognize that something is working better with this judge or this jury, then I'm going to nudge myself that way. And I feel like this lawyer that's just started for the defense is doing a good job of that.
A manila envelope that was maybe a 1/4 inch or less in thickness.
All right, and was it actually contained in a manila envelope?
Yes.
So like have a seal, not a seal, but like a little closing up at the top?
A label.
All right. Did you keep it sealed, or is it just in a manila envelope?
It's just in an envelope, not with the flap on top, but just a folding manila envelope.
I got you. All right. Now, at this time, we are, I think you said somewhere around May 28th, is that right, when the file you're estimating was brought back to you?
Yes, sir.
And that would have meant when you said that you believed you gave it to him around when in May?
The middle of May.
So about, the math would say like 13, 14 days. But you give me what your figure is.
I would say May 23rd.
May 23rd when you gave it to him?
Correct.
All right.
And then when it was returned on the 28th.
I got you. So you didn't have it for about 5 days.
7 to 10 days was what I recall. I apologize for the math.
All right. So at any rate, that period of time, it was out of your possession to be in the possession of the Attorney General, correct?
Yes, sir.
All right. Now, when you got it back, so let's say toward the end of May, what was the next event or conversation you had with anybody, the Attorney General, concerning Mr. Paul?
The last meeting that we had regarding the Department of Public Safety file was that we did not recommend changing our conclusion to protect the information, but that there might be an alternative solution to take in issuing a ruling.
Why did you come up with an alternative?
General Paxton had asked us to find a way to release the information.
So who came up with a possible alternative?
Justin Gordon, who's the chief of the Open Records Division, had...
And what was that partial, that compromised position?
It was basically taking a position of no position. So we were not making a ruling saying to withhold the information, and we were not making a ruling to release the information.
Had you ever participated in that kind of position before?
No, sir.
Were you aware of it having been done before?
Not until Mr. Gordon suggested it.
Now, I'm not suggesting to you that never had it before happened in my question in the AG's office. I really am just simply asking, were you familiar with it ever having happened before?
No, not in the open records context.
All right. Now, well, what would be the implications of taking a position of no position? Would that be of any advantage to anyone, as opposed to declining to release it? Let's do this. Under no position, would there have been 3 possibilities then that you would be treating that request? Here's what I mean. Just to flat out, we're not going to release the information because of law enforcement. That would be one, would it not?
Yes.
Another would be release the information, give it to them as they request. That'd be one, right?
Yes.
And then in the middle of that would be take no position, correct?
That's right.
If you take no position, does that have any different consequences than refusing to turn it over?
Objection. Mr. President, calls for speculation on the witness's part.
Sustained.
All I'm really asking you, I want to try to ask you in a way that's acceptable. I'm trying to determine what is this, why do no position then as opposed to just you can't have it? What's the significance of no position?
General Paxton didn't want for it to appear that his office was aiding the Department of Public Safety or the FBI. And so by taking a position of no position, it was semantics, I suppose.
Well, what is your testimony as to whether if you say no position in terms of what you're communicating to people outside the agency as to the level of resistance you have to resisting?
Objection. Mr. President, calls for speculation on the witness's part.
Sustained.
Now, at any rate, was that the decision that was made?
Yes.
No position.
We were directed to take a position of no position.
And in these conversations and all with the Attorney General,
Yes.
had you expressed your position in being opposed to that?
Yes.
Had Mr. Bangert expressed his position of being opposed?
Yes.
Was there anybody else involved in talking about it with the Attorney General?
Not with the exception of Mr. Gordon, who had attended one of the series of meetings.
All right. And was Mr. Gordon have the same position as y'all did, even though he's the one who came up with no position?
Yes, my recollection is his initial review was very flattering of the quality and the content in the FBI's letter ruling.
Now, after that, did there become a separate issue from reviewing the file? At some time, did Mr. Paxton's lawyer's position, Mr. Paul's lawyer's position become, well, we want the unredacted FBI brief?
Objection. Leading and compound.
Well, I'll be glad to rephrase that. Let me give it if that's okay.
I'll sustain it and rephrase.
Thank you very much. So let's go back now. And we, in that file, was there a brief that had been prepared by the FBI saying why the documents should not be released to Mr. Paul?
Objection. Mr. President, asked and answered.
Overruled.
Was there?
Yes, there was.
And you got to speak in the microphone. Is your microphone on?
Yes.
Okay.
Yes, there was.
That's all right. And you're going to find you get tighter and tighter as the day goes on. You got to stay up there. I speak from experience, okay? In this particular case, did the FBI brief, what type of information was in the FBI brief if it was not redacted?
Objection, Mr. President. This calls for hearsay and the contents of a document that is not in evidence.
There's no hearsay at all here. This is simply asking what documents are. These are not communications. This is nothing.
Hold on 1 second. Overruled.
What type of documents were in there?
The FBI's brief.
I say in there, referred to in the FBI brief.
Right. The FBI's brief identified emails, text messages, strategic planning, staging locations for the raid in August of 2019. They identified the task force members. The brief identified a under seal probable cause affidavit that said it was filed under seal, and the FBI brief indicated that that seal had not been lifted.
And so, including all these, when we talk about that affidavit sealed, it was actually under seal at that time in a federal court, wasn't it?
That's what the FBI brief
So
said.
the federal judge has ordered it sealed. It had not been unsealed But if the FBI brief unredacted was released to the object of the investigation, that person would have all kinds of information that a federal judge had sealed, correct?
Objection, Mr. President, leading.
I'm asking just, is that correct?
Sustain, rephrase.
What type of information, without going into the details of the FBI, let me back up this way. In the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background and history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against its disclosure?
Objection, Mr. President. Once again, this is not, the witness's testimony is not the best evidence of the content of this material. Well, has not been entered into evidence, and it remains hearsay.
Your Honor, surely we can't keep that information from this record. I'm asking you simply of the types of information that was in there.
We'll overrule. You can ask for the types of information.
Thank you.
Limited to that.
So, I believe my question was, in the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background, history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against this disclosure?
Yes, that was all the content of the probable cause affidavit that I recall.
So, what was your understanding as to whether or not lawyers for Mr. Paul were asking for things to be disclosed by the Attorney General's office that a federal judge had refused to disclose and sealed?
Objection, Mr. President, leading.
I can ask it another way. Were you aware that a federal judge had placed these documents under seal?
Yes, sir. Based on the content of the FBI brief that indicated that the records were sealed and that the probable cause affidavit was identified as sealed.
So essentially, was the Attorney General of the state of Texas seeking to reveal to a person under a federal investigation the basis of the evidence so far that the government had against him?
Objection, leading.
Sustain, can you rephrase that?
Sure. Was there a clear clash here between what the judicial system had decided somebody that it should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people, if disclosed?
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
All right, so how did it proceed now about whether or not, by the way, by this time, can you give us a time frame where all of a sudden they're seeking the FBI brief?
I believe the request was submitted May 24th of 2020. So it was in the middle of our conversations about the DPS file itself.
All right. And did they, when they were seeking it, how long do you think it was before y'all provided an answer?
I think the answer was due sometime in July. I want to say that July 28th.
of their open records request for the FBI brief? Is that what you mean?
Correct.
Okay.
So if I can lay it out
Yeah, please.
on a calendar.
Please.
The DPS file was due June 2nd. The request by Nate Paul's lawyers to the AG's office for the FBI brief was received May 24th. I believe the deadline to issue that ruling was July 28th, just based on the 45-day or 55-day time period.
Mr. Vassar, if we do this in a time frame, what is your testimony as to whether or not the request for the FBI brief by itself came before the no decision on the release of the DPS file? Did it become before or after?
It came before, because the DPS decision was not issued until June 2nd.
All right. When the June 2nd position was issued, I believe that was what you said was the no decision. Is that right?
Correct.
All right. Now, anytime after y'all said no decision, was there any attempt anymore by people on that Mr. Paul's position, excuse me, was there any attempt any longer to get access to the whole file?
No, not to my knowledge. So just generically, under the Open Records Act, when the Office of the Attorney General makes a ruling, the parties have the right to appeal that ruling to the district court. I'm not aware if that happened.
That's another way. So to your knowledge, are you familiar whether or not after y'all said no to the DPS file on June 2nd, was there any attempt by Mr. Paul's lawyers to appeal that to a district court as they were entitled to?
I'm not advised of that.
And instead, did they move to be trying to get an unredacted version of the FBI brief?
It's the timelines are suspicious.
And they're suspicious for what reason?
Sorry, Mr. President, I'm going to object to the witness's speculation and unresponsive statement and ask Your Honor to strike it from the record.
Yeah, we'll sustain that and strike that from the record. You can ask any other question.
When you issued no opinion on June 2nd, was there in that no opinion a redacted version of the FBI brief?
No, sir.
All right. As of June 2nd, had they had access to the FBI brief with the probable cause affidavit setting out the basis for the search and arrest?
Objection.
Just give me just a second. I'm sorry.
Please.
Strike the word arrest. There wasn't an arrest. I didn't mean that. Go ahead.
Objection, Mr. President. Calls for speculation. I understand the question to be asking for what Nate Paul's lawyers did or didn't have, unless I misunderstood Mr. Hardin.
Objection sustained.
Would it change if I said he misunderstood me?
Give it a try.
All right, no problem. All right, now let's do this. What was the decision? Did you have any conversations with the Attorney General on the issue of releasing to Mr. Paul the FBI brief?
Yes.
How did those conversations happen? When? Where?
They coincided with our conversations about the DPS file, just given that the timelines overlapped.
All right, so can you estimate the time frame when you talked to the AG about whether to release the FBI brief?
I believe it was the last week of May.
And when you did so, what did you do? I mean, what was the decision? Can you tell me what the Attorney General said?
I had notified General Paxton that the office had received a public information request related to the DPS file, and it was a request for the unredacted FBI brief that the FBI had submitted.
And what was his response?
He asked to see a copy of the two briefs, the redacted version and the unredacted version.
Did you give them to him?
Yes.
What happened next?
We met maybe the next day, and he showed me the two versions that I had sent to him, and he had highlighted and circled and marked up some of the documents. And he stated to me that he didn't see anything in here that should be withheld.
Attorney General of the state of Texas, are you saying, actually went over the affidavit and the brief, all the information that was referred to in the brief, and made circles himself on it?
He marked up the copies of the letter brief that the FBI had submitted to the Office of the Attorney General.
And the Attorney General decided, what had been your advice as to whether it should be released?
Well, the initial step in that process would have been to notify the FBI that the office had received a request for its information.
Did you do that?
Yes, I did not personally, but...
Was it done?
Yes, sir, it was done.
And what was the status? Were you waiting for their response?
Yes.
What was did the Attorney General have a position about that?
On the response?
Yes.
So it was my understanding that there was a delay in either connecting with the FBI or the correct person to make a decision on whether to respond and how to respond. After a follow-up attempt to contact their office, I don't know the content of that conversation, but I know we made a couple of attempts to contact them.
And then when you were unsuccessful in figuring out who in the FBI to talk to, what happened then?
After mentioning all of these sequences of events to General Paxton, he directed us to let the brief go out.
And he had earlier told you he didn't see anything there was a problem releasing?
That's right.
Do you know anything about the criminal law or practice history that Attorney General might have been particularly informed about to make those kind of decisions?
Objection. Mr. President, calls for speculation.
No, let me rephrase it to make sure it's understood.
Sustain.
Do you know of anything that you've ever witnessed or observed in terms of knowledge, background, or history of the Attorney General to be making a decision about what law enforcement information should and should not be released?
No, sir.
All right. Now, when you released, are you saying that the Attorney General's office released an FBI brief, unredacted, to the subject of a federal investigation, in spite of it having pointed out that the information in there currently was under seal with the federal judge?
Objection, Mr. President, leading.
I don't think that's leading. I can...
Sustain.
Pardon me?
Sustain.
All right.
Rephrase.
Tell us exactly what the consequences and what he did when he ordered that brief to be released to the subject of a federal investigation.
So the decision to release the information was done under the Public Information Act in order to reach a decision that the office was required to make in response to a request for information. Based on what I recall, the absence of the third party responding or responding in time or informing the office that it didn't intend to fight the release resulted in a release under the act.
Well, would you have released it even if you were making the decision? Let me put it this way. You, as a courtesy, tell fellow law enforcement agencies this is under consideration, correct?
It's a required notice under the Public Information Act.
In your processes, are you allowed and able to review law enforcement information from another agency? And even if you don't hear from that agency one way or the other, do you have the authority to declare the law enforcement exception to apply and hold it back even if you don't hear from the other agency?
There are situations in the open records context when the Open Records Division may raise exceptions based on the information that it reviews that may not have been raised by the parties.
In this particular case, what was your position, even when you had not heard from the FBI yet? What was your position as to whether this FBI brief, unredacted, should be released to the subject of the investigation?
I believe that it should have been withheld just based on the content of the document.
And did you argue that position?
Yes.
Did you argue that position even when you had not heard yet from the FBI?
Yes.
And once that information is it released under any conditions, or can the recipient share it with anybody he wants to?
It's not released under any conditions.
So when you release law enforcement information through a Freedom of Information Act or public records request, once that information is out, if anybody wants to find out, what would be the possibility if anybody with larceny in their heart wants to know addresses, names, all kinds of personal information about law enforcement or witnesses? Would they potentially have access to it if the possessor wants to give it to them?
Objection, Mr. President. This is leading and calls for speculation on Mr. Vassar's part.
Sustained.
Mr. Vassar, are you aware that in September of 2020, a, quote, special prosecutor was serving subpoenas using the names and addresses of officials that appeared in the file that your agency released?
Objection, Mr. President.
Are you aware of that?
I'm sorry. Objection, Mr. President.
That is why this is relevant.
Don't talk to each other.
second.
What is your objection?
Objection. Assumes facts not established in evidence in this trial, Your Honor.
Your Honor, I swear to you under my oath as a lawyer, you're going to have that evidence presented. Now,
I don't have it now.
Pardon me?
We don't have it now.
I know that, but it's coming. My point being is I'm only asking him if he was aware the event happened. When he talks about evidence not be before the court as yet, I'm seeking to find out if he's aware how this information was used. He can say he's not aware, and that ends the inquiry. But if he says he does, it points out the danger of what exactly happened here in this case, which is at the heart of the major impeachment contentions that we have.
Mr. President, may I be heard?
Yes.
I have great esteem for my colleague. However, I promise it's coming is not a proper response to that objection.
Sustained.
Only this question. Was the type of information I talked to you about available then to the recipient once you released the FBI brief?
Mr. President, same objection, same horse, different question.
Still a legitimate question. The question was that available to the recipient? That's all. I haven't asked about anybody else you haven't heard information about. I'm talking about the person in this case, Nate Paul.
In this case, Counselor, I'll overrule.
Was it?
The information that would have been in the FBI brief is what would have been disclosed to the requester.
Thank you. Now, can I move on to was that the last contact? To your knowledge, did the representatives of Nate Paul make any more attempt after you released the FBI brief? Was there any more attempt to get the information from the DPS?
Not to my knowledge.
So what is your testimony as to whether or not, after you issued no opinion, but then released the FBI brief, was there any more attempt to try to get to a fuller file of DPS?
Not to my knowledge.
Thank you. And was there any lawsuit, to your knowledge, filed in state court to try to get it?
No, sir.
What did that indicate to you?
They may have gotten the information.
From some other way?
Yes, sir.
All right. Now, if we can, when's the next thing you had to do with Mr. Nate Paul?
Well, unknown to me at the time, Ryan Bangert contacted me on July 31st, which I think was a Friday, in the evening, and asked me about a foreclosure opinion.
Did you? And how did that come about? That was, but you remember what day of the week that was?
It was a Friday evening.
All right. And Mr. Vassar, what did you understand that your responsibilities and mission were?
So Mr. Bangert contacted me and told me that we needed to look into foreclosure sales.
And did you understand, who did you understand this was a request from, that you were asked to do this?
From General Paxton.
Do you recall where you were when you got the information?
I was at home.
And what did you do as a result?
I responded to Mr. Bangert over the phone and told him that I would look into it. I would give him a first draft as soon as I could.
Now, what time of day was it? Was it, first of all, what day of the week was it?
Friday.
And what time was it on Friday night that Mr. Bangert called you?
Between 5 and 7. I mean, it was.
And at that time, did you understand in response to the initial call there was any urgency one way or the other?
Yes, it was.
And when were you supposed to try to have this opinion?
As soon as possible.
What did that mean to you? No, it's okay. Go ahead.
I told Ryan that I would get him a draft sometime that evening, if not first thing in the morning.
All right, did you do that?
Yes.
And then what did you do the rest of the morning in connection with it?
Ryan and I spoke about the draft. He agreed with the initial conclusion, which decided that foreclosure sales should be allowed to proceed under the governor's executive order at the time.
All right, and were the two of you in agreement with that?
Yes.
About what time of day did y'all get a document that you thought was sufficient to send over to the Attorney General as a draft?
It was probably 11 to 12 on Saturday, that next day.
What's the next thing you did in connection with it?
Ryan called me not long after that, probably 30 to 45 minutes after he had sent it to General Paxton.
Were you aware as a result of that phone call whether he had talked to the Attorney General?
Yes.
And as a result, what did you understand your new mission was?
I understood that General Paxton said that we got the wrong answer.
All right. So the right answer had been what, in your view?
Well, based on the office's position on numerous COVID-related matters, we had erred on the side of opening Texas, not closing Texas or prohibiting people from gathering. We had issued a number of opinions relating to houses of worship, election issues, and schools, all of them encouraging opening, not closing it. So the initial conclusion was based on my understanding of the office's position throughout the summer.
And did you make a legal determination that went in line with what you believed the office policy was?
Yes.
And then what happened when you were told you had the wrong answer? What did you do?
I laughed.
Why did you laugh?
I just because I found out that I had gotten the wrong answer when I believed I had reached the right answer just based on the office's position throughout the summer.
All right, so then what did y'all do?
I told Ryan that I would take a look at reaching a different conclusion. I think he volunteered to do that and made modifications to the draft that I had sent him.
Now, you two guys are deputy chiefs of the whole office, right?
Ryan at the time was deputy first assistant, and I was deputy for legal counsel. Yes, sir.
Well, you were pretty high up in the food chain, were you not?
Yes, sir.
How often do you two write opinions?
Rarely.
Do you have any idea why the two of y'all were doing it rather than very capable lawyers underneath you in the litigation section?
I think it was a priority issue that General Paxton wanted someone to get it done as quickly as possible.
All right, so who did the main drafting this second time?
It was essentially the same shell of the first draft, and Ryan Bangert revised the conclusion to conclude that foreclosure sales should not proceed.
Were you aware of at that time any contacts that Mr. Bangert and the Attorney General were having in drafting the opinion?
I knew that Ryan Bangert was speaking with General Paxton.
And were you getting any kind of progress request or were you aware of how often they were speaking one way or the other?
No.
All right. And then was there any challenge to rewrite it?
Well, I mean, we had to go back and adjust the analysis to the extent we could, based on the position that we had taken initially.
All right. Now, once you completed it, about what time in the morning on Sunday did you complete it?
I spoke with Ryan throughout the day on Saturday after we were exchanging drafts and trying to reach an opposite conclusion. It's my understanding that he finished around midnight on Saturday evening.
Was he passing on to you, y'all discussing at that time any involvement in the Attorney General in the editing process?
I was not involved in any conversations directly.
That was going to be my next question. So during that entire evening that night, is it correct to say you were not dealing with the Attorney General, only Ryan was?
That's right.
Okay. Now, once it was produced, at any time during that process, did you have any idea whether or not this was something that would or would not benefit Nate Paul?
No, sir.
Did you later change your opinion or your sense of awareness?
Objection, Mr. President. This calls for speculation.
I'm only asking about his mind state. I'm not asking anybody.
Overruled.
Thank you. Go ahead.
Yes, sir. I believe Monday, I think it was Tuesday.
And what changed your mind Tuesday?
Well, foreclosure sales across the state are held on the first Tuesday of each month. So when the opinion was announced on our website on Sunday at roughly 1 a.m, a foreclosure sale was reported in the media to have been...
Objection, Mr. President. Any reports in the media would be obvious hearsay and inadmissible.
Sustained.
All right. All I'm going to ask you is, did news reports provide you information that changed your sense of awareness?
Same objection.
I'm not asking you what you heard, not asking you what you read, not asking you any hearsay or anything. Just simply, did news reports later change your sense of awareness, whatever that was?
He's just asking about did it, not what was in them. Overruled.
Yes.
All right. Now, at the end of the day, did whatever that opinion was, did that concern you? And if so, why?
Well, not at the time. It was odd, but it wasn't concerning because at the time I had no context for who was involved or what it was for.
And then once you did have a context about who might be involved, did that change? What was your reaction to that?
It was even stranger that we would have gone through that effort to become involved in a potential Nate Paul related issue involving foreclosure sales.
Okay. Now, after that opinion was done, did you have anything else to do with anything that Mr. Nate Paul and his businesses did, whether it was later bankruptcy or any other events? Did you know anything else? Do you have anything else to do on that front, on foreclosure front, with Mr. Nate Paul or his affairs?
No, sir.
All right. Now, let's go to the final area I want to talk to you about. Was it tell us what your responsibilities were if somebody above you or below you wants to do a contract with an outside lawyer. Let's start here. What was the policy generally of getting outside law firms within the agency? How would that happen ordinarily?
So ordinarily, with an agency of 800 lawyers and 4,000 employees, there are sometimes a need to retain outside counsel. That could be because it's a specialized area of law. Maybe it's intellectual property law, where the Office of the Attorney General doesn't employ IP lawyers. It could also be a local counsel issue. If the state of Texas wants to intervene in a Virginia case, the office would need local counsel. So there are unique instances where we would have engaged outside counsel to represent the agency. All of those requests are managed by the General Counsel Division, which I oversaw in my role as Deputy Attorney General for Legal Counsel.
Well, now, how often in your memory have you ever recall outside counsel being retained to do a criminal investigation?
None.
Ever?
No, sir.
All right. And why is that?
Mostly just because the prosecutors and the attorneys in the office would handle that work.
So when did you first become aware that the Attorney General wanted to hire an outside law firm for a criminal investigation regarding the complaints of Nate Paul?
Well, the first time that General Paxton contacted me, I believe, was in the middle of August of 2020.
And what was the nature of that contact?
He wanted to know what the basic process was to retain outside counsel.
What did you tell him?
I told him exactly what I just explained to this chamber of there has to be a request, there has to be a specific need. The attorneys have to be vetted to ensure that there's no potential conflicts of interest. And there's a formal approval memorandum and a outside counsel contract template that is signed by the attorney and the Office of the Attorney General.
So can we have our exhibit 160, please, Stacy? Is that not in evidence? All right, we moved into evidence 160. Thank you.
No objection at all, Mr. President.
Show 160 be admitted into evidence.
Now, I represent, well, you tell me, what is exhibit, do you have a hard copy?
It's on the screen right now.
Okay. Do you recognize what it is?
I do. It's an email from myself to General Paxton's Proton Mail email address dated September 3rd of 2020.
Now, it's a different type of email address than the official Attorney General email route, isn't it, or is it? What is a Proton address?
I'm not sure. I believe it's a private email service.
Well, it's been suggested by his lawyers that that's very frequently used in your organization. Is that true? And there's a Proton email address in addition to your official one, very commonly used with the people in the office.
Objection, Mr. President, lack of foundation, and calls for speculation by Mr. Vassar.
No. They can't do what they did. You heard the cross-examination in this kid talking about how common and ordinary it was and everything. Surely I'm allowed to ask this witness if that's true.
Mr. President,
That's all I'm doing.
I'm sorry, Mr. President, I believe we've invoked the rule and perhaps should not be talking about what other witnesses testified to with this witness.
I was getting ready to say that.
Pardon me?
I was getting ready to say that.
Yes.
Sustained, and you should not be talking about other testimony given in that specific instant.
Well, let me ask you. If one were to contend it is commonly used within your agency to have a Proton email address, would that be accurate or inaccurate?
Objection, Mr. President, calls for speculation.
Your Honor, this is really...
Yeah, overruled. Go ahead.
Thank you.
Not to my knowledge. I've never, not to my knowledge. It would not be ordinary to me. I am not even sure what it was.
Yes, I'm not trying to suggest it's never done, but in your experience, have you frequently or infrequently been dealing with official business in your agency with the Proton email address?
Objection, relevance.
I asked whether he...
Overruled.
Yeah, thank you. Go ahead.
No, sir.
All right.
This could be the first time that I had used that email address for General Paxton before I hadn't seen it before.
How did you know to use it here?
I think I asked him for his email address that he wanted me to send the contract to, the draft.
The General himself?
Yes, sir.
So are you saying that 5 years you've been there, this email address is the first time you ever used it in dealing with him?
Objection, leading.
I'm asking, just try to be clear.
Sustain the objection, but rephrase.
Thank you. In this particular case, do you recall when he gave you this How did he ask you to do it, first of all? Did he call you, drop in on you, or how did this happen?
The first time was a phone call when he asked about the basic process for retaining outside counsel. The second, he came into my office on September 3rd, and he instructed me to draft a contract for Brandon Kamek.
And then did he tell you at that occasion where to send it?
Possibly. If I didn't follow up with him to ask him, he could have instructed me in my office on that day of where to send it.
Ordinarily, if you sent it to his regular official agency email address, who would have access to it?
I believe the assistant has access to his email box. I don't know if he had access.
Would this Proton address be on access? Would other people be? Is there any way other people would be aware of it or ultimately run into it? If you sent something at this address, does that become available to others, or would it be only to the user of this email?
Objection, Mr. President.
If you know.
Calls for speculation, lack of foundation, assumes facts not in evidence.
I'm not asking for any. I don't know what facts are not in evidence I have talked about. I simply trying to find out is if this is used, would that then be restricted in availability to the Attorney General? That's all I'm asking.
And Mr. President, what I will renew is my objection that there is no foundation laid for Mr. Vassar to know anything about what the other agency employees can access or cannot access.
Sustained.
Now, when you sent him this contract, did you draft anything in there that was a little different?
Well, I drafted the scope of work.
And when the Attorney General asked you to do the draft, was anybody else around you when he asked you to send it?
No, sir.
Did he describe to you what he wanted this person to get a contract for?
Yes.
What did he tell you?
It was my understanding that Mr. Kamek was being hired as a second set of eyes, if you will, to review the Travis County District Attorney's referral of the complaint involving Nate Paul.
And had you been ever asked to do that in the criminal law area before?
No, sir.
When was the last time you had done an outside agency contract for somebody to do a criminal investigation?
I can't recall one.
Does that mean you don't remember any?
That's right.
All right. So when you did that, did you pay attention to a particular concern as to how to limit the scope of work?
Yes, sir.
Why did you do that?
Well, the referral from Travis County used specific language about providing assistance to Travis County.
Did you look at it at the time, the referral?
The first time I was given a copy of the referral from Travis County was September 3rd.
Were you aware at that time, one way or the other, of any conversations and disagreements that had been occurring internally as to whether Mr. Kamek should be hired to do this? Were you aware through talking to other people or any other source?
Objection, Mr. President. That response would call for hearsay.
I've not asked for the statements yet. I've asked if he's aware of anything.
I'm going to sustain. Would you re-ask the question?
Thank you. So, at that time, were you aware of any other concern about this matter, namely Mr. Kamek being hired to review a criminal investigation or whatever the assignment was? Were you aware one way or the other as to whether there was any opposition by other people in the organization to hiring Mr. Kamek for this project?
Objection, Mr. President. That would be derivative of hearsay.
I have asked simply whether he's aware
Overruled.
Thank you.
He can answer.
Are you?
Yes, sir.
Is that another reason you wanted to be cautious?
Objection, leading.
All right, that's fair enough.
Sustained.
Are you? Thank you, Judge. Were you, because without going into what you said, had you had conversations before September 3rd with the Attorney General about this matter?
Yes, sir.
When did you have your first conversation with him about it?
The first time would have been when he asked about the basic process. That would have been around August 15th.
And at that time, did he talk to you at all about what he had in mind?
No, sir. It wasn't until the week of August 26th, I believe, when I was on vacation, General Paxton called me and asked me to explain the process, the basic process, to two individuals.
Did he mention Mr. Kamak's name?
Yes.
What did he say to you?
He just asked me to contact both of the individuals, explain the process to them, and that these were the two individuals that...
The other person, why two individuals? Was there somebody else under consideration?
There were two names that General Paxton gave me.
And what was the other name he asked you to prepare a potential contract for?
Joe Brown.
All right. Mr. Joe Brown had been a previous U.S. attorney, had he not?
Yes, sir.
All right. Now, so did you prepare a contract like we just introduced for both Mr. Kamak and Joe Brown?
No, sir.
All right. Whom did you prepare the contract for exclusively?
So the only contract that was prepared in this matter was for Brandon Kamak.
And why did you not do one for Mr. Brown?
Based on when the Attorney General came into my office on September 3rd and directed me to prepare a contract for Brandon Kamak, it was my understanding that there was no longer any need for a contract for Mr. Brown.
All right. I want to take the contract now. Stacy, if you could put up, I moved to introduce 160. I'm not sure I got a reaction one way or the other.
Mr. Hardin, you admitted it.
Thank you.
Yes.
Yeah, it's admitted.
Thank you, Your Honor. I want to move on this contract of September 3rd over to the addendum. Can you go to the next to last page, which says Addendum A? You have that?
Yes, sir.
And is there a portion of this contract and this addendum that you can direct the court and the jury to that will show how you tried to restrict the scope of activity in this contract?
Well, and again, this was all drafted based on my understanding of General Paxton's decision of what Mr. Kamak should be doing, as well as the conversations about the Travis County referral and the extent to which it authorized our office to assist. You can see that the first paragraph specifically refers to certain criminal violations made by state and federal employees. So there's a singular referral that this contract is referring to.
It says, does it not, that this is to be a review of the allegations, correct?
That's correct.
One could review the allegations just by looking at them, right?
That's right.
Object to the sidebar. Move to strike.
It's not a sidebar, it's a question, Your Honor.
You can strike the word right.
Okay. And a review of the allegations, which include complaints of potential criminal violations made by certain state and federal employees. Were you aware at that time of any of the details of what was in Mr. Paul's complaint?
When I drafted this scope, that was the first time that I received a copy of the referral and a copy of the complaint.
And when you looked in the referral, when you looked at the documents that Mr. Paul had provided the Travis County DA's office and that they sent over to the Attorney General's office, what type of allegations did you note as to what type of people and conduct this young man was to look into?
Based on what I recall, Mr. Paul had alleged that certain members of the FBI and the task force, the Department of Public Safety, may have taken his phone from him or not allowed him to contact his attorney. They may have damaged property, searching through evidence. I don't recall the specific nature of the allegations other than just...
Were there allegations about improper conduct by a federal magistrate?
Yes, sir.
Did that give you pause?
It did.
Well, all right. So when you see these kind of allegations, then how did you draft it to try to take care of that, in your opinion?
Well, the last paragraph refers to conducting an investigation under the authority of the OAG, which would be derivative of the complaint, which is to assist. Towards the end of the paragraph, it explains that notwithstanding anything else, outside counsel should only conduct an investigation consistent with the complaint and only as directed by the Office of the Attorney General, meaning that any activities that he wanted to pursue should have been authorized and approved by the office.
And in it, as the way you structured this, do you make any reference in there to this man becoming a special prosecutor?
There's a plain exception that says that the legal services under this contract do not include any other post-investigation activities, including but not limited to indictment or prosecution.
So, as you believed when you drafted this contract and circulated it to be approved by others, what did you think this contract was setting out, giving him the authority to do if it was approved?
In short, he was to review the allegations in the complaint, the statements in the complaint, prepare a report that would be returned to our investigators to provide a second opinion to General Paxton.
And those investigators of yours would have been of who? Who would they have been turned over to?
David Maxwell and Mark Penley. David Maxwell was the director of law enforcement at the office, and Mark Penley was the deputy attorney general for criminal justice.
Did you have discussions with the attorney general that this is what he was authorized to do? Or did you have any, first, did you have any conversations with the attorney general about this?
Yes.
About this restriction?
About the nature of the services that Kamek was being hired for, yes, sir.
What did you say to him?
I just explained that we can't, the OAG, the Office of the Attorney General, cannot ordinarily engage in a criminal investigation except for a referral, a case of a referral. General Paxton explained that he had a referral from Travis County, and then I explained that even under a referral, we wouldn't have an outside counsel representing the agency in a prosecutorial role.
What was his reaction?
He didn't have one that I recall.
All right. And so then, after you have done this, what kind of process it was supposed to go? When you sent this to the Attorney General, did you get a response from him?
No, sir.
Did you hear back from him on this?
Not that I recall. When he asked me to send him a draft of the contract, he also asked me to send it to Brandon Kamek.
Well, so if I can, I move to introduce 161, please.
I don't see this on our list.
I'm moving to introduce it. I believe it's not in evidence.
Okay.
No objection, Mr. President.
Stella, can I have a hard copy, please?
There are no objections when you receive it, Mr. Harden, you may.
Thank you very much.
We'll admit 161 to evidence.
Thank you.
Thanks.
Now, would you identify this for me on September the 3rd? Now, this is, I'm sorry, Your Honor, may I have just a second? Mr. Vassar, I want you to look at 161. I want you to look at 161 and see if that is basically the same document that you had sent the same day on September 3rd, except that this one is to Mr. Kamek. Is it the same document?
Yes, sir, that's right.
All right, so now you have forwarded a contract to Mr. Kamek and the same contract to the Attorney General. But what all would be necessary to happen before this became a true contract and Mr. Kamek authorized to work for the Attorney General? What would be necessary?
So ordinarily, when the Office of the Attorney General wants to engage an outside counsel, that has to be approved internally through what was referred to at the time as an executive approval memorandum. That memorandum would explain the background of the request, the nature of the legal authority through which the agency could act, and the amount that was likely to be expended.
All right. In this situation, if you're going to go through the matrix for the contract, would you explain on this type of procedure what would it be the process? How many people would have to approve of this?
I'll run through them very quickly, but generally the process would start with the General Counsel Division Chief. It would next go to the Financial Litigation and Charitable Trust Division. Budget would be next. I believe I would be next in line as the Deputy Attorney General for Legal Counsel. Given the nature of the services involved criminal justice, Mark Penley, the Deputy Attorney General for Criminal Justice, would have been next. I believe Lacey Mays was next.
Well, in y'all's process, what happens if anyone along that chain refuses to accept it or approve it? What happens?
Basically, the request is denied, but it could be revived based on further conversations.
All right. In other words, everything stops if somebody declines until at least it's talked about more? Is that what you mean?
Yes, sir.
All right. So what happens if the Attorney General goes out and unilaterally hires somebody without sending it through the process at all? In your opinion, could he do that?
Yes, sir.
All right. He has the authority, right?
Yes, sir.
He's the guy. Okay. Now, if in fact, are you familiar with why y'all follow those processes, though, that you just described that would be in the ordinary situation? Why do you do it that way?
Mainly for efficiency purposes, but also just to ensure that each decision is vetted by the divisions that may have input or advice on the specific issue.
So are the people that are put on there division heads of the divisions that are affected by the contract?
Yes, sir.
So in this contract, what all divisions would be affected that would have to okay it?
The General Counsel Division, the Financial Litigation and Charitable Trust Division, the Budget Division, myself, the controller, the agency controller, the Deputy for Administration, the Deputy for Criminal Justice, the Chief of Staff, and the First Assistant.
It's like 8 people, isn't it?
There's a lot.
Hey, thanks a lot. All right. Now, let me ask you, in the emails that we looked at, or in this document, 161 is a contract, earlier some emails where we looked at 160, 160 is the contract that goes to Mr. Paxton. 161 is a contract that goes to Mr. Kamek. Is that correct?
Yes, sir.
And then you go, if you want, 228, contract 228. Contract exhibit 228. Well, hold that, please. Don't put that. Hold on. I'm sorry, Shelley. I apologize. I want to ask you I want you to look at 166. I believe this is already in evidence, Your Honor, because I think it's already been up on the screen once.
Yes, it is.
Thank you very much. 161. Now, I want you to look at this and describe for everyone whether this sets out the approval level it has to be done. Does it?
Yes, sir.
All right. Now, this is the contract that is to be the process to get Mr. Kamak's contract approved, correct?
That's right.
So it starts out with Joshua Godby, the Charitable Trust Division. Why would he have to approve it?
So the Financial Litigation and Charitable Trust Division manage the Office of Attorney General's outside counsel contracts.
Do y'all ever approve a contract that hasn't been the agreement to fund it? Who has to agree to fund it?
The Budget Division has to approve funding.
All right. Let's go up. Then Josh Godby, after him is Ryan Vassar. Who drafted this particular document?
I did.
All right. And how did you know what to put down here under the synopsis and background?
Just based on my understanding, again, of the nature of the services that Kamak was being engaged for.
Excuse me.
Mr. President, I believe there may be some distrust over whether this document is actually in evidence. We do not object to it. It has not been offered.
Yeah, we're just re-looking at that now. So it was not entered, but you do not object. Is that correct? Pardon?
Not.
Okay.
I believe it was shown by an earlier lawyer on your side. I think you had
it was a pretrial issue that didn't come in.
We're good.
But you're good. Go forward.
Thank you very much.
You did not
Joe.
object.
No, thank you. Thank you very much. Now, let's...
Excuse me, for the record, 166 is admitted to evidence.
Thank you very much. Now, so you prepared over on the second page, or it says page 1, but second when you turn it, the synopsis of what happened in the background and all of that?
Yes, sir.
I want you to tell us in your own words, when you sign off and initial this particular contract, did you sign off as if you approved it?
Yes.
All right. Why did you do that?
I concluded, based just on my position of whether the agency had lawful authority to hire an outside counsel, Brandon Kamak, in this situation, that it did.
So you understood who wanted to hire him?
Yes.
Who was it?
General Paxton.
Describe it in your own words. Did he make clear he was going to do it?
Yes.
So did you have any doubt whether or not that's what he was instructing you to do?
No, sir.
When you draft it, put a synopsis and initial it. Tell us in your own words, what was your position then as to whether this contract should or should not be approved?
So based in my position as Deputy for Legal Counsel, my role was to recommend based on whether the agency had lawful authority to act, not whether it should act. So in my review, I determined that Kamak, as outside counsel, could provide legal services to the agency to investigate or to review the complaint referred by Travis County.
And what would be your position as to whether he had the authority if he stepped outside the scope that you had drafted so carefully in the Addendum A?
Objection, Mr. President. That would call for speculation.
Sustained.
Was he authorized to do more on behalf of the Attorney General's office than you set out in the Scope A of the contract?
Not in the draft that I wrote.
All right. Now, when you sent these two contracts, or these proposed contracts, that you've just raised an issue right there. Were these drafts or were they final contracts?
They were both drafts.
So at the time you sent these out to Mr. Kamak and to the Attorney General, what was necessary to make them a binding contract where the Attorney General's office had actually legally hired Mr. Kamak? What process was required?
Objection, Mr. President. This actually calls for a very important legal conclusion. And this witness is not qualified to reach that conclusion on the ultimate issue.
I'm asking him what process within his organization was necessary for it then to be, at least him to consider it, a complete contract with the agency. Let me put it that way.
That is a different question than the one you asked.
So I'm going to sustain the first objection. I'll sustain.
But he's allowing the second one. Is that
well? You can start the second one now.
Thank
one
you.
More time.
Thank you. So what was necessary in your mind as the person responsible for both drafting and initiating these contracts to make the drafts you sent to Mr. Kamak and to the Attorney General what was necessary to, as far as your procedures and your experience and in your opinion, to make it a contract that would, where Mr. Kamek was actually officially hired and entitled to be paid under the contract?
Objection, Mr. President. That question is extremely compound. There are several questions in it. Procedures, policies, his opinion may be very different things.
Sustain.
The contract that you sent, had it been signed by anybody?
No, sir.
To be a binding contract as far as you were concerned and the agency and your responsibilities, whom did it have to be signed by to be a binding contract?
Under the agency's signature delegation policies at the time, it would have been Jeff Mateer.
All right. And if the contract at that time was signed solely by Mr. Kamek, do you have a contract, or does it have to be signed by somebody that can bind the agency along with Mr. Kamek?
It would have needed to be signed by the agency as well as funding obligated to pay for the services.
So did we ever get to that process that you were aware of at this time?
It was started. I believe June 4th, we started the internal approval process.
And that's the internal process. It's circulating it to the people on Exhibit 166?
Yes, sir.
Just to correct the record, the witness said June 4th. I believe you mean September 4th. Is that correct?
That's right. September 4th.
I'm sorry?
Let the record reflect September 4th.
Okay. The cover sheet would be 166, would it not? The contract, I believe, were the 164. 161, I'm sorry. I just want to make sure we got it straight.
Oh, I'm sorry. Were you talking to me?
We've got 166.
Be best to speak to the court.
166 is what I introduced that you accepted. And that's a copy of the approval sheet. And that's what I was asking. I'm sorry, that's what I was asking about.
Don't talk over each other. Yes, sir.
166 is on the screen and it has been admitted.
Pardon me?
You can continue, Mr. Hardin.
I'm sorry, I'm all confused.
166 has been admitted.
Right.
166, correct?
And I thought you were changing the number on me.
I'm sorry, I'm confused by your statement. Maybe this would be a good time for a break.
All right.
In about 15 more minutes. About 15 more minutes, we'll have a break.
All right, thank you. So let's try to move through this real quickly. Did this start going through different procedures, and what was the outcome of this contract? Did it ultimately go all the way, or did it stop somewhere along the way?
It stopped
the approval process. And where did it stop?
Mark Pendley declined to sign the approval memorandum.
And when did you become aware that Mr. Pendley would not sign it?
I don't recall the exact date. I recall there were conversations that when I signed it, it would go to Mark Pendley next. I advised Jeff Mateer that that was going to be the next line in the sequence. I also advised Mark Pendley that he was going to be next after I signed it. I don't recall exactly when Mark Pendley declined to sign.
I think there are other documents that we can introduce later that would show that. We'll do it through other people. As to your involvement, Mr. Vassar, how would you view your role once you started sending out the drafts? Did you start having contact personally with Mr. Kamek, where he would have several different requests that you would communicate with him, or what?
I was the point of contact for Mr. Kamek just based on the introduction through General Paxton. After the internal approval process had started, I received a call from Mr. Kamek. I believe it was around the 13th of September.
What did he want?
He asked if there were any official documents or an official email address that we could give him.
And at some stage along the line, were there inquiries about whether he was going to have inquiries by him as to where he was going to have credentials?
I'm sorry, could you say that?
Was he going to have credentials? Did that ever become an issue that would show that he was authorized to work on behalf of the AG's office?
No, sir.
Did you ever provide him any?
No, sir.
Did he ask you for any?
He did on that phone call.
And what did you tell him?
I told him that he didn't have a contract yet. I didn't understand why he needed credentials to identify himself as representing the agency.
All right. Were you aware, what was your level of awareness as to whether Mr. Kamek, or belief, was authorized to be speaking for the AG's office before this process was completed? What was your belief?
He had none. He had no authority to represent the office.
In your opinion, when would he have had authority to represent the office?
When?
Yes.
When he had a binding and executed contract.
And did he ever, to your knowledge, have a binding and executed contract?
Objection, Mr. President. This once again calls for a very important legal conclusion that goes to the heart of the matter.
I'm not asking him for a legal conclusion.
Witness can answer the question if you know of your own personal knowledge, not on hearsay.
On October 2nd, I believe Brandon Kamek sent a contract that appeared to be signed by General Paxton and Mr. Kamek himself.
Do you know when you first saw that?
I believe it was October 2nd.
Is that the first? Describe for us. Were you aware before, any time before that, that General Paxton had decided to sign the contract on behalf of the Attorney General's office?
No, sir.
Did you have any idea at that time when you saw it on October the 2nd, how and when that happened?
No, sir.
Did Mr. Paxton ever tell you that he had signed a contract personally with Mr. Kamek?
Yes, he did.
When did he tell you that?
I believe it was Friday in October, which may have been the 3rd. He emailed me and informed me that he had signed the contract with Kamek and that there had been a mistake in Jeff Mateer's letter terminating the contract as an invalid agreement.
We need to jump ahead a little bit for this particular portion. You're aware, or you're not, that, well, let me ask you, do you recall what date you and a group of people went to the FBI to report your concerns?
September 30th.
All right. And are you aware then when you all informed the Attorney General that you had done so?
October 1st is when we notified General Paxton.
And after you informed the Attorney General, did it sometime on the either September the 30th or October 1, had Mr. Kamek been sent a cease and desist letter?
Yes.
And whom did he send a cease and desist by whom sent him a cease and desist letter?
I believe Mark Penley sent a letter to Mr. Kamek, and Jeff Mateer sent a separate letter to Mr. Kamek.
And then separately was action taken in the courts concerning the subpoenas, grand jury subpoenas, that Mr. Kamek had obtained and was serving. Was there separate action undertaken by either Mr. Penley or Mr. Mateer?
Mr. President, we object as to leading.
Are you aware of anything?
Abstain.
Excuse me. Are you aware of any action that had taken, personally aware of any action that was taken in the courts concerning the subpoenas that Mr. Kamek had been serving?
Mr. Penley moved to quash the subpoenas.
All right. And so then when you get a letter, did you get a letter from the Attorney General? And if so, what date that was, or text?
It was an email indicating to me that he had signed the contract with Brandon Kamek and that Jeff's letter telling Kamek to cease and desist was improperly sent.
All right. At that time, during that first week in October, when we got to October 3rd, what was your status with the agency?
I was still employed.
And had Mr. Mateer resigned the day before, October 2nd?
October 2nd. I believe he resigned on Friday.
All right. When he resigned, had he sent a letter to Mr. Kamek before that, if you know?
Yes.
And at that time, were all of these actions being done with the involvement of each of you deputies that had been called colloquially the whistleblowers?
Yes.
Now, before that, when this contract, what was your involvement as far as the contract for Mr. Kamek once Mr. Penley refused to sign off on it? What happened then?
From what I recall, Mr. Mateer and Mr. Penley sent a cease and desist. Mr. Kamek followed up to our agency mailbox, just the general mailbox, with invoices that he had purported to work under some authorization from General Paxton. Because we didn't have a record of a contract or a copy of a signed agreement, we informed Mr. Kamek that we could not pay him, and his response was that he had a signed
What
contract.
date was that?
I believe it was October 1st.
All right. And during the time that you were going back and forth with Mr. Kamek about the contract, were you the person that was communicating with him?
He had emailed me directly, but the rest of the conversation was through the general mailbox that he is.
Did he send you an invoice seeking to be paid?
Yes.
Do you recall when he did that?
It was right around the same period, so it would have been October 1st.
And when he sent you an invoice to be asking to be paid, what was your response?
We informed him that we did not have a record of a contract under which to pay him.
And did you tell him you need a contract signed by somebody within the agency?
Well, we just told him we didn't have any contract with his name on it.
That had been signed by anybody?
Correct.
So what did he do?
He responded and said that he had a signed contract.
Do you recall what date he told you that he had a signed contract?
He provided it to us in the morning. I believe it was October 1st. Or no, I apologize. It was September 30th because we went and met with law enforcement on September 30th.
And did you get a contract from him that had been signed by the Attorney General before you went to law enforcement?
Yes.
Now, at the time this was all going on, were you willfully and totally involved in the actions that were decided and that led to you going to law enforcement?
Yes, sir.
Why did you go?
I formed a conclusion, just based on my good faith belief.
Keep it to the microphone.
That General Paxton was using the power and authority of his office to benefit a private individual.
And what was your opinion as to whether or not y'all had done everything you could to stop him before that?
Well, all of these sequences of events, ranging from May of 2020 to the foreclosure letter in late July and August of 2020, and the Kamek issue in August and September of 2020, in isolation were just activities that we tried to handle for General Paxton.
Mr. President, I'm sorry, I must object as non-responsive to the question.
Well, let me continue
Sustain.
with you.
Re-ask the question.
Thank you. Now let me ask you this. What was your state of mind in terms of the degree that you, in your opinion, of the degree and you and others had engaged in to try to dissuade him from this conduct that you disagreed with?
We had repeatedly suggested that the positions that we were being asked to take were contrary to established law and policies. When we did that, he directed us to find a different way. So as lawyers do, we found alternatives, and those were the alternatives that he chose.
Well, then what was the tipping point about September the 29th or 30th that led you to decide to go en masse to the FBI?
Well, it became clear at that point that the degree and the extent to which General Paxton appeared to be using the office to benefit a single private individual, to target and harass law enforcement, rose to a level that, just based on our good faith belief, criminal activity had occurred. And under no circumstances did Brandon Kamek have any authority, either under a contract that was unsigned or a contract that was signed, or by some deputation by Travis County District Attorney's Office to serve as a special prosecutor for the Office of the Attorney General. So he was representing himself in a capacity that did not exist, and doing so for the benefit of a single individual.
Under those circumstances, did you feel that the Attorney General had any authority to appoint a, quote, special prosecutor?
No, sir.
Objection, Mr. President.
Did,
The objection is relevance. I don't believe that there is any contention on the part of the House Board of Managers that General Paxton appointed a special prosecutor. That is not the allegation.
Sustained.
Are you aware as to whether or not Mr. Kamek was going around and serving grand juries subpoenas claiming he was a special prosecutor of the Attorney General's office? Are you aware one way or the other as to whether he was doing that?
Objection, that would call for hearsay.
No, it doesn't call for hearsay. This witness can be cross-examined about what the basis of his knowledge is, and then he can say whether it's solely hearsay.
Overruled it.
Thank you.
You may answer the question.
Yes, sir. I'm aware.
And in fact, was Brandon Kamek ever hired by the Attorney General's office, by anyone in the Attorney General's office, and designated a special prosecutor?
No, sir.
And in what is your opinion as to whether or not they even had the authority to hire a special prosecutor in this case under the facts that you knew him to be?
Objection, Mr. President. Lack of foundation, speculation, and relevance.
Sustained.
Mr. Vassar, what was your concern if y'all did not go to the law enforcement on September the 30th of 2020?
Well, the concern was that it would only get worse. General Paxton's use of the office would only continue to be more extreme, to benefit Nate Paul, and the potential for us to be labeled as co-conspirators.
How long did you remain with the Attorney General's office after October the 1st, 2020?
I was terminated November 17th, 2020.
And what was the stated reason for terminating you?
For disclosing confidential information outside the agency.
And did they describe to you or give you anything in writing to tell you what confidential information you were supposed to have disclosed?
No, sir.
Did you ask for a meeting to find out what it was?
I asked what it was, and they didn't provide a response.
Who replaced Mr. Mateer as the first assistant after Mr. Mateer resigned?
Brent Webster.
Is he still acting as the first assistant to your knowledge?
Yes.
Did you, without going into other conversations, did you seek to find out what confirmation or what information was being used to terminate you? And did you ever find out what it was?
Yes. I asked Mr. Webster what information I had allegedly disclosed outside the agency, and he didn't give a response.
To this day, do you know what confidential information you were supposed to have revealed?
I have not received a direct answer, but based on the agency's own internal whistleblower report, they've made allegations.
Finally, when you were terminated, how old were your children by then?
6 months to 4 years.
I believe you indicated, but I'm not sure I remember. How long did it take you to find another job?
6 months.
How did you live?
Just on savings that we had saved.
And when you took another job, where is it now?
Yeah, it's for a local nonprofit policy think tank here in Austin.
At the end of the day, in light of all that, and by the way, have you sued? Are you a whistleblower that has sued the Attorney General of the state of Texas?
Yes, sir.
Why did you sue?
Mainly for my family.
What do you mean?
Well, to take care of them financially, but also just to be a good example for them.
And what do you mean about a good example for them?
Just to stand up for the truth.
You read this report that they put out back in 21?
Yes, sir.
You saw what it said about you?
Yes, sir.
You saw what it said about the others?
Yes, sir.
How would you rate the level of accuracy of the report that Mr. Webster says he primarily prepared?
On a scale of 1 to 10, I'd give it a 2.
And was that report been out on the internet to the world at large?
Yes, sir.
All about you and the others being rogue employees?
Yes.
Is this the first time you've ever had an opportunity to tell your side since this all happened?
Yes, sir.
You feel better or worse?
It's not fun.
I'll pass the witness.
We'll break now until 5:25, and members, there are some snacks back in the back for you to get a little energized, and we'll come back for about another 60 to 90 minutes, depending on how it goes.
Okay, that's a lot of interesting testimony we've heard from Ryan Vassar. Just this whole description of how this FBI brief came to be released.
Yeah.
What's your thoughts on that?
More following the narrative that the prosecution has been putting forward about how outside the norm this is. It is unprecedented, very, very strange to release, first of all, law enforcement data, as we've heard and we've talked about before, how that has always been the common practice of the Attorney General to not release current investigation information. But on top of that, this is information that was sealed by a federal judge. And I just, for the public out there, a judge's order is a big deal. A federal judge is the biggest of big deals. These are people that have a lifetime appointment. They're essentially emperors.
Right.
The only person bigger than a federal district judge is the Circuit Court of Appeals that is over them and the U.S. Supreme Court. And so the idea that some attorney general in one of the 50 states could just say, you know what, I don't care about that federal judge's order sealing this information. We're going to release it anyways to the target of the investigation is pretty shocking. It was pretty damning, pretty outside the norm, which again just kind of follows that general theme of how unusual this is.
And I think it illustrates the audacity and arrogance of Ken Paxton, that he was quite willing to push through on this and to push his people to do it.
It's a pretty stunning display of, but again, I think what you see is over and over them showing just systematically how they went outside the norms of the office.
And how direct Paxton was involved. This isn't so-and-so told me that so-and-so said. This was Ken Paxton said, find another way.
Right.
This was Ken Paxton saying, I don't care what that is, I want you to do it this way.
I want this to happen, you find a way to make it happen.
Right.
To his staff.
Well, and Vassar said, that when the Kamek situation arose, I feel like the Kamek situation is the straw that breaks the camel's back, right? This is the one where they go, okay, first we had the open records thing, we had the foreclosure thing. We might not like it, but we can muddle through. But now we have subpoenas being issued,
Right.
we have banks being served, we have requests subpoenas for emails and phone records of law enforcement officers and magistrates and that kind of thing. So now we're in different territory.
And it brings up their own personal liability.
Right.
When it all breaks open.
We heard there, close to the end, how he talked about I didn't want to be a co-conspirator.
Well, he said the concern was that it would only get worse, and for us to be labeled co-conspirators.
And that's a big deal, especially if you're talking about something where the federal government is possibly prosecuting you.
Right.
If the feds decide that you have committed a crime, the number one charge that you see in federal prosecutions is conspiracy.
Yeah.
And that is how those indictments get so big and so nasty. And so, that was a very legitimate fear, especially considering that, a federal prosecutor could very easily allege that by releasing, information that had been sealed, that they had run afoul, and that if you were involved in that, then you ran afoul.
And I don't mean to minimize at all their concern for the public good. I think they are all very sincere about that. But I think self-preservation was kicking in too at this point.
Well, I also think that
there's some definite truth to that.
Yeah. I also think that there was, this was a continuation of a pattern, right? At first it's, that's strange, but they didn't have enough information. All the pieces hadn't kind of come together. But then after the foreclosure, there's this, there's that, they're adding on top of each other, then this happens. So it's a continuation of a pattern. They're starting to fit the pieces together, and then this one is so audacious, arguably violating a federal order, sealing records, giving away information from from the FBI. Again, we talked about it at the last break. The Attorney General is the top cop. He is the chief law enforcement officer in the state. And generally speaking, more than generally, every single time I can think of, law enforcement sides with law enforcement because they're all on the same team.
Exactly.
They're all prosecuting crime,
they're all
investigating
supposed to
crime.
be on the same team.
And so for them to, so we heard Ryan Vassar talk about how we reached out to the FBI as per usual, and then it gets released without the FBI even having a say. Again, that very, very strange.
Very strange. And I can understand the alarm that must have run through this group of people as the word spread about what was happening.
Well, yeah, because again, you have Kamek going out, and they haven't played the audio yet, and I don't know. I'm assuming they will, but when Kamek goes out to deliver the subpoenas, at least in one case, to one of the banks, he has the attorney representing Nate Paul with him.
Yes. Again, the audacity is breathtaking.
I cannot emphasize enough how rare that is.
This is
not rare.
It's
unheard of.
Yeah,
it just doesn't
that's
happen.
far more than rare.
I mean, when I listened to that audio when they released all those documents a couple weeks ago, my mouth dropped.
Yeah.
I mean, first of all, I was going. I'm not clear on who recorded this. Was it Kamek that recorded it? Was it the bank guy? I think it was probably Kamek because there's more than one of them. There's like a couple of audio recordings where they're going to deliver subpoenas, and I'm just,
which makes it even more astonishing that he would record that happening.
Yeah.
That Kamek would report.
Yeah,
doesn't that seem even more astonishing?
I can tell you, I've never had a detective give me a call and say, "Hey, you represent so and so. Why don't you come down to the crime scene and we'll let you be involved?" Defendant's attorney. It's really shocking. On top of that, there's so much to unpack here. The more I think about it, it came out as a fairly dry presentation, and I think the defense did a good job. And we can talk about this more. The defense did a good job of interrupting the flow. The defense attorney was very successful with his objections, and I think he had Rusty Hardin stumbling a little. But there was more to unpack there. The fact that, generally speaking, it's very common to put an independent outside counsel.
Right.
That happens all the time. It's a huge office. There's all sorts of issues. Sometimes there's specialized issues, and they don't have that many lawyers. So yeah, that's fine. But when it comes to a criminal investigation, they're not they never have the jurisdiction to prosecute in that instance. And the fact that, so he drafts the contract the way they always draft the contract, and yet again, this is going to be the theme for the prosecution. Again, Ken Paxton says, no, not in this instance. When it's benefiting my buddy, that's going to be the theme. I want you to go outside the norm and do something completely unprecedented, and give him wide-ranging authority. All of that put together, it really is shocking.
And you're right. The theme is for my buddy.
Right.
We're going to do this way, this really unusual, anomalous way to benefit my buddy.
And we haven't heard it yet, but of course, the affair and the mistress and the fact that she works for my buddy.
Well, we heard some of that from Mateer yesterday morning, which was, this whole description of how, the nexus is
it puts it all together. Because,
does.
Right now, if you're just hearing this out of context, if you haven't been following this, it's easy to say, I don't understand why he would do all this for this guy. There has to be a rational explanation. But then once you find out that there is a very rational explanation, it's just not okay. Right. The rational explanation is that he's doing this so that, because you're giving me the keys to my mistress's apartment or whatever. That's pretty incredible.
Right. Because they're going to ask me about this. They got me in the 6 o'clock, so I'm curious. What are the biggest surprises to you guys today?
Well, I don't know why this surprises me, but I do think the scale of the audacity and the arrogance is astonishing. The sheer scale of it, the unprecedented nature of it, and the whole defense that the AG, of course he can do this.
Right.
He's the Attorney General. No.
That doesn't mean you can do anything. Yeah, I agree. I hate to not offer an additional surprise, but I completely agree. It shouldn't be surprising because before Dan Patrick issued the gag order, I can't remember, I think it was Rusty Hardin, said when all the facts are out, it's going to be shocking how audacious. I forget his exact words, but he told us that the scale of the audacity, the scale of how irregular was going to be really shocking. All the facts weren't out. Wait till you hear. Well, we're hearing. I have followed this. I was aware of the basic allegations. I've read the articles of impeachment. Right. More than your average person. When Rusty Hardin said that, I thought, oh, okay, get your popcorn ready. This is going to be interesting. Even knowing all that coming in today, that it still has surprised me how irregular all of this is.
It is the systematic use. That's what the testimony has shown. Mm-hmm. Right. The systematic use of this office to further the interests of one man,
one person.
That's right.
Nate Paul.
That's right.
And over and over, the office, Paxton asking his people to do things that go outside the norm.
Exactly.
With the open records situation, the foreclosure situation, the MIDI Foundation, just over and over, and then you have this thing with Kamek, and this hiring and then going out and doing subpoenas. Just all this stuff is just wild.
I would love. I'm sure my clients would love to be able to have an attorney general to do this on their behalf, to investigate the investigators, to give them access to sealed documents. My clients would love it. I would have to tell them, that's not going to happen because, you're not
I think that
Ken Paxton's buddy.
Even John Grisham could not write a novel when
stranger than fiction.
The publisher would go,
no, this can't happen.
No, this can't happen. Well, go try again.
And again, you can't say enough that Ken Paxton, until he was suspended, was the state's top law officer, and the AG's office is the law firm for the state of Texas.
Right.
That's right.
That's really important when you put this all in context.
Yeah.
This systematic stuff. And these guys, all of these guys, these are true believers. Mm-hmm. These are and every one of them, and he didn't say which nonprofit he went to work for, but it wouldn't shock me if it's something along the lines of what Mateer
it is.
He didn't
and
go join
Bangert
the
are doing.
ACLU
No,
or something like that. He went to
Right.
join some kind of Federalist Society, super conservative. I don't know either, but it would shock me if it was anything
And
but.
when you think that this is the law firm for the state of Texas, and we're doing all this for this one Texan, and then you factor in that there were 75 times when this office declined to represent state officers, state agencies, universities,
Right.
declined to represent them.
Right.
The very
And
people that
they are
supposed
charged
to. Right.
with, and
Yeah.
those entities and individuals had to go out and use taxpayer money to hire other attorneys to do the work this office should be doing.
Right.
That's
I mean,
the-
it makes
yeah.
it even worse.
That really is a good reminder, because I've seen some of the comments saying, this really isn't against the taxpayer. That's a great example. The idea that the Attorney General's office is there to represent state actors, state universities, state agencies, and when they don't, because they're very busy carrying the water of some private citizen
Right.
who's buddies with their boss, that is a direct impact to the taxpayer. That is a direct affront to the taxpayer.
I just want to note for the people that are watching on YouTube right now, this is not from today.
Yeah.
Ken Paxton is not in
Has
the
not
Senate
been there
chambers.
at
Yeah,
all
This
today.
is video. This would have been video from Tuesday. 'Cause
Morning,
the only
yeah.
right Tuesday morning, because Ken Paxton has not been in the
They've
Senate
not required him to
chambers.
be.
He's not required to be.
Right.
And so he has not been there.
There's been a lot of discussion of that. So let me kind of address that. This is not a standard criminal trial. This is a political trial. An impeachment is a quasi-criminal, but it's essentially a political trial. In a criminal trial, the defendant has to be there. There are rules that require that. This is a very different place. No criminal trial gives the jury the right to vote on the rules of the trial and to change the rules in the middle of the trial. These are crazy things. This is the way
vote
this
on all
works.
the motions.
Right. The jury doesn't
Right.
vote on the motions. It really is strange. It's a upside down world. But in this world, he's not required to be there, and so they're making a strategic decision. I'm sure his lawyers, I would be concerned about the same thing, are concerned about, or would be concerned about, he's going to be watched every second, judged every second, every facial expression he makes is going to be judged, and it's just easier not to have him there. On the other hand, there certainly is oh boy, why isn't he there? What's he doing?
Well, and my
it plays both
understanding is
ways.
he's already been doing fundraising on this. That this trial is persecuting him.
Right. I wouldn't, I hadn't heard that, but that doesn't sound at all surprising.
No,
Given
and he
the
well
political
actually,
nature of
Bud
this.
when Bud Kennedy was here yesterday, he showed us the email that went out. And I think that's why the prosecution has taken pains to walk each of these witnesses through to say, okay, tell us your conservative bona fides. Where'd
Right.
you go to law
Right.
school? Where'd you grow up? Who do you work for now? And that kind of thing. And so they've really made sure they're walking folks through to show these are not your rhinos. This
Right.
is not
This
the
is not-
ACLU
right,
type.
not some
This is-
hippie.
this
is
is not a hippy
some
dippy lawyer. This is
malcontent bad employee
No.
who gets
No,
kicked
these
out
are
of everywhere he goes.
true
Yeah.
believers. Yeah.
They believed in the mission,
Evangelical
and-
Christians. They believed in the mission of Ken Paxton's Attorney General's office. They wanted to serve those goals and that vision, and this is how it ended up.
And I think they would say that besides Nate Paul, they still do believe in that mission.
Yes.
Oh yeah.
Absolutely.
Which is
I think
why
so.
I want to return to that. Is I'm sure what they're
Right.
saying is
Yeah.
I want to return to when we did that.
Yeah, right. Which is why Vassar, Bangert, acknowledged that they had taken some cases to the AG's office. That was the thing that
Yes.
Oso didn't
I still
follow
believe
up
in
on.
the system, basically.
Right. Yes.
Is what he could have said
I believe
in response.
in what Ken Paxton, says he stands for over here.
When it
I'm just
doesn't
not for this.
involve Nate Paul,
Right.
Like, I have faith in the system as long as Nate Paul's not involved, is essentially the response. For a second, I just, again, being the lawyer, kind of law nerd out here for a second, I do think the defense has done a much better job in this kind of middle to second half of the afternoon affecting the pace. This lawyer that's going now has been a lot more effective than Mr. Oso. I think. Obviously very different styles. He's a lot more understated, but his objections have been very effective. I'm sure the commenters on YouTube have noticed that, their rate of getting their objections sustained has skyrocketed.
Right.
He's being very effective. And, frankly, and I don't blame him for this, I think he's taking advantage of the fact that Dan Patrick is not a judge. He's layering his objections.
Very effectively.
He's layering his objections. He's saying, this is relevance and hearsay and outside the scope and this and that, and basically making it such that Dan Patrick, I'm guessing, is thinking, well, it's got to be one of those, So he's getting those sustained. A couple of times, just on a pure legal basis, I sat here and listened and thought, those are nonsense objections. I know the rules of evidence, none of those apply, but Dan Patrick is giving him that because, one, he's not rolling his eyes and acting like Oso was.
He's being very
respectful. Yep.
Right.
He's got a good courtroom demeanor, and then he's very meticulous, and he's not getting scolded like a bad child for talking over and all that. And he has effectively turned the tables on Rusty Hardin to some degree, because a couple of times Rusty Hardin talked over him, and then he started getting scolded.
Right.
And we talked earlier about Rusty Hardin kind of giving a master class. Well, here's what a seasoned lawyer can do. Rusty Hardin is not impervious. He can't, he can be bested. And I think for a short period of time that this lawyer has done a really good job.
Yeah, I'm not clear on who that lawyer is.
I keep calling him this lawyer because I don't know his name.
He's been identified. I went through and looked to see. I can't find who he is.
Well, I give him kudos. One defense lawyer to another. I think he's doing a very good job.
Of breaking up the flow.
And look, breaking up the flow, I seen comments on YouTube, and you folks are just like just like jurors. Now, obviously not these jurors because you're not state senators, but I mean, that's the idea. If you can break up the flow and make it boring and make it monotonous, make it dry, then the effectiveness of that evidence goes way, way down. And
this was the flow of the narrative.
Right, and this was very powerful evidence, but I don't think it landed as well as it could because the flow got affected. And a few times, I feel like Rusty Hardin could have easily pivoted and got his point, but the objection threw him off. And then he kind of like we talked about earlier, why did Oso turn away right before he made his point? Rusty did it a few times.
Right.
Where it would have been easy just to reframe your question and get it in. The witness has already heard what you want him to say,
Right.
And so just ask it another way, and the witness is going to give you exactly what you said. But then Rusty kind of got flustered and moved away. So I think the defense is doing a really good job there.
But I still think overall he's gotten some decent stuff out of Vassar.
No, yeah.
Oh, yeah.
It's not been a bad witness. Vassar, I still think, has been a very. Bangert was fantastic, and other than that one little he wouldn't say yes stretch, I think he never got flustered. He never got upset. He did a very good job. This witness, although he never got upset and he's been very calm, he wasn't as interesting. And even though the facts of what he was laying out were very powerful, the presentation wasn't nearly as powerful.
What do you think about the whole contract thing and who signed it and that kind of thing?
The details that are kind of you get mired in.
Right.
I don't think any of that is really all that important, but it's a great job by the defense to throw that up and let you get caught in it.
The fact that the end of it was that Ken Paxton himself signed.
Right.
Even that it didn't go through the procedures.
And he had, and he did have the authority to do that.
Right.
Yes, that's true.
And I think we have to.
Yeah.
He had the authority to do that.
But it wasn't the norm.
It was not the norm.
Yep.
And the issue is.
He bucked his entire staff.
Right, he bucked his entire staff, and then then you get into the questions, and that's where they feel like the staff felt like, which is what led them to go to the FBI, was they felt like the reason he did that had an illegal,
right,
or the abuse of office kind of thing.
Right. Right. Yeah, because, I mean, some of the commenters have pointed out, and it's a fair thing, the boss has a certain amount of leeway. He's the boss, right? And he can say, underlings, you're underlings, and I don't care what you say. Sure, I run my office. I'm the boss. But a whistleblower has every right to call law enforcement if the boss is essentially violating the law.
And in this case, attorneys have a responsibility.
That's right.
To do that.
Especially the top law enforcement officer in the state who represents the state. He has the highest of kind of duties to us as citizens. And yeah.
A lot was made of the fact that they went to the FBI without telling Ken Paxton.
I think that is a great red herring argument to throw out. But if you just sit and think about it, if you have been objecting to how weird this is for months and months, begging your boss, why are we doing this? This is unusual. This is crazy. And then you finally feel like the straw that broke the camel's back has finally broken the camel's back. Why, if you have to go to the extraordinary step of going to law enforcement because you're afraid you're about to be made a co-conspirator in, possible criminal activity, why would you tell him I'm about to go report you to FBI? It's crazy.
Right,
but
exactly.
It sounds good. It does. It sounds good.
Well, if you're building a narrative of traitors and
that they're
coup and
plotters,
plotters,
kind of a mutiny on the bounty situation
right.
going down here.
If that's the story you're trying to sell, that is a good piece to bring in.
Looks like we're maybe about to get started. Yeah, he's at the podium.
Okay, let's take a listen.
I'm going to try to pick up a few crumbs here.
Your witness.
Thank you, Mr. President. Mr. Vassar, my name is Mitch Little. I'm with the law firm of Sheaf and Stone, and I represent the elected Attorney General of Texas. We've much to discuss. I'm going to try to pick up a few crumbs here. The word that I heard at the end of your testimony was co-conspirators. Do you remember that word coming out of your mouth?
Yes, sir.
One of your concerns on September 30th was that if you didn't go to the FBI immediately, someone would think you were co-conspirators with the elected Attorney General in this state, right?
That was one of the concerns, yes, sir.
And your attorney that you hired before you went to the FBI is a man named Johnny Sutton, correct?
That's right.
And he's here today, correct?
He is.
And he's sitting in this courtroom, yes?
Yes, sir.
Would you indicate him for us?
It's right there.
Yes. And he represented a number of you employees at the Attorney General's office, correct?
Yes, sir.
And by the time that you went to the FBI, Mr. Vassar, just tell these senators, did you know who performed the home repairs and renovations at the Paxton's home?
No, I had no direct knowledge.
You didn't have any indirect knowledge, did you?
It was discussed when all of the events came together and we met as deputies on September 29th. That was mentioned as one of the potential concerns of bribery of the Attorney General.
Who mentioned it?
Based on my recollection, it may have been Mr. Brinkman.
And Mr. Brinkman heard it where?
I'm not sure.
He heard it from someone else, correct?
I'm not sure.
You don't know?
I don't know where he heard it.
But one of the criminal complaints that you and your group of people who went to the FBI alleged was that the Paxton's home was being renovated at the cost of someone who was under federal investigation, correct?
You said one of the criminal complaints. I'm not, we did a verbal complaint.
Yes.
At the office, but I'm not sure.
Let me be clearer. One of the things that you told the FBI in your meeting with them was that you were concerned that someone else was paying for the home renovations to the Paxton's home, correct?
Me individually, I had no knowledge, but yes, in the meeting with the FBI, with all of us present, there was a roundtable discussion about some individual's good faith belief that the Attorney General was involved in bribery.
A good faith belief based on what?
I'm not sure. It wasn't my direct knowledge.
You were in the meeting.
Yes, I was in the meeting with the FBI. But
what was the basis?
I'm not sure. I think it was redoing the kitchen countertops.
Redoing the kitchen countertops? Is that what you heard?
I've just given you the context of what I recall.
Did you see any documents exchanged with the FBI in this meeting?
No, sir.
Not one.
No, we did not provide any documents to the FBI.
And let me be clear, because I think your testimony was a little bit confusing, at least to me. It may have been to the senators as well. But you learned about Brandon Kamak's signed contract with the Attorney General after you reported the Attorney General to the FBI, correct?
I think that's correct, yes.
So when you went to the FBI and you told presumably some FBI agents that Brandon Kamak was out serving grand jury subpoenas without authority, you did not know that that man had a signed contract with the Attorney General of this state's signature affixed to it, correct?
That's my recollection.
Well, surely when you found out, you went straight back to the FBI and told them, right?
No. I mean, at the time, we were represented by Mr. Sutton.
Surely at that time, Mr. Sutton asked you to go back to the FBI and correct that misinformation, correct?
What information, what misinformation? That Mr. Kamak had a contract?
Yes, he had a signed contract affixed with the signature of the elected Attorney General of this state, correct?
Yes, based on what he had provided to us was a signed contract, and General Paxton had confirmed to us that he had signed a contract.
And you had it in hand, correct?
Yes.
And surely your lawyer said, guys, we need to go back to the FBI and tell them that there's a signed contract with the affixed signature of the elected Attorney General of this state, right?
There wouldn't have been any reason to provide them with a signed contract because that wasn't part of the complaint that we had filed with the FBI.
Part of the complaint, let's be clear about the complaint, okay? Part of the complaint to the FBI was that Brandon Kamak was out serving grand jury subpoenas to support someone else's agenda besides the people of the state of Texas. True?
Yes.
And at some point after your meeting with the FBI, you discovered from Brandon Kamak that he had a signed contract with the elected Attorney General, correct?
That's absolutely true, for nothing that he was doing.
And I'll object to the non-responsive portion of the question or answer and move to strike, Your Honor.
Strike the last comment.
Now, let's be clear about something else. After this contract that was signed by the Attorney General of the state of Texas, Ken Paxton, he had the authority to enter into it, correct?
Yes, I believe he did.
And that's because over 4 million voters in this state gave him that authority, correct?
Yes.
And that authority exists to bind this state. And if the voters don't like it, they can vote in someone else, correct?
That's, yes, how the political system works.
That's my understanding as well. At what point in time did you come back to the FBI and say, well, maybe there was some authority for Brandon Kamak to do what he was doing? Did you ever do that?
No, sir. And just because
Object non-responsive to anything after no, sir, Mr. President.
Please keep your answers to the questions.
In your meeting with the FBI, did you tell the FBI that Ken Paxton had illegally disclosed some confidential material to someone?
We filed a complaint based on activity that we had formed a reasonable belief that...
Mr. President, I will object at this time as non-responsive.
Sting.
Madam Court Reporter, would you mind reading my question back? I should have I'm sorry, I don't have one. Yes or no?
I disagree with the phrasing of the question.
It's a very simple question. Did you tell the FBI in this meeting, did someone in this meeting tell the FBI that Ken Paxton had illegally disclosed some confidential information to someone? Yes or no?
In the meeting, we alleged based on a reasonable belief that that activity could have occurred. But we were not investigators. That was what law enforcement was for.
That's right. And Mr. Vassar, I want to see us on this point. You're a lawyer and you're doing some, I mean, you have very good command of the language. You had a good faith belief in certain information, but you didn't know that Ken Paxton had disclosed anything to anyone when you made this report to the FBI, did you?
No.
You were hoping the FBI would sort it out for you and not think that you were co-conspirators with him, correct?
No. The purpose of the complaint to the FBI was because we had formed a belief in good faith that the Attorney General was involved in criminal activity.
This is something that I keep hearing over and over again. Formed a good faith belief that the Attorney General of this state was engaged in illegal activity. Did I say that right?
That's accurate.
But you didn't know, right?
Well,
you didn't know, right?
That's the point of the good faith belief, is we had no evidence that we could point to, but we had reasonable conclusions that we could draw.
You went to the FBI and reported the Attorney General of this state with no evidence. Do I have that correct?
We reported the facts to the FBI.
That's not my question. You had no evidence that Ken Paxton had done anything illegal. Did you?
Your Honor, it's not necessary to yell at this witness. I suggest it's disrespectful, and I request he quit doing it.
I apologize. Let me do this again at a lower volume. Madam Court Reporter, would you read my question back for me, please, at an appropriate volume? Yes?
Repeat that, because they could not hear her on the microphone.
Yes, Mr. President, I will. Watching the live stream over there? Hold on. Let me ask this question again. Let me get this straight. You went to the FBI and reported him for potential crimes without any evidence. Do I have that correct?
We went to the FBI and reported.
Please answer my question, yes or no.
Our belief that criminal activity had occurred.
That was not my question.
Witness needs to answer the question, yes or no.
Did I ask it again, Mr. Vassar?
Please.
I want to get this straight. You went to the FBI on September 30th with your compatriots and reported the elected Attorney General of this state for a crime without any evidence. Yes?
That's right. We took no evidence.
Did you gain any after that? Did you gain any after that?
Well, we weren't collecting evidence.
Did you gain any after that?
Evidence of what, sir? Of
evidence of a crime committed by the elected Attorney General in this state, elected by over 4 million voters. That guy.
I don't recall if we had collected any evidence.
Don't you think that's something that you should be able to recall, sir?
Well, when we presented ourselves to the FBI, we did so as witnesses, not as investigators to collect evidence.
Did so as complainants, hoping that you would not be named as co-conspirators, true? You made a complaint, yes?
Yes, it was.
Without any evidence, yes?
No.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me, these sidebar testifying comments are an inappropriate form of cross. If you just asked a question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar, we've got a lot of people whose time is invested in this impeachment proceeding. Did you gain any evidence after you went to the FBI?
I'm not sure what evidence that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled. He was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes, sir.
Be kind?
Yes, sir.
Ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
Well, that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
But would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly with General Paxton. I was not part of those conversations. So any concerns that they had raised with him would have been in their conversations. I had no reason to call him directly.
Object non-responsive.
Sustained.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time, so...
Object non-responsive.
Sustained.
I object to the contingent interruption of the answer. If he doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Thank you. Can we go
That
back to my
objection's
question?
overruled.
Thank you. May I go back to my question, Mr. Vassar? My question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't? Yes, I do.
Well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
You don't? You worked for him for 5 years.
That's right, and I believed in him.
He gave you a job, correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Like I said.
Do you wish you could go back and call them?
I'm sorry,
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay. You don't know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
You didn't work on the MIDI Foundation case, did you?
No, sir.
When you went to the FBI, did you have Ken Paxton's phone number, at least? Could you call him on his cell phone? Did you have the number?
I believe I had his phone number in my phone. Yes, sir.
How'd you get it?
I think he gave it to me.
Why?
Just based on working with him and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss struck you? What was going on?
September 29th, I was in a meeting, just a division meeting with Lacey Mays, and she received a text message on her phone from an individual that I did not recognize, and the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes, and the rest of that thought is, if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamek's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible, but he was out of the state at that time. So I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to
the object is non-responsive to the remainder of this answer.
Sustained.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that any time the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
Only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the attorney general, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the attorney general while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting attorney general, again, that would depend on the statute. The statute provides if the attorney general is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
out of the state?
It would mean the ordinary meaning of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court. So I could not be able to say.
But in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time?
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it. So, letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the MIDI Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I gotta ask you something that's just been really bothering me, and I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the MIDI case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
Okay. Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Benkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, well, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth, so help you God, true?
That's right.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys, and that was it.
Did anyone give you a copy of it?
A copy of my statement?
Your statement, yes.
No, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as the gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
We can take it as being true, yes?
Yes, sir.
Okay. Have you ever, before today, have you ever in your life been asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee hearings, but I don't recall if there is an oath administered to a resource witness. So I apologize.
Have you ever given sworn testimony anywhere before today?
No, I don't think so.
It's a tough first outing, isn't it? Mr. Arroyo, if you would, Article 1 of impeachment, please. Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the MIDI Foundation matter.
And just to be clear, have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in the state?
No, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo, Article 2, if you would. Now, Mr. Vassar, you've given some testimony about what we'll call the foreclosure opinion, right? It was issued August 1?
Yes, sir.
Issued August 1 of 2020? Yes?
Yes, I believe that's right. It was a Sunday.
That opinion was not a legal opinion under Subchapter C, Chapter 402 of the Government Code, was it?
Yes, it was a legal opinion under Subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's not what I said, and my testimony today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was hoping that we would be able to have a chance to discuss this. Mr. Arroyo, please bring up Section 402.042 of the Texas Government Code. No, we're looking for 042. That's .212. We'll get to that later. Thank you. While Mr. Arroyo is bringing this up, I've got a couple questions for you about that. In order for the foreclosure opinion to have been authorized under Chapter 402 of the Government Code, Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman and chair people of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up. There you go. If you could just highlight the text at the top, that big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer. We can read this together, right? Right?
Yes, sir.
It says a request for an opinion must be in writing and sent by certified or registered mail with return receipt requested, addressed to the office of the Attorney General in Austin, or electronically to an email address designated by the Attorney General for the purpose of receiving requests for opinions under this section. Did I read that correctly?
Yes, sir.
That didn't happen with the foreclosure opinion, did it?
I'm not advised if it did.
You were in charge of the section. Is there anybody who has more knowledge about this than you, perhaps?
I don't have access to the email box that it would have been received at. So I'm not aware of how it was delivered, if it was delivered by electronic mail.
Can you tell the senators whether the criteria of section 402.042C were satisfied? Yes or no?
I'm not sure. I don't recall.
And that you were in charge, right?
Yes, sir. Subsection D allows...
Seems kind of, I'm not talking about subsection D. We're not there yet. Seems kind of important to know whether this satisfies the criteria for the Attorney General to provide formal legal advice. Yes?
Yes, sir.
But you told the House Board of Managers this foreclosure opinion was not formal legal advice, correct?
That's correct. It
was not formal legal advice. It was informal guidance. True?
I believe so.
And during COVID, the Office of the Attorney General was dispensing informal legal advice related to COVID almost every day. Was it not?
It was very frequently. I don't know if it was every day. But
were you writing the opinions?
Some of them, yes.
People who are working for you were writing the opinions as well. Yes?
Yes.
And there were all kinds of COVID opinions coming out almost every day, informal legal guidance from the Office of the Attorney General that did not satisfy the criteria of Chapter 402 of the Government Code. True?
I'm not sure about that. A lot of the things that you're referring to about the daily stuff would have come through Chapter 418, which is the Disaster Council legal function. Those would have come from county mayors or city mayors, county judges, and emergency management directors. Those were coming more frequently than the other ones.
Well, let's build two boxes. In this box, we have Chapter 402, formal legal advice, correct? Okay? So in this box, we place formal legal opinions from the Office of the Attorney General that satisfy the criteria of 402.042. Yes?
Sure.
And it's assigned a KP number, correct?
That's right.
And it's published in the formal opinions section of the office's website, correct?
That's right.
And to be clear, for the ladies and gentlemen of this jury, the foreclosure opinion did not satisfy anything in that box, correct?
No, that's why it was flagged as not a formal legal opinion.
It's in the 418 box. Because at that point in time, the governor of this state had decided to empower the Attorney General to give the people of Texas guidance more freely about what's going on during COVID, true?
That's not true.
It's not true?
That's correct. It is not true.
How did the Attorney General get the ability to give people informal legal advice under Chapter 418 of the Government Code?
It wasn't from the governor. The legislature enacted a statute that the governor signed, giving the Attorney General the power to advise three categories of people: county judges, city mayors, and emergency management directors.
I apologize for my imprecision. So at this point in time, these people, the legislature, at least in part, had empowered the Attorney General to give informal legal guidance more freely, true?
To select people, yes, that's true.
Yes. How select were they?
It's the three categories of people: county judges, city mayors, and emergency management directors under the Disaster Act.
There were people on the House Board of Managers who were requesting informal legal guidance relative to COVID, weren't there?
But that wouldn't have triggered Chapter 418. The only other express statutory authority for a legal opinion is 402.
But if it doesn't have a KP number and it doesn't satisfy the criteria of 402.042, it's not formal legal advice, correct?
That's correct. It's not a formal piece of advice. It's an informal piece of advice under Chapter 402.
One of the things that had to do with your termination, I believe, is your voluntarily sending secret grand jury subpoenas outside of the Office of the Attorney General to someone who is not authorized to receive them. Do you understand that?
That's never been stated to me, but that's my understanding based on the OAG's whistleblower report.
Well, you don't have to wait for the OAG to tell you that. You know you did it, right?
I only sent copies of records to my private lawyer. I did not send them to any member of the public or disclose them to the public outside of the agency.
Was Johnny Sutton authorized to receive secret grand jury subpoenas from Travis County? Yes or no?
Well, on their face, they weren't valid. Brandon Kamek had no contract. He was not a special prosecutor. He had no authority to request them or to obtain them.
Mark Penley thought they were valid enough to quash and to get a judge to sign an order to quash them, didn't he?
Well, because they were issued.
They were issued. And when they were issued, they were secret, true? True?
I guess unless they were invalidly obtained under false pretenses.
Are you aware of some type of exception that allows you to send secret grand jury subpoenas to your lawyer?
Well, I thought sending it to my lawyer for purposes of legal advice would be permissible. I'm not a...
Did you check and ask Mr. Sutton whether he represented any of the subpoena recipients before you sent them to him?
Yes, in our conversation for him to represent us, we discussed whether he was able to do so.
And after you sent those grand jury subpoenas to your lawyer, copying the rest of the so-called whistleblowers, you deleted that email from your inbox. True?
That's right.
I think you will probably recall at some point in your 5 years of employment at the Office of the Attorney General receiving some type of training in document preservation. Yes?
Yes.
And what types of training did you receive? Please tell the ladies and gentlemen of this jury.
I believe it's an annual information security training. There's annual sexual harassment training. So there's a variety of required annual trainings that employees of the office are required to complete.
In a second, I'm going to ask you, well, let me ask you now. You are not allowed to delete official records of the Attorney General's office. True?
Official records, no. That's right. Unless...
in a second, I'm going to ask you whether you deleted emails from your computer that should have been preserved as official records. Do you want to consult with your criminal attorney first?
No, sir.
Did you delete official email records of the Office of the Attorney General, sir?
I deleted emails to my personal attorney under the agency's own information security policy that's provided to every employee that personal messages of a de minimis nature are allowed on agency devices, provided that those messages are deleted to prevent archival. Because I made a determination that I emailed Johnny Sutton in my personal capacity with copies of records, not records that had to be maintained on an agency device, but copies of records that existed in the office, I deleted the personal message to Johnny Sutton.
It seems, Mr. Vassar, that one of the things you are accusing Ken Paxton of doing is by allowing people outside of the office of the Attorney General to see secret things they should not see. Do I have that correct?
No, sir. Mr. Sutton was my personal lawyer.
No, that wasn't my question. Let me try again. Listen to my question. One of the things that you are accusing Ken Paxton of doing is forwarding secret information of the Office of the Attorney General to people who should not have it. Yes?
That is a suspicion.
You don't even have enough to make an accusation. You suspect that it occurred, right?
Yes, sir.
But that's what you did, isn't it?
No, I forwarded it to my personal lawyer for purposes of legal advice.
And you think that protects you somehow?
Well, if any ordinary person gets a subpoena, I imagine their first call is to their lawyer who reviews the subpoena.
In preparing the foreclosure opinion, Ken Paxton didn't direct you. Ryan Bangert did, yes?
Yes, sir.
And Ken Paxton didn't direct Austin Kinghorn. You did,
That's
correct?
right.
If you would, Mr. Arroyo, please bring up Article 2. This allegation is not true, is it?
Is there a specific part that you'd like me to review? Or
Read it all. Ken Paxton is innocent of this allegation, isn't he?
So the first provision of the second sentence, this is Article 2 of the Articles of Impeachment. Paxton caused employees of his office to prepare an opinion.
Hold on a second. I don't want you to read it out loud.
Okay.
We don't need to waste the jury's time doing that.
Sure.
They can read. Many of them are skilled attorneys themselves. This article is not true, is it?
Well, it is true that he caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure of properties.
But you don't know whether those properties belong to Nate Paul or business entities controlled by Nate Paul, do you? You don't know that.
Nothing other than what's been reported in the media.
You don't know that what's been reported in the media. Have you ever heard the phrase self-licking ice cream cone before?
No, sir.
Let me explain to you what a self-licking ice cream cone is, Mr. Vassar. A self-licking ice cream cone is when a bunch of employees at the Attorney General's office begin to suspect their boss. They read it in the media. They believe what the media says. They report it to the FBI. And then the media reports that you went to the FBI. That's a self-licking ice cream cone. Are you familiar with the expression now?
Based on your description, yes, sir.
You don't know whether this article is true or false, do you?
No, sir, I didn't write this.
Mr. Arroyo, Article 3, if you will. Article 3, thank you. You weren't directed to act in contravention or contrary to the law, were you?
No, sir. General Paxton.
Object non-responsive to anything after no, sir. Mr. President.
Sustained.
Do you think that your decision with regard to any open records request that was made by anyone was improper?
No, sir.
It wasn't, was it?
No. Everything that we did in a way that we could find a way to make it lawful, because we wouldn't have participated otherwise.
You did it by the book, correct?
Yes, sir.
You wouldn't do it any other way, would you?
That's right.
Mr. Arroyo, Article 4, if you will. Can you see Article 4, Mr. Vassar?
Yes, sir.
Ken Paxton didn't improperly access anything in his office that you're aware of, did he?
No, not that I'm aware of.
And if he wanted to ask for a file, he could do that anytime he pleased, couldn't he?
Sure.
Because that's what 4.2 million voters elected him to do. True?
Yes,
To
that's
access whatever file the heck he wants. Yes?
true.
Article 5, please. We know that Ken Paxton's innocent of this article, right? Right?
I'm not even, I don't recall the distinction about an attorney pro tem. I used to know it, but
You don't even know what an attorney pro tem is, do you?
I know there's two categories. One is court appointed and one is recusal based, but I don't recall the nomenclature.
And Brandon Kamak wasn't either one of them, was he?
He said he was on the subpoenas.
Stop there. Brandon Kamak wasn't either one of them, was he?
No, he had no authority.
Wasn't an attorney pro tem, was he?
Honor, he keeps interrupting the witness. He should be entitled to finish his answer.
You're right, Mr. Hardin. I apologize, Mr. President. May I try again?
You may try again.
Mr. Kamak was not an attorney pro tem ever, to your knowledge. True?
Like I said, I don't recall the distinction between the two categories of prosecutors, but he was not hired to be a prosecutor.
He wasn't hired to be any type of prosecutor, true?
Yes, sir.
He was hired as outside counsel because that's how you drafted the contract personally, yes?
Yes, sir.
So when it says Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem, Brandon Kamak wasn't a prosecuting attorney pro tem, was he?
Not based on my understanding of what that...
I didn't think so either. Article 6, if you would, Mr. Arroyo. You're familiar with this allegation dealing with whistleblowing, correct?
Yes, sir.
Don't you kind of think Ken Paxton had a right to be upset with you reporting him to the FBI without any evidence?
I suppose he's entitled to whatever feelings he may have felt at the time.
Article 10, if you would, Mr. Arroyo. This says the Paxtons, and it says Ken Paxton, but you understand he's married to Angela Paxton, right?
Yes, sir.
So when somebody's spouse gets accused of bribery and the form of the bribery is improvements to a home that are owned by both of them, really you're accusing both of them of being corrupt, right?
I don't know.
Don't you think?
I don't know the elements of bribery. I'm not a criminal lawyer, so I'm not sure what the implication could be.
As you sit here today, you know darn well that the Paxtons paid for the renovations and repairs to their home, don't you?
No, I don't know that, actually.
You don't know who paid for them?
No.
Maybe it'll come out in this trial. Mr. Vassar, would you expect to be placed on investigative leave for sending a set of secret grand jury subpoenas to your outside counsel and then deleting that email?
No, sir. I mean,
You wouldn't expect anybody to investigate that?
for sending an email to my personal lawyer relating to my report to law enforcement
Yeah.
and to be retaliated against by being placed on investigative leave. Is that?
No, my question was a little bit different, so let me be clear about what the question is. Wouldn't you expect the Office of the Attorney General to investigate your use of your office email to send secret grand jury subpoenas to that man, Johnny Sutton, and then delete the email? Wouldn't you expect to be investigated for that? Yes or no?
No, not necessarily.
Okay. Wouldn't you expect to be fired for that?
No.
Wouldn't you expect to be fired for reporting your boss to the FBI without any evidence?
No, I would expect an opportunity to answer questions based on answers that I was provided when I asked, what documents are you alleging that I disclosed? And when no response was given, I couldn't give any further information about who the messages may have gone to or for what purpose.
Mr. President, I'm conscious of the indulgence of the hour, and I want to make sure that I'm not running up against any type of deadline or keeping.
We were prepared to go to 7 if needed.
Would you like me to continue?
You may continue.
I will be happy to. You are the chief of the General Counsel Division at the Office of the Attorney General, correct?
At one point, yes, sir.
Yeah, so for the ladies and gentlemen of the jury who are here and may not be lawyers, and for the people of Texas who may be watching, you were really a lawyer to lawyers, correct?
That you could describe it like that. Yes,
That's
sir.
how I would describe it. General counsel is really a lawyer's lawyer, yes?
Yes, sir.
And so what happens in the Office of the Attorney General when you are in the General Counsel's office, actual lawyers come to you and ask you for legal advice, yes?
Yes, sir.
And that happened regularly, true?
Yes.
You were first chief of the General Counsel Division, and then you were Deputy Attorney General for legal counsel, true?
That's right.
And your first involvement with anything related to this impeachment was being approached in the fall of 2019 with a question about an open records request made to the Texas State Securities Board, true?
That's true.
And Ryan Bangert approached you with a question. Remember, you're the lawyer's lawyer. He approached you with a question about whether the State Securities Board's involvement in a joint task force could harm the law enforcement or investigative privilege, true?
That's my recollection, yes, sir.
And you answered his question, yes?
Yes, sir.
And then you were not involved in anything else related to this impeachment matter until March 2020, true?
That's not true. I think it was May of 2020, which was the DPS request.
You're wrong about that, but
Okay.
I just want to make sure I understand what your understanding of the timeline is, okay? So when was the period of time when you believe you first got a request or an open records request related to this impeachment matter?
Well, to back up just a little bit, if I may, I was not promoted to deputy for legal counsel until April 1st of 2020, so I wouldn't have been overseeing the open records division until after April. So I don't know when the DPS request was submitted to our office. That could have been the date that we received it in March, but I wouldn't have been tasked with anything related to it until after I was promoted on April 1st, and then the conversations that I had in May of 2020.
Tell the ladies and gentlemen of the jury who Joe Larson is.
I believe he's an attorney representing Nate Paul.
And what type of work does he do, to the best of your understanding?
I'm not sure. He was a requester in 2 of the open records requests.
Yes.
I don't know if that's his practice.
In fact, Joe Larson works at, he's pretty well known in the state of Texas for being a Public Information Act lawyer, yes?
I'm not sure.
Had you ever encountered him before?
No, sir.
Okay. So I'm going to tell you, my understanding is on March 3 of 2020, Joe Larson sent what I call the big request to DPS. Okay, so the one that happened in 2019 was a request for public information was made to the Texas State Securities Board. Yes?
Yes.
Ken Paxton asked you about the law enforcement privilege. You answered his question. Oh, I'm sorry. Ryan Bangert asked you about the law enforcement privilege. You answered his question. And that went away. Poof. Yes?
Yeah, I never heard anything else. Yes, that's right.
Then March 3 of 2020, Joe Larson made a Public Information Act request to DPS, what I call the big request. He's asking for a whole lot of information related to the search warrant execution on Nate Paul. Yes?
Yeah, I don't know about the dates. Again, I don't know when he submitted it to DPS, but yes, if that's how you want to categorize the big request, then yes, that is accurate.
Well, this is probably beneath many of the people on the jury who very well understand this, but for people who are watching at home, when someone makes a Public Information Act request of an agency in the state, the agency comes to the Office of Attorney General for representation, says, help us decide. Yes?
It's not representation, but it's a request for a ruling.
Yeah, they want a ruling.
Right.
And so in this situation, DPS wanted a ruling. Yes?
Correct. If they want to withhold anything under the Public Information Act, they must request a ruling.
But Joe Larson didn't wait for your ruling, did he?
I don't think I follow.
On April 10th of 2020, Joe Larson sent a demand to DPS saying, I asked for this stuff, give it to me now. Are you familiar with that request or demand?
No, sir.
And on April 16th, he filed a lawsuit to get it. Are you aware of that, sir?
I recall the lawsuit.
I'm going to show you what's been marked as Exhibit 5. I maybe light one copy. Your Honor, may I approach the witness? Thank you.
Thanks.
We move for admission of AG Exhibit 5.
Mr. Hardin?
No objection, Your Honor.
Mr.
AG
Arroyo.
Exhibit
Oh, I'm sorry.
0050 should be admitted to evidence.
Thank you, Mr. Arroyo. Exhibit 5, if you would. This is good. What is this, Mr. Vassar?
This appears to be a petition for mandamus filed by Joseph Larson, as a plaintiff against the Department of Public Safety, April 16th of 2020.
Who did he sue?
He sued the department, it appears.
What did he sue to get?
I'm not sure.
Take a moment and look through it. Maybe you can figure it out.
Sure. So according to count 1, Joseph
You don't need to read it out loud.
I'm not.
Okay.
I'm summarizing.
I'm sorry. Go ahead.
He's suing DPS because of his claimed refusal to produce the information that he requested.
Mr. Arroyo, can you find count 1 for the ladies and gentlemen of the jury so that they're not listening to this blind?
Do you want me to continue?
Not quite. There you go. Thank you. Can you just pull up count 1? Mr. Larson is suing DPS based on his big request for all the documents that DPS has related to the Nate Paul search warrant. True?
I don't I don't know. It looks like, yes. Page 1 references the March 4th, 2020 DPS request for all communications. So we could call that one the big one, if that's the big request.
I call it the big request.
Okay.
Okay, so in the big request, Mr. Larson is suing to get all the raid information. Yes?
Yes, I mean...
Probable cause affidavit, yes?
It says all communications in this document, but I would assume it would have said all records.
He wants the full Monty.
Right.
Everything DPS has related to the Nate Paul search warrant, yes?
I'd presume so.
And he's suing to get it, yes?
Yes, it appears so.
And the OAG was aware of this litigation, true?
Yes, we became aware of it. I don't recall when, but...
It would be pretty stupid for Nate Paul to sue to get something that he already had, wouldn't it?
Well, this predated any conversation. This lawsuit could have even predated a request for ruling to our office. So
let me press pause there for a second. To be clear, this big request is the request to which OAG responded and said, we take no position on it. True?
Yes, the big request.
Yeah, the big request. So this thing, by the time OAG even decides anything, Joe Larson's already sued DPS to get it, true?
Correct. If I'm following, so this was filed, it appears to be April 16th. The OAG's non-decision in the big request was June 2nd. So this lawsuit, and I apologize if I'm not following you, but...
You are following.
Okay.
Mr. Vasher, you are following me. What happened is Joe Larson says, I'm not going to wait to see what the OAG decides on this. I'm suing. Right?
Sure. I don't know what he was thinking at the time. But.
And the OAG's no decision on the big request did not lead to the production of any documents to Nate Paul, did it?
Not under the Public Information Act. No, sir.
No. But Joe Larson didn't stop there, did he?
If you're talking about the public information request to the Office of the Attorney General for the FBI brief, then you are correct. He did not stop there.
All right. Let's press pause there. This third request from Joe Larson was for an unredacted copy of the FBI's brief. Let's go back a step. This is very confusing and arcane, so I want to go slowly, all right? When Joe Larson made the original big request of DPS for the search warrant, etc., DPS had to give notice to the FBI, yes?
Yes, sir.
Because they were holding the FBI's own documents, yes?
That's right.
Said, hey, we're holding some stuff that probably by right belongs to you. Do you want to object? And the FBI has a period of time to object, yes?
That's right.
And what the FBI did in response to that was they sent a legal brief, yes?
Yes, sir.
And that legal brief is a bunch of legal arguments from a lawyer at the FBI, yes?
That's right. The brief identifies the content of the information that the agency wants to withhold.
And the brief that the FBI generated and gave to Mr. Larson was almost completely redacted, like something you might get from the CIA, right?
I don't recall exactly, but based on what I recall, it was redacted.
It was just basically a bunch of pieces of paper with big black blocks on them, right?
I don't recall, but it was redacted. I do remember that.
And Joe Larson says, this is no good. He makes a demand for the unredacted FBI brief. He made a third request, so request number 3 under the Public Information Act, for an unredacted version of that brief. And he made it directly to the OAG's office, yes?
Yes, sir.
He didn't make it to DPS. He didn't make it to FBI. He made it to your office, yes?
Yes, sir.
And what happened is the OAG sent notice to the FBI, the same notice DPS had sent earlier, and said, hey, this guy wants a copy of the unredacted brief. You guys need to show up and object if you don't want him to get it. True?
Yes, that would have been the third party notice.
And the FBI blew it, right?
I don't recall. I was not involved in those conversations. I don't recall what happened.
The FBI didn't respond in time. True?
True? I believe that could be true. I don't recall. I'm happy to refresh my recollection if you have.
Joe Larson got the unredacted FBI brief, yes?
Yes, I believe so.
And he got it because your office decided the FBI blew the deadline, yes?
That's functionally correct.
Functional? What do you mean? What does that mean?
Well, after we had advised General Paxton about the issue.
What did you need to advise him about? Paxton, hold on a second. Ken Paxton.
Excuse me. He asked him, what do you mean? He's in the middle of answering, and he cuts him off because he doesn't want the answer. Excuse me.
Slow down.
You're very right. My apologies.
Did you want me to?
Did you need Ken Paxton to tell you that the FBI blew the deadline?
I'm sorry. Did I need Ken Paxton to tell me that the FBI missed the deadline?
Yes.
No, sir. No. I brought it to General Paxton.
Not responsive to everything after no, sir.
Sustained.
So, after the FBI blew the deadline, Joe Larson got the unredacted FBI brief fair and square. Yes? Yes?
I assume so. I did not provide it to him, but I assume a copy was provided in response to the decision to let the brief go out.
Okay. Just make it like, tell the ladies and gentlemen of the jury like you would a 7th grader. Did Joe Larson get the unredacted FBI brief because the FBI blew the deadline?
It was mainly because General Paxton told us to release the FBI brief.
And he told you to do that because the FBI blew the deadline, right?
I don't know if that's why he told us that.
But they did blow the deadline, yes?
I don't recall. I was not involved in contacting them directly. I don't know what any responses we would have received or when.
Sorry. You're in charge of this, yes?
That's right.
And you can't remember, right?
No, I don't. I didn't have direct contact with the FBI about a brief or a notice. Those are all handled by the opinions division.
Are you satisfied in your own mind that the proper notice was provided to the FBI and the deadline was not satisfied?
Based on my knowledge, yes. I didn't see it, but
Nate Paul's lawyer got that fair and square, didn't he?
Maybe under the Public Information Act.
The law, you mean?
Correct. Just under an interpretation of whether sufficient notice was provided or whether a third party submitted briefs that it wanted to submit.
It's just a brief. It's just a bunch of legal arguments, isn't it?
It is.
You told Rusty Hardin when he asked you on direct that this item contained all types of information that would subject law enforcement to potential retaliation, that somebody might come and shoot them at their home or something like that. That's not true.
Well, that's not exactly what I said.
This unredacted FBI brief is just a bunch of legal arguments from some Fed lawyer, isn't it? Isn't it?
The act requires the brief to identify information to which exceptions might apply.
That's all he asked for, right? The brief.
Correct.
So the insinuation that Ken Paxton somehow got the file and sneaky, delivered it to Nate Paul, you don't have any evidence to substantiate any of that, do you?
I have no direct knowledge of what he did with the file when it was in his possession.
You want to make an accusation while you're here on the stand? You want to accuse the elected Attorney General of this state of delivering something to Nate Paul that he shouldn't have? Do you want to do that now?
I don't know what he did.
So when Ken Paxton asked for the file, you gave him the file, right?
Yes, sir.
He had every right to ask for that, yes?
Yes.
If he just felt like looking at it, he could ask for it, yes?
That's right.
And irregardless of his feelings about Nate Paul and whether he was unjustly being railroaded or the feds are mistreating him, he had every right to look at it, didn't he?
Yes, sir.
And you don't know that Ken Paxton did anything illicit with that file, do you?
No, sir, I don't.
You're not here to testify about any of that, are you?
No.
In fact, when Ken Paxton had this meeting with you about the file, he told you that he had spoken to Nate Paul. He didn't hide that, did he?
No, sir.
He told you he would believe that Nate Paul was being railroaded just like he has been, yes?
Yes, sir.
He told you he didn't trust DPS or the feds, didn't he?
Yes, sir.
And he didn't hide that, did he?
Not in that meeting.
Do you, by the way? Do you trust the feds? Trust the FBI?
Yes, I have no reason not to. I trust law enforcement and our peace officers.
You can't think of one reason in the last 3 or 4 years not to trust the FBI?
I'm speaking mainly personally.
Ken Paxton told you he didn't want to use his office to help the feds in any way, didn't he?
Yes, sir.
He didn't hide that from you, did he?
No, sir.
And when you were discussing the ruling, what I'll call the no decision ruling on the big request, you reached an impasse where each side made its case, and he's the boss, right? Yes?
Yes, sir.
And he didn't overwhelm you. He didn't tell you to do anything against your conscience, did he?
No, sir.
He told you to be a lawyer and make a decision, right?
No, sir.
You made a no decision, yeah?
Well, to clarify, it wasn't my decision to make. It was his decision for the ruling to be a non-decision. There was a couple of decisions in there that maybe confused me.
Have you ever seen the probable cause affidavit in connection with Nate Paul's search warrant? Have you seen it personally?
Yes, sir.
Earlier, you said that you delivered a file to, you gave a file to Drew Wicker. And just show the ladies and gentlemen of the jury with your fingers how thick that manila envelope was. Like that?
I'd say less than 1/4 of an inch, just not very thick.
Probable cause search warrant affidavit is 224 pages, isn't it?
I don't know.
You don't know? You said you saw it.
Well, I saw the body of the affidavit. I don't know if there was anything else attached to it. When DPS submitted its request to us, it was a request based on representative samples of information. So we would have received a representative sample of whatever DPS provided. And I don't recall seeing a document of that size.
Counselor, we'll go maybe 10 more minutes. You can stop anywhere you'd like in between.
You're very kind. Thank you. I want to talk about the foreclosure guidance for a few minutes before we retire for the evening. The legal question from Ryan Bangert was, are foreclosure sales gatherings, quote unquote, since the governor and the local county judges and mayors had prevented gatherings of 10 or more people, right?
Yes, that's what I remember his question to be.
That's really the simple legal question. And you, as a lawyer at the OAG's office, you do your research and then you take a position, yes?
That's right.
Okay. And we agree that what you were doing was not a formal attorney general opinion, true?
It was not formal, that's right.
These are what you call informal letters or announcements, yes?
Yes. Informal opinions. I mean...
Let's save us a little bit of time. I have a transcript of what you told the House Board of Managers. And what you told them was this AG foreclosure guidance was an informal letter or announcement, yes? True?
If that's what you're saying.
Is that what you said?
I don't recall. Again, based on my recollection of 402 and 418, those are the only two statutes that give the Office of the Attorney General express statutory authority to issue legal opinions.
And after you and Austin Kinghorn did the research and he explained to you his position on it, you talked to Ryan Bangert, true?
Yes.
And Ryan Bangert called you and said, well, that's not the right answer, true?
We prepared a draft and then provided that to Ryan Bangert. And then, yes, he called me and said that's not the right answer.
And Ryan Bangert told you General Paxton wants to stop these foreclosure sales, right?
Yes, he said we reached the wrong answer.
Yes. And so what you know secondhand is Ken Paxton disagreed with the result that you and Austin came up with, didn't he?
Yes, that's what.
And he has the right to do that, doesn't he?
Yes.
And he was elected to make those decisions, wasn't he?
Yes.
Did Ryan Bangert tell you, you know what, Ryan Vassar? There's two Ryans. I'll sign this so you don't have to ruin your career, Ryan. Did he tell you that?
No, sir. I don't recall.
Did he intimate that?
No.
Did he imply it?
No, it was basically a timing.
What do you mean it was basically a timing? Tell me what you mean.
We prepared the first draft. By the time Ryan had finalized the second draft, it was 11 o'clock at night or midnight, and he was talking with General Paxton, is my understanding. So I had gone to bed and wasn't available to sign it.
Were you happy to sign it?
I would have signed it.
You didn't avoid signing it, right?
No.
You didn't say, Ryan, I don't feel comfortable. Would you sign this instead of me?
No, sir. I didn't say that.
So Ryan Bangert didn't jump on the grenade, so to speak, and say, you know what, this is really dangerous, Ryan Vassar, I'm going to sign it. Did he?
Not that I remember.
Did Ryan Bangert tell you, Ryan, I totally disagree with what we're doing here, but I'm going to do it over my own strenuous objections?
I don't remember him saying that.
You worked on this opinion on Saturday night, right?
It was all day Saturday. Yes, sir.
But that wasn't even the only COVID opinion that went out that day, that Saturday, was it?
I'm not sure. I would have to go back and look.
Well, I'll put it in front of you here in a little bit. You do not have the first clue whether this informal foreclosure guidance stopped a single property foreclosure, do you?
I have no direct knowledge.
And you heard it secondhand from some Austin Business Journal article, right?
That's right.
Did you believe it? Did you believe it?
I had no reason to disbelieve it just based on the timing.
Did you do any research yourself?
No, sir.
Any investigation at all?
No, sir.
Just one problem. It's 100% false. Never happened. It's not true. It's pure fiction. Did you know that?
No, I wouldn't have had any reason to know that.
Your Honor, I believe this is a good time to stop for tomorrow if Your Honor is willing to conclude for the day.
Yes, court will adjourn for the day, 9 a.m. tomorrow morning.
Okay. Katie, Mike, reactions to what we've been hearing?
It's been a very long day. I'd like to start there.
It's a really long day.
And you could see it
On
in the senators and the backgrounds of the shots that they were just, I mean, and I think Dan Patrick saw it too and said, okay, we're done. And I think this attorney did not help himself, although I thought he did a good cross-examination and he achieved what they want to do, which was to set the witness back on his heels and to confuse him. It was the wrong time of day to do it, I think.
It doesn't land the same if they're fresh.
It really doesn't.
So I'll say, first things first, the attorney's name is Mitch Little. I've been saying this attorney for hours now.
Mitch Little.
We finally have
Mitch
a name.
Little, Mitch Little of Frisco, and some of our commenters were on top of that. So I'll say this, look, Mitch Little did a much, much, much better job than the previous defense lawyers of controlling the witness. He kept Vassar on his heels. He kept Vassar to short answers, and he bullied Vassar. And that was effective. You can see how different it is when the witness doesn't feel comfortable and doesn't feel like they can go on at length versus our previous witnesses. However, as a lot of our commenters mentioned, he badgered the witness so many times I lost count. I was pretty shocked Rusty Hardin didn't object more. We talked about this during.
Well, he was asking the guy to say, well, he's not guilty of this article, right? And so I was waiting for Hardin to go, that's the jury's decision.
Right. Well, and especially, what's good for the goose is good for the gander. You guys have made that invades the providence of the jury. That's the ultimate issue.
Over and
objection.
over and over again.
Yeah, 100 times. And now you're doing it? So I was kind of surprised he didn't do that. 3 or 4 times, Hardin would object that he was yelling at the witness. He never used the word badgering, but that's the official terminology we use in trial. But that was his objection. And, 4 times, Mr. Little apologized, agreed, and then went right back to doing it.
Right back.
And I think this is another great example of an experienced judge would have cut that so short that would not have happened.
Well, I mean, Dan Patrick is only a few days into his judgeship.
He's a baby judge.
Well, we have learned some new, sayings. A self-licking ice cream cone will live on in infamy.
Are you saying that
I have
you've
to
never
say,
heard
I've never heard of that.
Well, I've never heard that either.
That was a good one. A bucket of hair is another one. There are no coincidences.
Well, there's no coincidence in Austin.
That's
one
another one I've never heard.
That's the cliche he failed to repeat.
Then this man was elected by 4 million voters. Well, that sounds really good until you look at that. There are 30 million Texans and there are 17.7 million registered voters in Texas, and he was elected by 4 million.
And also that Ken Paxton is a gentle, kind, attentive
that was
man.
the other thing. I have to say, that was a first for me, too, to hear Ken Paxton described as a gentle, kind, attentive to your needs boss.
I'm going to be...
what you expect of the chief law enforcement officer in the state.
That was kind of bizarre.
I'm going to self-edit, but I think...
Oh, come on.
Self-editing is always good.
Don't hold back.
I think the choice of words was pretty creepy. And it wasn't an accident because he clearly, so he was using...
Well, no, because he said it more than once.
Right, he was using a trial technique it's called a trilogy. You want to, if you think you've got a good turn of phrase or a good point, you want to say it 3 times, and then he trilogied, and then I think he doubled his trilogy. So, I mean, he clearly seemed to think that this was a real silver-tongued,
As near as I could tell, it caused bursts of laughter throughout all the viewers everywhere.
I know our commenters. We read through your comments, and you guys definitely seem to enjoy that.
Well, I practically spit water onto my computer screen. So, I mean, it's
some of you guys
who are you talking about?
Almost owed her a new computer.
Yeah. I just think that overall, what we got, from yesterday and today is, this emerging picture of just all the ways that things were done outside the norm.
Yes.
Yeah.
And I think we've also got that the defense doesn't have a lot, but sound and fury, which they referenced themselves on the first day. That is exactly what they're providing, is a lot of sound and fury that signifies nothing. So far.
I have a different take on it as a defense lawyer, but I mean, I know what you mean, and I don't think you're wrong. I think that kind of is the defense in the vast majority of criminal cases. I don't have to prove my client is innocent.
You're right.
Right. All I have to do is poke the tiniest of hole, and there just needs
exactly
to be reasonable doubt.
Because the burden
of proof
rests with the prosecution.
Right.
That's
the prosecution
right. You're
must prove
absolutely
it,
right about
and they
that.
must prove it beyond a reasonable doubt. I love to tell juries, look, you can think he might have done it. You can think he probably did it. You can think you're pretty sure he did it. You can think he did it, but he's not guilty. He's not impeached if you have even the slightest doubt in your mind that is reasonable. And that's, that's the highest burden. And so, I think sometimes we get swept up in, the defense has nothing, they're grasping at straws. The defense, they're doing a good job of sticking with their narrative, and their narrative, some people may think it's ridiculous. Some people think it's, grandstanding, but the people who feel that way are not their intended audience.
That's right.
And I do think this is landing with their intended audience. The ultimate question is how much.
And is it landing with the senators they need it to land?
Well, like this
with?
whole thing about, not the FBI, not trusting the FBI. Somebody asked here something to the effect of, should Rusty Hardin have done a better job prepping Mr. Vassar?
I'll say this: it's impossible to know. I can't imagine Rusty Hardin didn't prep his witness thoroughly. What I can tell you, viewers, is as a lawyer, I'll prep my witness till the cows come home, and they are always going to get on the stand and say something different. It's the moment, it's the stress. Testifying is horrifically scary, and so when they get up there, you just never know how they're going to do. You can't tell them what to say, first of all, but even when you practice and you get used to what they're saying, they're almost invariably going to say something different when they take the stand. I do think Ryan Vassar, much more so than the previous witness, struggled with the cross. Now, of course, he was getting a much more aggressive cross,
right,
and a much more effective cross.
Well, from a more seasoned attorney.
From
clearly.
a more seasoned attorney.
And he did recover a little bit
He
toward
did.
the end of it, where he sort of got his feet back under him.
Yeah, you were saying that off air towards the end, and I totally agree. I think towards the end, he seemed to, maybe he just got used to it. Or maybe he's looking out at the jurors, and maybe he's seeing the faces. This is certainly possible,
Yeah.
and realizing I can stand up for myself. They're not buying this. I mean, I'm not saying that's the case because I can't see all of their faces, but whether he just got used to it, whether he just got his legs under him, he definitely seemed to do better at the end. But yeah.
Well, and we've heard a lot about these whistleblowers over the last 3 years, but it's really the first time we're really hearing from them. And it's one thing to tell your story when you go meet privately with the FBI, and it's another thing to go, privately and, be interviewed and this, that, and the other. But it's a whole nother thing to have, to be testifying in Senate chambers and to have it live streamed
Right.
all
Lights,
across
camera,
the
action.
country. Right?
Yeah.
Well,
it's
and
a whole
think
different ballgame.
It's important to remember that whistleblowers aren't required to bring all the evidence and prove the case.
Right.
They're required to bring enough to cause an FBI to decide to open an investigation to see if what they're blowing the whistle about has any validity.
Yeah.
Their job is not to prove the case.
No. Yeah, Mr. Little kept talking about you had no evidence, you gathered no evidence. Well, that's, I think, the first time Vassar started to get his legs under him a little bit. He still struggled for a while, but he said several times, that's not what we do. We don't gather evidence, and you're absolutely right. I think Little, look, it's a great argument. It sounds good. It's one of those things that if you squint, it looks good, But if you think about it, yeah, I mean, a whistleblower just knows what they know. Hey, look, something smells bad
Right.
here.
They felt like they had smoke. They didn't necessarily have fire.
Right, and so
And
I'm
that's
going to go.
the FBI's job.
Right.
Is
I'm
to
gonna
find out, is there fire there?
I'm going
Or
to go
is
to the
that
fire
just
investigator
incense blowing around?
and have them look. I'm going to go to the professionals who look into this sort of thing. This is over my head. What I
And
know is
when
this.
you think someone is committing crime, you generally don't go to them and say, I'm going to report you because I think you are committing a crime. That's generally not how that works.
But what if that person is kind and gentle and nurturing?
Oh, well, there is that. There is that.
Well, so, Mike, I'm going to ask you this because you are the trial attorney, and Katie and I were just,
the trial attorney.
So, overall, from a trial attorney's perspective, who carries the day? Who wins the day?
I hate to give a lawyerly answer and split hairs.
Of course you're going to.
Of course,
you're
right?
going
Yeah,
to.
you're not going to get me to give you a simple answer. I'm a lawyer. No, I mean, I think, look, I've said this before, both sides achieved their objectives, right? I think from a factual standpoint, Rusty Hardin and his witnesses laid out some pretty damning evidence, some pretty strong evidence. We've been saying it, how outside the norm this stuff was, how it's all tied to one person, and it right now, if you haven't seen all the evidence, as the jury hasn't, you have to be asking yourself, good God, why would they do all these abnormal things? And they're going to find out. There's more evidence coming about, this relationship and the affair and how it relates to Nate Paul. So I think the prosecution has done a really good job there. The defense has scored some points, and that's really all they need. So I think the lawyering all on a whole, Rusty Hardin out-lawyered the defense as a whole. When you look at that last witness, maybe Rusty was, maybe he thought that Mr. Little was making a buffoon of himself, and therefore I'm just going to let it go and not object. Personally, I thought he could have been a little more strenuous with objections. I kind of thought maybe Mitch Little
I really
out-lawyered
thought
him a little bit.
with the articles thing, that's where I would have said, wait a minute, you're asking him to say guilty, not guilty. This.
I mean,
that's
he's
up to
not the
Senate.
juror,
That's
right?
Right. That was where
These are the jurors, not
Well,
this.
I started thinking, because I've seen prosecutors do this, and jurors hate it, and everyone hates it, when they have 100 things to go through, and they're like, all right, I'm going to go through every single one of these one by one. Everyone goes, oh my, especially late in the day. And that's what he started doing. And, I think that's the biggest, besides maybe overblowing, himself. I think Mitch Little, went on a little too long, kept saying he was going to respect these people's time and then didn't. I think that's where he made some mistakes. But all in all, he definitely fixed the errors that I was talking about earlier about not controlling a witness. But
He did do that.
He swung
maybe they were watching
too far. Yeah,
because there was a period of time when Busby was out of the room. Maybe he was watching.
Right.
All right, guys, we're going to wrap this up. Well, I'm going to give Katie the final comments and then I'll wrap it up.
Oh, the final comments.
Well, I got the lawyerly guy.
I got to go.
Okay,
It's your turn.
all right. Well, I think that so far, if you want my take on all this, I think the defense has not done what they need to do, which is to poke enough holes in all of these accusations, because it only is going to take one.
That's right.
And so far, I don't think they've done that. They've come strong after a couple of them, but even there, I don't think they've struck gold yet. I don't think so. And now that's not saying the prosecution couldn't be doing a little stronger in some areas too, but I think the charges are so strong and so shocking that it's going to take a lot to overcome that. And just the sheer audacity and arrogance of it is indeed breathtaking. Even if Ken Paxton is kind and gentle, he's already very audacious and arrogant too.
Well, I'm not going to comment on that. It's been a very interesting 2.5 days, and we will be back. Well, Mike is assuming this goes into week 3. Mike is on tap again. Katie's back tomorrow, and then of course I've got Bud coming back next week. We're going to have a legal guest and a political commentator on every day, because the reality is what we realized very quickly as we started this was we need the differing perspectives that folks who because this is different than the tip. I've done trials before, but I've never done one like this.
This is different. Yeah.
Yeah, part trial, part politics.
It is. It's very, exactly. Anyway, we will be back tomorrow, or I'll be back tomorrow, and Katie will be joining me, and I'll have Ed Loya, who is a former federal prosecutor. He worked in public corruption. He'll be joining us as our legal analyst, and we'll be back tomorrow just before 9 when the Senate gets started. Hope to see you.